Good morning, everyone. We'll be starting shortly. I request all the advocates to be seated in their places. I repeat, I request all the advocates to be seated in their places. We'll be starting shortly, and I also request all the advocates to leave the first three rows for judges and important guests. I repeat, I request all all the advocates to leave the first three rows, first two rows for important chief guests and also for judges. I repeat, I request all the people to leave first two rows vacant for important guests and the judges. The program will be starting shortly. Please have some patience. And also, everyone must be registered. And the people who did not register, we have on-spot registrations and new registrations available. So please go get yourself registered. And the help desk is in the lobby. So please make use of it. Thank you.
campuses in Vijayawada and in Hyderabad, the capital of startup state Telangana. KL University employs higher-order teaching pedagogies, driven by globally renowned faculty. State-of-the-art research department with additional focus on industry-driven skilling have been paramount in attracting 500-plus MNCs to engage with KL, resulting in an impeccable track record of 100% placement.
At KL University, we concentrate on overall development of the student. Along with the academics, we give equal importance for all-round development of the student.
The faculty at KL is made up of eminent faculty from premier institutions in India and across the globe. With more than 500 faculty holding PhDs and 550 more pursuing PhDs, KL leaves no stone unturned in edifying higher education. Academics at KL are divided between our faculty and a roster of acclaimed international and guest faculty. The usage of teaching pedagogies like flipped classroom, project-based learning, empirical learning, and deep and blended learning, faculty at KL certify a holistic education for every student. Lab taken to class allows students to receive a more hands-on education, which leaves them with a deeper understanding of concepts and practices. Our fully flexible choice between credit system empowers the student to hold the reins of their education. Skilling is about adding another dimension and expertise to a student's arsenal. We keep our eyes on the future, while our feet firmly rooted in the present. In an exciting association with National Skill Development Council and engaging the best in the industry and domain experts, KL has introduced methods to educate students in skills necessary for the future, like big data and analytics, Internet of Things, artificial intelligence and machine learning, cybersecurity and forensics, applied signal processing, robotics, renewable energy, and many more. Technical clubs in all the departments allow students to interact with like minds and grow further. Research in all domains is given as much importance as academics. KL is at the forefront of industrial and academic research, with 2,000 plus active researchers, 7,000 plus research publications, and 50 plus patents. Needs of the common man are the most important for us at KL, be it our research in big data, helping us to map out weather patterns, to enhance satellite communications, or map DNA. The Government of India supports our endeavors fully, as evidenced by their aid in the form of more than rupees 40 crore. Everything at KL is geared towards providing our students a clear shot at their dream career. All registered students placed to companies, resulting in our proud 100% placement rate. More than 50 companies have offered salaries larger than 5 lakhs annum. KL provides launchpads for the career progressions of every individual student. Coaching and mentoring services are available for GRE, TOEFL, IELTS, GATE, and civil service. To further hone the entrepreneurial spirit, we have a government-sanctioned business incubator and center for innovation and entrepreneurship to nurture student-led startups.
And also we prepare students for higher education. So for example, if students want to go abroad, do their master's program, so we also have GRE coaching at the university itself.
Life at KL is a plethora of great times spent with like-minded people in an environment conducive to creativity and growth. We host national-level techno and cultural fests, where students are given a platform to display their talent and more than 70 hobby clubs to explore said talent. They stay fit at our world-class sports arenas and gyms, and nourished at their choice of 8 multi-cuisine cafeterias. And has formed partnerships with over 64 foreign universities with exchange programs to deliver a truly global exposure to our students. Semester abroad and twinning programs give the students a global exposure. With its sights set far above the horizon, KL is bringing global education to everyone. With
will be starting shortly. I also request all the people who have not yet registered to go and get themselves registered. I repeat, I request all the advocates who have not got registered yet to go and get themselves registered. We have on-spot registrations and new registrations available in the lobby, and we also have a help desk. Please make use of it.
Their launch of the new campus in Hyderabad. Designed by the world-renowned architects Woods Bagot, the state-of-the-art campus is being built to international standards. It's easy to be part of the crowd and follow, but it's difficult to be different and stand out. At KL, we do not believe in simply teaching. We believe in creating global personalities who stand out with KL. KL, deemed to be university.
Welcome to this very exclusive auction. और ये है, ladies and gentlemen, भारत के संविधान की ओरिजिनल कॉपी। उन 1000 कॉपियों में से एक, जिन्हें कॉन्स्टिट्यूएंट असेंबली मेंबर्स के लिए स्पेशली तैयार किया गया था। A very rare and truly a collector's item, which was meant for those जिन्होंने 3 साल रात दिन एक करके इस किताब को मुकम्मल किया था। पेश करते हैं लेडीज एंड जेंटलमैन, द कॉन्स्टिट्यूशन ऑफ इंडिया, भारत का संविधान।
ये कोई आम किताब नहीं, बल्कि प्रतीक है हमारे मुल्क का। पर कभी सोचा है आपने कि ये मुल्क आखिर होता क्या है? समाजशास्त्री कहते हैं कि एक ही नस्ल, धर्म, जबान, परचम और हुक्म को मानने वाले बाशिंदों के समूह से बनता है एक मुल्क, एक देश। मगर हिंदुस्तान जैसे बहुत सी भाषाओं, धर्मों और तमाम जातियों प्रजातियों वाले सब कॉन्टिनेंट को किसी तंग नजरिए से नहीं देखा जा सकता है। और ऐसे मुल्क, ऐसे समाज में पुरानी रीतियों को तोड़कर सबको साथ लेकर आगे चलने के लिए किसी पुराने कानून से भी काम नहीं चल सकता है। इसीलिए हमारे पुरखों ने बनाया था हमारा संविधान, हमारा कॉन्स्टिट्यूशन, हमारा आईन। ये आईन ही तो वो आईना है जिसमें देखकर ही हम खुद को पहचान पाते हैं और संवार भी सकते हैं। आज से मैं आपको इस जादुई आईने के अंदर के संसार की सैर पर ले जाऊंगी। ये कैसे बना, कब बना, किस किसने बनाया और क्यों बनाया। तो चलिए चलते हैं वहां जहां कहानी शुरू हुई थी, हमारे संविधान की। बट फर्स्ट थिंग्स फर्स्ट, पहले आप भी तो ठीक से देख लीजिए उस मुकद्दस किताब को जिसकी बात हम कर रहे हैं। शांति निकेतन के प्रसिद्ध चित्रकार श्री नंदलाल बोस की रहनुमाई में कई कलाकारों ने भारत के इतिहास, पुराण और लोक कथाओं की छवियों से इस ग्रंथ को सजाया था। और प्रेम बिहारी नारायण रायजादा जैसे खुशखत कातिबों ने इसे अपने कलम से निखारा था। मगर ये काम मुश्किल होते हुए भी बहुत आसान था उस काम के मुकाबले जो इस संविधान की कल्पना कर इसे लिखित रूप देने वालों ने संविधान सभा में पूरे 3 साल लगाकर किया था। क्योंकि वह कल्पना केवल एक किताब की नहीं थी, वह तसव्वुर था एक नए मुल्क का, एक नए समाज का, एक ऐसी नई संस्कृति का जो इससे पहले इस संसार में कभी देखी नहीं गई थी। दिसंबर 1946 में जिस इमारत की तामीर शुरू की गई थी, असल में उसकी नींव बहुत पहले रखी जा चुकी थी। 1857 की क्रांति के दौरान बागी सिपाहियों ने भी हिंदुस्तान का एक अपना संविधान बनाने की कोशिश की थी। उनका विद्रोह तो जल्दी ही दबा दिया गया, मगर आजाद देश का एक अपना आईन बनाने का सपना न दबा था न हारा था। और जैसे जैसे महात्मा गांधी के नेतृत्व में आजादी की आवाज तेज हुई, तो अपना संविधान बनाने की मांग भी और तीव्र होती गई।
My mentor Gopal Krishna Gokhale presented to the British government a note on the Constitution in 1914, and the British said, yes, we will accept it after the war. But now they want to make a constitution for us. But you know, a constitution for India should be and can be framed only by Indians. Now it works.
What will you do with this spinning wheel, Mr. Gandhi?
This is my secret weapon to drive the English rulers away so that we will have the power to make our own constitution.
अब गांधी जी की सरपरस्ती में इतिहास ने दोबारा हमें एक नए भारत को गढ़ने का मौका दिया था। कांग्रेस नेता और आला वकील पंडित मोतीलाल नेहरू ने 1928 में एक रिपोर्ट तैयार की जिसे नेहरू रिपोर्ट या स्वराज संविधान के नाम से भी जाना गया। और उनके बाद जब उनका बेटा जवाहर कांग्रेस का सदर बना, तो उस युवा नेता ने हिंदुस्तान के अपने संविधान के सपने को और शदीद तरह से सबके सामने रखा।
आजादी दी नहीं जाती, स्वतंत्रता किसी कानून के नुक्ते को बदलकर नहीं मिला करती। इस तरह तो नए निजाम के नाम पर अंग्रेजों की पुरानी गुलामी को और मजबूत किया जाएगा। सच्ची आजादी तब मिलेगी जब हम अपनी चुनी हुई संविधान सभा के जरिए खुद अपने देश का संविधान सोचेंगे, अपना आईन तय करेंगे, अपना कॉन्स्टिट्यूशन बनाएंगे। भारत माता की जय! भारत माता की जय!
जवाब में अंग्रेजों ने सन 1935 में एक गवर्नमेंट ऑफ इंडिया एक्ट बनाया। ये एक्ट भारतीयों की उम्मीदों से न सिर्फ बहुत कम और अलग था, बल्कि इसकी वजह से कांग्रेस और मुस्लिम लीग के दरमियान दूरियां और बढ़ने लगीं। इस बीच दूसरे विश्व युद्ध के दौरान सन 1945 में डॉक्टर तेज बहादुर सप्रू ने सभी पार्टियों से मशवरा करके एक सांझे संविधान का खाका बनाने की कोशिश की। उधर वर्ल्ड वॉर 2 की मार और इधर आजाद हिंद फौज और भारत छोड़ो आंदोलन के चलते अंग्रेजों का भारत पर अनंत काल तक राज करने का इरादा नेस्तोनाबूद हो चुका था। विंस्टन चर्चिल युद्ध तो जीते, मगर बेचारे चुनाव हार गए और बर्तानिया के नए प्रधानमंत्री क्लेमेंट एटली ने कहा कि भारत के लिए नया संविधान बनाने और मुसलमानों को अलग अधिकार देने की मुस्लिम लीग की मांग पर काम फौरन शुरू किया जाएगा। इसी के मद्देनजर पहली बार हिज मैजेस्टी की सरकार के 3 कैबिनेट मंत्री एक साथ भारत भेजे गए और ये कहलाया कैबिनेट मिशन।
Believe me, India will be a much better place after you have left us to ourselves.
That's precisely what we ought to do, Mr. Gandhi. Our only fear is whether it's possible to minimize the violence and the bloodshed which is predicted in this subcontinent when it breaks into Hindustan, Pakistan, and Princeton.
Then don't break India.
But what about Mr. Jinnah's Pakistan?
Why will you listen to my brother Jinnah if you are not ready to listen to others? And why do you presume that Jinnah will not see sense when you meet him in Shimla?
I do wish our hopes come true when we meet in Simla, but it is important that you're also present there.
What will I do there? I'm neither a member of the Congress nor of the Muslim League or of the other outfits that you have invited there.
But still, we will need your wise counsel in Simla when discussions are held about an interim government and a new constitution for India.
लाट साहब यानी वाइस रॉय की शिमला कोठी में बैठक लग रही थी और वहां भारत भर की अहम सियासी हस्तियां जमा हो रही थीं। कांग्रेस की तरफ से आए थे उनके अध्यक्ष मौलाना आजाद, साथ में थे पंडित जवाहरलाल नेहरू, सरदार वल्लभ भाई पटेल और खान अब्दुल गफार खान। मुस्लिम लीग की तरफ से थे मिस्टर जिन्ना, जिनके साथ थे लियाकत अली खान, सरदार निश्तर और नवाब इस्माइल खान। फिर सिख, पारसी, ईसाइयों और दलितों के नुमाइंदे भी थे। उधर पूरे मुल्क में फैले सैकड़ों रजवाड़ों की तरफ से वहां मौजूद थे भोपाल के नवाब मोहम्मद हमीदुल्ला, जो उन दिनों चेंबर ऑफ प्रिंसेस के चांसलर थे।
Friends, the winds of change have swept the old order all over the world, ever since this bloody war started. And our new Labour government of Britain is of the opinion that the time has come for Indians to decide how they are going to govern themselves. And the purpose of this meeting is to have discussions with all of you. The representatives of British India and the Indian states is to secure a way of framing the constitution of a free India.
जिन्ना साहब को ये बात नागवार गुजर रही थी कि जिसे वो महज हिंदुओं की पार्टी मानते थे, उस कांग्रेस के आधे नुमाइंदे मुसलमान थे और उनकी रहनुमाई भी एक मुसलमान ही कर रहा था। शिमला की ठंडी आबो हवा का ऐसे माहौल में गर्म हो जाना लाजमी था।
मैं और मेरे साथी इस वक्त यहाँ पूरे हिंदुस्तान की आजादी की पेशकश लिए मौजूद हैं। बाकी मसाइल दोयम है जो हम बाद में भी तय कर सकते हैं। अपनी कॉन्स्टिट्यूएंट असेंबली में जो जमा होगी एक आजाद हिंदुस्तान के ख्वाब की ताबीर करने के लिए।
My colleagues and I stand here for the independence of the whole of India. Other matters are subsidiary to this and can be discussed and decided in the Constituent Assembly, which will make a blueprint for an India of our dreams.
Dreams that may turn into nightmares for the Muslims of this country if we allow the Congress to have its way. That's why it's imperative that we Muslims of India have our own group of states that may decide its own constitution.
What are the groupings you have in mind, Mr. Jinnah?
All the Muslim majority states like Sindh, Punjab, Balochistan, and Northwest Frontier Province will form the first group. And the states of Assam and Bengal will be in the second group.
Mr. Jinnah, if, as you suggest, these groups separate from the body of India, then pray tell us, what is left for the Constituent Assembly to make laws for?
The rest of India in the center and the south.
And what happens to the princely states?
Well, they can have their own constituent assemblies.
This is not acceptable to us. We are here to discuss the fate of a united India, not to break India into pieces. And if this is the purpose of this mission, I'm afraid we have no business being here.
In that case, I'll be forced to adjourn the meeting.
जिन्ना साहब चाहते थे कि हिंदुस्तान के पूर्व में असम और बंगाल और पश्चिम में 4 मुस्लिम बहुल सूबों के लिए एक अलग संविधान सभा बने और बाकी के भारत के लिए दूसरी संविधान सभा, और राजे रजवाड़े खुद अपने आप तय करें कि उन्हें किसी के साथ जाना है या खुद मुख्तार रहना है। जाहिर है कांग्रेस के नेताओं को ये अनेक संविधानों की सूरत बिल्कुल बर्दाश्त नहीं थी।
कल कुछ लोगों ने ग्रुपिंग्स के लिए एक तजवीज पेश की थी जो हमारे मुल्क को मजहब व मिल्लत की बिना पर बांटने की एक पेशकश है। हम ऐसी किसी भी तरह की पेशकश के सख्त खिलाफ हैं। हिंदुस्तान एक मुल्क है, आप सुन रहे हैं लियाकत अली खान साहब? हिंदुस्तान एक मुल्क है और एक ही असेंबली इसका आइन बना सकती है जिसमें तमाम सूबों, इलाकों, मजहबों और फिरकों के चुने हुए मेंबरान और राजे रजवाड़ों के भेजे हुए नुमाइंदे भी शामिल होंगे।
References were made yesterday to groups of provinces arranged on communal lines. We are totally against any machinery to run any such groupings. India is one nation and it needs its constitution to be made by one assembly, which has elected representatives of the states, region, religion, and the nominated representatives of all the princely states as well.
This is what I call the tyranny of numbers. Everyone knows here that such an assembly will have a brute majority of caste Hindus and their party, the Congress. And in the game of numbers, minority Muslims will have no say left. That's why we need 2 assemblies, so that Muslims can frame their own laws.
मगर मेरे भाई जिन्ना, क्या आज तक हमारे पास हिंदुओं के लिए अलग और मुसलमानों के लिए अलग आइन थे? नहीं थे ना? तो फिर यकबयक आज इन 2 कानूनों की जरूरत क्यों आन पड़ी? क्यों?
I trust the British sense of fair play. But with the Hindus ruling India through their Congress, Muslims need a special constitutional protection. I have gone through the length and breadth of India, and I know how vulnerable Muslims are feeling today. And as their sole representative here, it is my duty to...
ये आपसे किसने कह दिया कि मुसलमानों के अकेले नुमाइंदे आप ही हैं? अरे भाई, मुसलमान तो हम भी हैं, क्यों मौलाना?
Well, I do not need to establish my credentials here. Because the Muslims of this country know who stands here for their rights and who here is a paid quisling Muslim masquerading as their representative.
I take strong objection to such a remark being made about my esteemed colleague.
Mr. Jinnah, if I've got you right, you need these groupings because of the communal mistrust that exists in this country.
That's perfectly right, Sir Stafford. Muslims cannot be a part of a constituent assembly which will be dominated by caste Hindus.
Maybe deal with first things first, please. Which is to dispose of the problem of the Indo-British relationship. For that, we need to make our own constitution for a free India. The communal problem can be dealt with later.
Later? Later, there'll be no Muslims left alive in India if Congress is given its way.
Hello. I request all the advocates to be seated, and also I request all you people to turn your phones onto silent mode. I repeat, please turn your phones onto silent mode. We'll be starting shortly in 2 minutes.
And I request everyone to be seated.
Ladies and gentlemen, esteemed advocates and respected guests, a warm welcome to the 3-day residential orientation program organized by KLEF College of Law, a constituent unit of KL deemed to be university, in association with Bar Council of Andhra Pradesh. Today, we gather to renew our commitment to the pursuit of justice, knowledge, and professionalism. Your presence here enriches this occasion, and we are honored by your participation. Let us embark on this journey of learning and camaraderie together as we seek to elevate the legal profession to new heights. Once again, welcome and thank you for gracing us with your presence. This is Vaishnavi from 3rd year BBA LLB.
And this is Maushmi from 4th year BBA LLB. With great pleasure and profound administration for the rich tapestry of cultural heritage, that we extend a gracious welcome to the traditional dance performance about to grace our esteemed gathering. As we immerse ourselves in this captivating display of artistry, let us pay homage to the timeless traditions that bind us together in appreciation of the arts. We invite you all to embrace the allure of the performance and revel in the beauty of our shared cultural legacy. Without further ado, join your hands to welcome Lavanya from 5th year BBA LLB of KL College of Law to perform a classical dance.
धीमहि गुणशरीराय गुणमण्डिताय गुणेशानाय धीमहि गुणातीताय गुणाधीशाय गुणप्रविष्टाय धीमहि एकदन्ताय वक्रतुण्डाय गौरीतनयाय धीमहि गजेशानाय भालचन्द्राय श्रीगणेशाय धीमहि एकदन्ताय वक्रतुण्डाय गौरीतनयाय धीमहि गजेशानाय भालचन्द्राय श्रीगणेशाय धीमहि गानचतुराय गानप्राणाय गानान्तरात्मने गानोत्सुकाय गानमत्ताय गानोत्सुकमनसे गुरुपूजिताय गुरुदैवताय गुरुकुलस्थायिने गुरुविक्रमाय गुह्यप्रवराय गुरवे गुणगुरवे गुरुदैत्यकलक्षेत्रे गुरुधर्मसदाराध्याय गुरुपुत्रपरित्रात्रे गुरुपाखण्डखण्डकाय गीतसाराय गीततत्त्वाय गीतगोत्राय धीमहि गूढगुल्फाय गन्धमत्ताय गोजयप्रदाय धीमहि गुणातीताय गुणाधीशाय गुणप्रविष्टाय धीमहि एकदन्ताय वक्रतुण्डाय गौरीतनयाय धीमहि गजेशानाय भालचन्द्राय श्रीगणेशाय धीमहि एकदन्ताय वक्रतुण्डाय गौरीतनयाय धीमहि गजेशानाय भालचन्द्राय श्रीगणेशाय धीमहि सर्वराजाय गन्धाय सर्वगानश्रवणप्रणयिने
गाढानुरागाय ग्रन्थाय गीताय ग्रन्थार्थतत्त्वविदे
गुणवते गणपतये ग्रन्थगीताय ग्रन्थगेयाय ग्रन्थान्तरात्मने गीतलीनाय गीताश्रयाय गीतवाद्यपटवे गेयचरिताय गायकवराय गन्धर्वप्रियकृते गायकाधीन विग्रहाय गङ्गाजलप्रणयवते गौरीस्तनन्दनाय गौरीहृदयनन्दनाय गौरभानुसुताय गौरीगणेश्वराय गौरीप्रणयाय गौरीप्रवणाय गौरभावाय धीमहि गोसहस्राय गोवर्धनाय गोपगोपाय धीमहि गुणातीताय गुणाधीशाय गुणप्रविष्टाय धीमहि एकदन्ताय वक्रतुण्डाय गौरीतनयाय धीमहि गजेशानाय भालचन्द्राय श्रीगणेशाय धीमहि एकदन्ताय वक्रतुण्डाय गौरी
Thank you, Lavanya. It is with great honor and immense respect that we welcome the esteemed chairman of the Bar Council of Andhra Pradesh, a paragon of legal acumen and unwavering dedication. He has tirelessly championed justice and integrity within our legal community. Under his visionary leadership, the council has flourished, setting new benchmarks in legal excellence and professional ethics. His commitment to upholding the rule of law and nurturing young legal minds has been nothing short of inspiring. Let us applaud and celebrate the remarkable contributions of a true luminary in the field of law. I request Honorable Sri N. Dwarkanatha Reddy Garu, Chairman of the Bar Council of Andhra Pradesh and the President of today's function, to come to the dais and adore the chair. I request Madam Vijay Sudha Garu to present a bouquet to Honorable Chairman Sri N. Dwarkanatha Reddy Garu.
Honorable Sri Justice U. Durga Prasad Rao Garu, the one who has made indelible contributions to the legal world, epitomizing judicial excellence and profound erudition, his jurisprudential insights and steadfast commitment to justice have consistently illuminated the path of equitable legal interpretation and application. Renowned for his sagacity and impartiality, Justice Rao has rendered landmark judgments that have significantly shaped contemporary legal thought and jurisprudence. His dedication to the rule of law and meticulous legal scholarship has not only fortified the legal framework, but also inspired the legal fraternity, setting a lofty standard for integrity and intellectual rigor within the judiciary. I request the chief guest of today's function, Honorable Sri Justice U. Durga Prasad Rao Garu, Judge of the High Court of Andhra Pradesh, to come to the dais and adore the chair. And I request Sri P. Narasimha Rao Garu, Member of Bar Council, to present a bouquet to His Lordship.
Sri S. Krishnamohan Garu, an embodiment of legal prowess and ethical fortitude. He has been a stalwart advocate for justice and professional integrity. His profound legal acumen and unwavering dedication have significantly advanced the Council's mission, fostering an environment of excellence and accountability. Through his visionary leadership, he has championed pivotal reforms and initiatives, enriching the legal community and enhancing the practice of law. His exemplary service and steadfast commitment continue to inspire and elevate the standards of our generation. Today, I'd like to request the the Vice Chairman of the Bar Council of Andhra Pradesh, Sri S. Krishnamohan Garu, to come onto the dais and adore the chair. I request Mr. Piyush to present a bouquet to Sri S. Krishnamohan Rao Garu.
Sri K. Chidambaram Garu, a luminary in the legal fraternity and president of the AP High Court Advocates Association, whose eminence and dedication has left an indelible mark on the legal landscape. With erudition and unwavering integrity, he exemplifies the epitome of legal scholarship and ethical advocacy. As a distinguished member of the Bar Council of Andhra Pradesh, his contributions to legal reform and jurisprudence are unparalleled. Sri Chidambaram Garu's visionary leadership has steered the legal community towards greater professionalism and social responsibility, fostering a culture of legal excellence and equitable justice for all. I request member of the Bar Council of Andhra Pradesh and President of AP High Court Advocates Association, Sri K. Chidambaram Garu, to come on to the dais and adore the chair. I request Ms. Ashrita to present a sapling to Sri K. Chidambaram Garu. Mr. Gantarao Garu, a distinguished senior advocate and esteemed member of the Bar Council, epitomizes legal excellence and unwavering commitment to justice, possessing an erudite understanding of jurisprudence. His illustrious career is marked by a philanthrop of landmark cases and profound legal insights. Renowned for his sagacious courtroom demeanor and meticulous legal acumen, Mr. Rao stands as a paragon of legal integrity and ethical conduct. The indomitable passion for upholding the rule of law. He remains an influential figure in the legal fraternity, revered for his profound intellect, unwavering advocacy, and steadfast dedication to the principles of equity and fairness. I request Senior Advocate and the Member of Bar Council of Andhra Pradesh and Program Coordinator, Sri Ganta Ramarao Garu, to come up to the dais and adore the chair. I request Mr. Shastri to present a bouquet to Sri Ganta Ramarao Garu. Ramachandra.
As the custodian of administrative efficiency and academic sanity, the Registrar of Koneru Lakshmaya Educational Foundation, Guntur, embodies a quintessence of institutional stewardship and scholarly diligence, revered for the orchestrating the seamless orchestration of bureaucratic mechanisms and academic protocols. Their tenure epitomizes a harmonious fusion of administrative finesse and educational excellence. With a sagacious stewardship that transcends conventional paradigms, the Registrar stands as vanguard of the institutional ethos, ensuring the preservation of academic integrity and the promotion of holistic educational values. Their judicious oversight and unwavering commitment to excellence serve as guiding beacons, illuminating the path towards the institutional eminence and scholarly enlightenment. I request Dr. K. Subbarao Garu, Registrar, KL deemed to be University, onto the dais and adore the chair. I request G. Vasantalakshmi Garu to present a bouquet to Sri Dr. K. Subbarao Garu.
As we prepare to commence this enlightening journey, we invoke the timeless symbolism of the lamp, a beacon of enlightenment and sagacity. In a moment of solemnity and reverence, I beseech all the distinguished dignitaries on the stage to graciously step forward and inaugurate this ceremonial act by igniting the lamp, thereby heralding a new chapter of erudition. May this illumination kindle the flames of insight and inspiration within us all.
दीपज्योतिपरं ज्योतिः दीपज्योतिजनार्दनः दीपो हरतु मे पापं दीपज्योतिर्नमोऽस्तु ते शुभं करोतु कल्याणम् आरोग्यं शुभसम्पदः द्वेषबुद्धिविनाशाय आत्मज्योतिर्नमोऽस्तु ते आत्मज्योतिप्रदीप्ताय ब्रह्मज्योतिर्नमोऽस्तु ते ब्रह्मज्योतिप्रदीप्ताय गुरुज्योतिर्नमोऽस्तु ते
We are honored to invite the esteemed principal of Law College, whose visionary leadership and dedication have profoundly elevated our institution. Under his guidance, the college has achieved unparalleled academic excellence, fostering a culture of integrity, innovation, and scholarly brilliance. His unwavering commitment to legal education has inspired both faculty and students, setting a benchmark for future generations. Now, we invite Principal of KL College of Law, Dr. I. Pavan Kumar Garu, to address the gallery.
Hope everybody is comfortably seated. Good morning to all of you. Distinguished guests on and off the dais, honorable judges of High Court of Andhra Pradesh, chairmen and members of Bar Council, honorable Vice Chancellor in absentia, faculty, KLUF College of Law, senior advocates, press, media and representatives of various disciplines of society, advocates, delegates, and my dear student community at large. It's a great occasion for all of us. I have two roles to play here. One as a principal, College of Law, and second one as the convener for this event. So I take 2 minutes of your time. The first one as the principal, College of Law. I have a couple of proposals to the professional body that has come here, AP Bar Council, and also the Chamber of Commerce representatives, AP Bar Association, members of Bar Association, representing various bar associations here. Number one is that we plan to empanel senior advocates having academic acumen to share and interact with the students of College of Law and guide them into the profession, because they are the budding advocates, they are the future advocates. So I want the advocates here to volunteer themselves to panel themselves in the list of advocates, so that they can, the students can enrich with their experience. And we also welcome research collaborations with every organization, including Bar Council of Andhra Pradesh, India, as well as Chamber of Commerce and other institutions. Research immersive learning we are embarking upon, KL University, the objective or the philosophy of KL University is to ensure that every program that we offer and every course that we teach should have a social impact, should have a social relevance. So in that pursuit, even law, we all know, is a social engineering is all about. So we want to extend your cooperation in allotting some of our students to the senior advocates, so that they can imbibe into the social immersive learning. We also have a proposal for professor of practice position in the College of Law in the university. Whoever has academic interest and want to join hands with the Department of Law, please, you can approach me. I am available 24/7 here. Then as, for this specific event, I want everybody to participate in this in all the interactive sessions. Luminaries of law are coming here to share their experience and knowledge. So get optimum benefit of it. And also I request earnestly to own the campus, own your hostel, own the AC units. This is your platform. Every facility that is given here has its own cost implications. My earnest request is to be sensible enough with all these facilities, and my students, faculty, everybody are at your disposal. Thank you all. Happy learning. Thank you.
Thank you, sir. I request Sri N. Dwarkanatha Reddy Garu, the Chairman of Bar Council of Andhra Pradesh, to preside over today's inaugural session.
Honorable Justice Durga Prasad Rao Garu, the Judge of the Honorable High Court of AP, the Vice Chairman of the Bar Council, my friend Mr. Krishna Mohan, the President of the High Court Bar Association, and also Senior Member of the Bar Council of AP, Mr. Chidambaram, the former Chairman of the Bar Council, Mr. Ganta Ramarao Garu, and the Registrar of this prestigious institution, KL University, Mr. Subbarao Garu, and just now your principal, the principal also has spoke just now. All the delegates of this conference or a workshop, and particularly the honorable members of the Bar Council who allowed me to conduct this particular seminar or the workshop in collaboration with this particular university, KL University. My friends and the colleagues in the Bar Council, Mr. Nagreddy Garu, V.R. Reddy Garu, Darsing Rao Garu, Chandrasekhar Reddy Garu, Rajendra Prasad Garu, and Subbarao Garu, and all the guests, my dear friend, dear advocates. It is indeed an excellent day, particularly for the advocates who joined here in this workshop. This is not the first time that the Bar Council of Andhra Pradesh is arranging this meeting. Last year also, we had this workshop with the benevolence of the Vice Chancellor of KL University, the founders of the KL University, and all the people, those who are associated with the KL University. I do not know where the founder, Mr. Konirul Lakshmai Garu, is there. I hope so, sir. You are blessing all our advocates here. Because of your benevolence, we are conducting this particular meeting in collaboration with the Bar Council of Andhra Pradesh. Any seminar, any workshop, for the sake of any either the students or for the law students or for the lawyers, is to see that emulating themselves in their own careers, particularly in their future endeavors in our profession. I found many of, not only juniors, many of the senior also has come. It's really a wonderful thing to have an interaction with many of the judges who are going to adore the stage and address the meeting you. I request you to make all the points, because we have already, on behalf of Bar Council, we have already provided the material. Just make the important points and go to the office afterwards, check it with, particularly with the case law and others. Then that will be useful. There is no purpose, very important point, if you are not going to make it a point of that, it's not possible for you to see that how it is useful in your life. This is a wonderful thing for the 3 days workshop. As the chairman of the Bar Council and my beloved members of the Bar Council, and also the former chairman of the Bar Council, Mr. Ram Rao, we all very happy to invite all of you. And I thank particularly the management of the KL University for providing facilities for all of you. May God bless all of you. Thank you. Very nice of you. Now I request the former chairman of the Bar Council, Mr. Ganta Ramrao Garu, to address.
The President of the inaugural session, Honorable Chairman Bar Council of Andhra Pradesh, Mr. Dwarkanath Reddy Garu, the Chief Guest of today's function, Sri Justice Durga Prasad Garu, the Vice Chairman of the Bar Council of Andhra Pradesh, Mr. Krishna Mohan, my friend, the Member Bar Council of Andhra Pradesh, and the President of the High Court Advocates Association, Mr. Chidambaram, the Mr. Subbarao Garu, the Registrar of the University, the Principal of the Law College, Pawan Garu, and the staff, my advocate friends, ladies and gentlemen, it's very happy to meet you all again. I know that at least 50%, more than 50% of the people attended today who attended already in the last year's program. This program was first time conceived, this kind of program was conceived in 2003, consisting of 100 members at Bhagavatipuram, without having any state-of-art facilities like us. Even we are lacking the proper power connection. I still remember that due to power cut, we could not stay in the rooms and taken those mats and slept on the lawns of that building. And the cooperation that was extended by those participants made us to conceive these kind of programs and continue till today. In 2004, followed in 2004 in Nalsar, a program was conceived and nearly 250 people attended at that program. Thereafter in 2005, Bhavani Islands at Vijayawada, 275 people attended. All of them stayed in the island for 3 days and had a wonderful program there. Thereafter, Swarna Bharati Trust at Nellore in 2006, 2 days program held. in that 2 days program, 1 day is meant for training the young advocates, and those young advocates on the second day have educated the farmers about their day-to-day affairs. Pesticide Act and other legal awareness program was conducted. And then thereafter at Nagarjuna Sagar, for the benefit of the Guntur district as well as Nalgonda districts, the 3 days program was held at that resort tourism at Nalgonda, that Nagarjuna Sagar. And thereafter, on 3rd and 4th May of 2008 at Osmania University, and thereafter again on 10th May 2009 and 10th May 2009 at Nalsar University, and thereafter in 2016 there was a gap, again from 2016 at ICFI University, and 2017 again at ICFI University. Thereafter, all of you know, bifurcation taken place, and the new Bar Council state of Andhra Pradesh was came into existence, 2 states, and thereafter, though in 2019 we could conceive and plan to have 3-day program at Visakhapatnam, but unfortunately due to spread of virus, that program was cancelled. And thereafter, in fact, there are 2 orientation programs conducted in 2019, one at Guntur, another at Kadapa, and thereafter, due to virus, our ambitious plans to have these kind of programs were kept in abeyance. We could not proceed with them till the last year. Again, the last year, with the cooperation of the KL University, 3 days program was organized at here. And not only here, at district level, after the virus was controlled, each and almost 10 districts, 10 programs in 9 districts were organized, and in some districts 2 programs were also organized, 1-day programs. Is ultimately, even this year, either Bar Council or the KL University came forward to conduct this kind of programs because of the discipline that you have followed during the previous year and the way that you have cooperated with the organizers. I request and understand so that other people also who joined with us with a great mind and with courtesy, they provided us this campus and very worth of a program. It is being conducted with the courtesy of the university. Please kindly utilize all the opportunity without affecting adversely any infrastructure that is made available. From tomorrow onwards, you will have the benefit of yoga in the morning, probably in the lawns. Previously, we organized that institution, but if all the people attend, because last time only 300 people stayed in the campus, whereas now 480 people, around 480, are going to stay within the campus. Therefore, maybe it will be announced in the evening, if possible at the lawns, it can be organized. Please kindly take advantage, and these 2 days, tomorrow and day after tomorrow, you can practice yoga, and some of those kriyas and some of the things which were learnt last year, some of us have been practicing even till today, which will be more useful to all of us in our day-to-day life. Apart from that, there will be a cultural programs in the evening today and tomorrow also. And all of you, I request you all to cooperate by our forbearance, by our very discipline, so that we will bring respect to the institution, so that even the next year or the subsequent years, the institution will come forward to host this kind of program. The regular program, there are 13 sessions, these 3 days, and consisting of mainly 2 themes. One is property laws, second is these amendments to the these acts, that's Evidence Act and IPC and CRPC, and there will be discussions on these subjects. Apart from that, advocacy skills and other aspects relating to the profession. I request you all to pay the attention. Please, 3 days, don't switch on and switch off if necessary. These 3 days, stop here and dedicate yourself for updating ourselves and utilize each and moment, every second and minute for our updating ourselves and become a different person by the time you leave this campus. Thank you one and all.
Now I request Dr. K. Subbarao Garu, Registrar Kale University, to address the gathering.
Honorable Sri Justice Durga Prasad Rao Garu, other esteemed dignitaries on the dais, off the dais, delegates from various corners of the state, participants, a very good morning to all of you. First of all, as the registrar of this university, on behalf of the university, I express my happiness and joy on the occasion of participating in this 3-day orientation program to advocates, residential program. As a small engineering college started by late Koner Lakshmaya Garu, along with the present President, Chancellor Sri Koner Satyanarayana Garu in 1980-81 academic year. Now this is one of the top ranked universities in our country with NAC A++ accreditation and 28 among all the universities and including NITs, IITs in India given by NERF. This shows the journey of this university over the years with the vision of our Honorable Chancellor Sri Koner Satyanarayana Garu that the student going out of this university is ready-made to the needs of the industry and useful to the society. That is the reason why in this university academics alone is not the only component we concentrate. Academics along with the skilling is one component. Overall personality development is the second component. Innovation and research is the third component. And taking the student to the destination, whether the student is interested towards higher studies or placement or becoming an entrepreneur, a roadmap designed for each of these three components and ensuring the success of the student is the fourth direction. Effective systems have been established corresponding to each of these four components I have stressed. That is the reason why a student studying at KL University is considered as an all-round developed student. In this particular journey, irrespective of whether the student is engineering or any other programs joined, like we have got management, sciences, humanities, pharmacy, agriculture, law, various programs in this university, and so many academic flexibilities to the student with perfect discipline in place, with zero ragging. This is the dream for the parents to join in KL University by virtue of the implementation, by virtue of the processes we follow. And Honorable President Sri Koner Satyanarayana Garu, the visionary, the systems, whatever they have been established, are being implemented very, very effectively under the dynamic leadership of our Honorable Vice Chancellor, Sri Dr. Pardasarthi Varma Garu, and the Pro-Vice Chancellors, Dr. A.V.S. Prasad Garu, Dr. Venkatram Garu, Dr. Rajsekhar Rao Garu, and various heads of the departments, principals, effective system is established. I wish this 3-day program a grand success. As I already mentioned, our university is always, we come forward and we take the pleasure of contributing to the society in any requirement or any need. In this process, whenever there is a need, we come forward and contribute from our end. I thank the organizers for giving me an opportunity to speak to all of you on this occasion. Thank you very much.
Now I request Mr. Chidambaram Garu, the member of the Bar Council of Andhra Pradesh and also the president of High Court Bar Association.
President of the today's meeting and Chairman Bar Council of Andhra Pradesh, Sri N. Dwarkanath Reddy Garu, Chief Guest, Honorable Justice U. Durga Prasad Rao Garu, Senior Member of the Bar Council and Vice Chairman of the Bar Council of Andhra Pradesh, Sri S. Krishna Mohan Garu, Senior Advocate and Coordinator of this meeting, Member Bar Council, Sri Ganta Ramarao Garu, Registrar, KL University, Sri K. Subbarao Garu, members of the Bar Council of Andhra Pradesh, Principal, Law College, KL University, and faculty members of Law College, KL University, senior advocates, young advocates from High Court and various parts of Andhra Pradesh. Good morning to all of you. Now, the Bar Council of Andhra Pradesh has been conducting this type of seminars or workshops, symposiums for the benefit of advocates, particularly young members of the bar. Now, coordinator of this event, Sri Ganta Ramarao Garu, has already informed about the various programs, this type of programs conducted by the Bar Council of Andhra Pradesh for the last 10 years. Purpose for conducting this type of symposiums is to share the knowledge in law by the legal luminaries for the benefit of the particularly the young members of the bar. Now, I do not want to waste your valuable time. Now we are going to hear the knowledge sharing of His Lordship Justice U. Durga Prasad Rao Garu. I request all of you to kindly follow and acquire some knowledge in law for dispensation of justice. I request you all to maintain discipline, enjoy the atmosphere of KL University and their hospitality, acquire some knowledge for dispensation of justice. I request you all to cooperate with the management of KL University as well as the Bar Council in conducting this program. Thank you for giving me an opportunity. Thank you very much.
Now I request Mr. Krishna Mohan, the senior member of the Bar Council and also the Vice Chairman of the Bar Council of Andhra Pradesh, to address the gathering.
President of today's function, Sri N. Dwarkanath Reddy Garu, Chairman Bar Council of Andhra Pradesh. Chief guest of today's residential orientation program, Honorable Justice Sri U. Durga Prasad Rao Garu, Judge, High Court of Andhra Pradesh. the Registrar Dr. K. Subbarao Garu, Designate Senior Advocate K. Chidambaram, Member Bar Council of Andhra Pradesh, and President Bar Council, President High Court Bar Association, High Court Bar Association, and Sri Ganta Ramarao Garu, the Chief Coordinator of this entire program, of the orientation program. Actually, we thought of organizing this program with the university immediately after vacation, the starting of summer. Due to various reasons and holidays and election process, now we could get this premises and program conducted today with the full support of the KLEF University. Ganta Ramarao Garu is a senior Bar Council member, 5th time in the council. I also was in the member from 2000 at Combined High Court. From 2003, as Mr. Ganta Ramarao has informed, 2003, 2004, 2005, 2006, 7, 8 and 9, we have conducted seminars or workshops or orientation program at Nalsar, Hyderabad, Vijayawada, Nellore, Guntur, Osmania University, Hyderabad, and ICFI residential program in the year 2016 and 2017 during summer vacations. And it gives me a great pleasure for me to address this gathering in the inaugural session of it by the chief guest to address on today's subject, overview of Bharatiya Nyaya Sanhita IPC, the new laws, which is more relevant for us in day-to-day practice in the legal profession. Thereby, the same shall be useful to the bench and the bar, to the regular advocates, practicing advocates, and also the students from the university who have attended. I am very happy that the house is full with the 13 district advocates, from day one advocate till senior advocates ranging up to 25 years of standing and more. This is a good sign for continuous legal education. Bar Council, in Bar Council, we have that, it's a part of the program that we have to go for legal education. And from 2003, we are continuously going in the Common High Courts, Common High Court at Hyderabad. Now after separation, out of 13 districts, we have completed 10 and 3 are remaining to get a program, either with the active assistance of the Bar Association or the universities, now with KLEF University. As you all know that this 3 days program will enrich your knowledge by our honorable speakers coming from different fields, and also from our Honorable High Court and Supreme Court, with their vast knowledge and experience on different subjects, which is very useful to our day-to-day practice. And as requested by my elder speakers, I request all the delegates and the participants here to pay their full attention and make use of the opportunity and maintain full discipline and bring dignity to the Council of Andhra Pradesh, so that again we will get a chance and utilize the facility of KLEF University. Discipline is only the better thing where we can show. Morning we had a walk, myself and the chairman and all the other Bar Council members. We have observed that 45 vigilance officers are there in the entire campus, which is a very rare incident to see and watch. Their only duty is to see that the university is kept clean, with no anti-ragging, zero, and every student is being put in a proper way. The students are very lucky, and their parents are also lucky to have this type of university. And the principal, Praveen Kumar Garu, has requested for juniorship, professorship, combined programs, if any, with the university legal team. Definitely, the entire bar council will sit and we will make a proposal on the council members. And our state bar council is always indebted to the Honorable High Court judges and Supreme Court judges who are sparing their valuable time in spite of their busy schedule by addressing and sharing their knowledge. And the same shows their concern towards this legal profession. Lastly, I thank the organizers for giving me this opportunity to address this gathering at the inaugural session. Thank you all.
The man who is well known in the judicial field and the senior judge of the Honorable High Court of AP, our chief guest, Honorable Justice U. Durga Prasad Rao, the judge of the Honorable High Court of AP, will inaugurate this meeting and address you on the presentation on overview of Bharatiya Nyaya Sanhita. You all very well know what is Bharatiya Sanhita. It is no other than the previous Indian Penal Code. Now I request the chief guest to address the meeting.
Good morning, all of you. The Chairman Bar Council, Sri N. Dwarkanath Reddy Garu, Vice Chairman Krishna Mohan, members of the Bar Council and senior advocates, Sri Ganta Ramarao and Chidambaram Garu, who is also happened to be the President of the Bar Association, High Court of AP, and senior advocates, and also most importantly, the young and budding advocates, the registrar of the premier university, KL University, and also the principal of the law college of the university. Before I interact with you on the subject, it is my pleasant duty to congratulate Miss Lavanya, who has enthralled us with her dance performance. I'm happy that this program has begun with a traditional note of Ganesha Stuti. If you have had closely observed her, she gave a message, I feel, to us. Not just giving an entertainment to us, not making a devotional dance, but she has given an underlying message which is most important for us, mostly those who are in the field of the law, that you need an immense concentration. There is a sloka in Natya Shastra, Natya Darpanam, how much concentration one artist has to take upon to give an entertainment, a fulfilled entertainment. I quote, Eto hasta tato drusti, eto drusti tato mana, eto mana tato bhava, eto bhava tato rasaha. If you have to give a rasa, there are called in our traditional style, 9 rasas. Any rasa you have to exhibit through your dance performance, how much the epitome of your concentration should be. Because a dancer performs with his 108 mudras, they call it. These mudras are with hands and legs, they will exhibit. So while the performance is going on, the artist must keep on her drusti, sight onto these mudras. Not only that, not only the drusti, but this manaha, manas also should be on performance. Not only manaha, if you concentrate this manaha, drusti on your hands and legs, the way you are performing, then only you can give the bhava which you wanted to. If you can give that bhava, then only the rasa can be in the form of entertainment that can be given to the audience. That is what she has done today. That is why I have taken time. In every walk of the life, particularly for us who are in the field of either science, law, or any other faculty, concentration is most important, because the young advocates are here, which they have to shine in the due course of time. I request to imbibe this principle of immense concentration is required. Land advocates, that is what I think this girl, Lavanya, has given to us to understand, not only the mere entertainment. Now come to today's topic. I'm happy that always the Bar Council of Andhra Pradesh has been undertaking the task of giving the advocate community various programs on various legal subjects. Yes, it is required. We have to constantly sharpen our saw. Otherwise, like a saw, our mind will become blunt. Just now the principal was telling that they are preparing the social engineers. Yes, social engineering is the term which was coined by Roscoe Pound, the Harvard Law School Dean of the faculty. Social engineering, law serves the purpose as a social engineering. What is social engineering? If a person or if a community or if a nation loses its rights, they are victimized. They will first approach not to the court, they will approach to the lawyer first to get or solicit his advice, the way they can retrieve their lost rights. So the lawyer is the first person who serves the society to make them to regain their lost rights. That is why a lawyer is called as a social engineer. This is the word, a phrase coined by, in the latter years, by the great jurist, the Krishna Iyer. So I have been seeing in you, so many social engineers to serve this society. But to be an effective social engineer, you need to be a voracious reader of the law, not only law, social science. Not only the social science, the application of the law to the present day needs, that is more important. So you have to constantly upgrade your knowledge in every subject which you are dealing with in courts of law. Friends, that is why we are here now to hear a different legal luminaries giving you inputs on various subjects of the law. I tell you, I have been in the law subject for 40 years, both as an advocate, as a judge. Since 1984 onwards, I have been in this field. I have seen in due course of my journey in my Ulysses, a number of new law have been came into forth. One day when we were practicing 1986-87, we never conceived that the pronote litigation, Kundi litigation, will be converted into an offense. But you know that Negotiable Instrument Act has been amended, Chapter 17 has been introduced in the year 1988, making a check which was drawn by the drawer and which was rebounced for lack of funds in his account a criminal offense. Is not it? Am I right? We never conceived of, in early days of our practice, we thought that the only remedy is going to a civil court of law to get back your amount. But the law has changed with the change in the requirement, because the suits were taking a long time to get the amount rebacked to the lender or to the in the commercial transactions. So what I want to impress upon you is the law is not a static subject. Unlike some subjects, law is a dynamic one. It will change every day to suit the requirements of the country. I can also give a number of examples. One more example is, we never thought that a social equalization law will be promulgated by the center, and we thought that what you call PCR Act, Protection of Civil Rights Act, Section 7 would be sufficient if a person on account of his caste or creed only would be ignomized. But we have seen in 1989, an act was promulgated. What is it? SCST, Prevention of Atrocities Act, isn't it? So, again, I'm emphasizing the fact that law is not a static one. It will change. It will change to suit the requirements. So also dynamic laws have come. A revolutionary impact has been given in the concerned field. For example, in 1988 and also in 1994, a revolutionistic changes have come in the Motor Vehicles Act. The way one can claim for damages or compensation on account of the motor vehicle accidents. In 1994, a sea change was brought into removing the jurisdiction as well as the limitation, isn't it? In 1994 is a sea change which we have never thought of. In the early days of practice, we did not think, but to suit the requirement, a victim of this motor vehicle accident should not go empty-handed without getting compensation on account of the technicalities like limitation or jurisdiction. Now that there is no limitation or jurisdiction, isn't it? This is one more a radical change which was brought into the field of concerned field. We can talk of n number of examples. One more example, I will just close and come to our subject. When the banks were unable to realize their amounts which they have loaned to the third parties in quick and easiest manner, there the promulgation of SURFACE Act has come into, isn't it? Securitization and reconstruction of the financial assets and Secured Interest Act, SURFACE Act we call it. What it is it is a radical change. The banks and financial institutions, I am telling not for the senior advocates, please do not take it that I am teaching something which you are dealing every day with effortless ease. I am talking to primarily to the law students and young lawyers, those who have had no opportunity to deal with these subjects. A radical change was brought into in the field of the banking system for easy facilitation of getting back the loan amounts. A power has been given to the banks and financial institutions to declare a particular loan account as a non-performing asset. They call as NPA. They will give the notice under Section 13 to pay back the amount within a short time stipulated. If there is no answer from the borrower, maybe it an individual, maybe it is a company, or maybe it is a partnership firm, whoever obtained the loan from the concerned bank or financial institution. If they don't pay, they will declare that concerned agency, concerned borrower as a non-performing asset, and they will initiate the proceedings under section 13(4), etc. All of you know. They will seize off the secured asset and they will put it in auction and get back their amount. For seizure, they may depend upon the Metropolitan Magistrates Court, nearest one, to appoint an advocate commissioner to seize off that particular secured asset to put it in auction sale. Hitherto it was not there, only very sparingly under State Financial Corporation Act, section 29 and the 30 it was there. But it has been now expanded to banks and financial institutions also, now that they can themselves take the asset and put it in auction. I was for a considerable period a State Bank of India and State Financial Corporation Standing Counsel in my young days. I had seen rather how much difficulty it was to get back the loan amount given by the banks in 1980s and 90s. You have to institute a regular civil suit, it has to be tried. Even the defendants used to take a very interesting pleas, like the bank called me, I went there to borrow amount, they just obtained some signatures on various papers which I do not know, and the borrower is not an illiterate but a very senior industrialist. These type of pleas they used to take. We have to conduct a trial. That means bank standing counsels have to conduct trial, prove everything to get the amount, and execution is another ocean. You know how difficult it would be to get back the amount. But now a sea change has come by virtue of the SARFAESI Act. If the banks and financial institutions resort to this act, relatively with ease they can get their amount, which we have been seeing. Of course, there are some intricacies, there are some difficulties in implementing this law also. But when we pit these acts against the old and traditional type of litigation, comparatively, now the banking institutions are able to, financial institutions are able to recover their dues. This is another sea change. So, again, I'm trying to emphasize the budding advocates that law will never be a static one. That underlying message we must keep in mind every day. Every day you have to read like a student of law. Before coming to this place today, yesterday I happened to read till late at 10 o'clock in the court hall, because High Court library would be available for me to first of all myself acclimatize with all types of issues. So friends, there is no easiest way. If you want to sustain in the law field, legal field, as an advocate or in future as a judge, there is no other way but to read and read and read and imbibe in it, to acquire workable knowledge at least. Expertise is a different thing. At least workable knowledge in court of law you have to study, there is no other go. So in the course of the change is inevitable. Now my assigned topic, my assigned subject is relating to the 3 criminal measure acts which have been amended, which have been not amended rather, which have been newly brought forth by the central legislation, parliament, by repealing the existing 3 criminal measure enactments, that is Indian Penal Code, Criminal Procedure Code and Indian Evidence Act. These 3 enactments which are going to come, which are going to be operated in full swing from 1st July 2024 onwards. These 3 enactments are called as Bharatiya Nyaya Samhita BNS abbreviation, which is Indian Penal Code, Bharatiya Nagarik Shiksha Samhita BNSS, Bharatiya Nagarik, what you call? Samhita BNSS, which is equivalent to Criminal Procedure Code, isn't it? Then the third one is Bharatiya Shiksha Sakshas Adhinayan. That is also BSS. So, I respectfully welcome and my pranams to my senior brother Sri Akul Seshaya Garu. So, these three enactments are going to come with effect from 1/7/2024. For paucity of the time, it may not be possible for me to deal with all the three enactments, but I choose only one enactment, that is Bharatiya Nyaya Samhita, that is Penal Code. That too, the important provisions which are going to be introduced and which are the important provisions which were there, which have been repealed, which we won't find now in this enactment. So I want to give a bird's eye view on it and to relate to you this new enactment. Please bear with me. Then Bharatiya Nyaya Samhita, just if you go back to Indian Penal Code level, the historic situations under which the Indian Penal Code itself was enacted in 1860, if you go back, the year 1860 has some relevance, historical relevance, at least for me. If you read, you will also may find it out. 1857 was the Sepoy Mutiny for the first freedom fight in a large scale, which was waged by the Indians for Sampurna Swaraj, but that was failed for various reasons. Then the British colonialism thought that these type of mutinies may repeat, so we may have to bring one effective code to control these type of situations, mutinies, aggressions against the established government, and also to prescribe various other offenses and also punishments. The very purpose was to somehow punish rather than giving either victim was, it is not a victim oriented, rather it is mainly a punishment oriented, retributive you may call it. That is why if you carefully read in Indian Penal Code, the same offense sometimes in a different formats also, they dubiously call it as an aggravated form. Simply, section 410 of IPC deals with the property, stolen property definition. 411, again, a person who is recipient of the stolen property, stolen for various modes, theft, extortion, robbery, dacoity, it is already there, 411. Again, 412. 412 is by way of robbery, if a property was captured and that property is in the hands, it is treated as an aggravated form. Again, 413, in another aggravated form. So somehow the culprit is to be punished in one way or other ways, though some part of the earlier section was covering the other part also. Some sections of the Indian Penal Code were couched in such a manner that the punishment oriented laws that was felt by the law commissions recently, 22nd Law Commission, then they thought that certain redundant provisions should be deleted. Some more important provisions have to be incorporated in the new code, and therefore they felt necessity of they have felt the necessity of redrafting a new legislation, not only for Indian Penal Code, in the same lines other two Criminal Procedure Code and also the Evidence Act. So, but as I told, when we go back, the old Indian Penal Code was much more a punishing oriented, which was felt by our government recently. It was drafted by, all of you know, under the chairmanship of the first Law Commission of India, British India, Macaulay. Macaulay was the chairperson for drafting this penal code. It was introduced in 1860 and it has ruled the roost till recently. But the feeling of the nation of late was that it was not serving the purpose. Certain sections, as I told, were redundant, not necessary. They don't deal with the present day requirements. So therefore a new law has to be enacted, a new code has to be enacted. That is how this law has been drafted, and we will see important features of this, what you call, as I told, it is coming into force with effect from 1/7/2024, except one provision. That is section 106 subsection 2, which is dealing with hit and run type of cases. A hit and run away motor vehicle drivers, now they are made liable. If you happen to deal with the Motor Vehicles Act and cases, we will find sometimes the hit and run cases. In such a case, a nominal compensation of 25,000 or something was provided under the Motor Vehicles Act. Now, those type of cases are increasing. Therefore, it was thought fit to enact one provision. They introduced, it was not there in the earlier. It was sought to be introduced under 106 subsection 2 to the effect that in hit and run cases, if a driver hits any person or a property, causes damages or death or injury and goes away, and later if he is found out, the punishment will be very severe, 1 up to 5 years. That has been introduced in 106(2), second proviso, but its operability has been stalled. Though entire code comes into with effect from 1/7/2024, this particular provision is still halted. A separate notification would be given by the Parliament for its operation, except that the entire code comes into operation from what you call 1/7/2024. Another thing, a thumbnail sketch of both the enactments. While the old code was having 511 sections, this new code is only having 358 sections. You may ask how it was possible. By 3 modes they made it possible. The first one is they have shrunken or consolidated the definitions portion. If you see the penal code, the chapter 2 almost deals with the definitions and explanation, general explanations. Each explanation was given as a new section. So section 6 to section 52A, each individual explanation is treated as one independent section. For example, court. For example, what you call colony, British government, or any other thing, man, woman, dishonest. These type of each phrase, each word was given a separate section number that was consolidated by the new code. So almost 50 sections were consolidated and put in the new code, section 2 and section 3, subsections A, B, C, D, E, F, like that, they have given the nomenclature. So that is how 50 odd sections were taken away. Another mode in which they have taken away out of 153 sections are taken away. One more method is certain sections have been almost repealed. They have been repealed which were there in the previous code. I will give an example. Section 497. Section 497 adultery, because the Supreme Court has held that it is against the constitutional provisions, Article 15, Article 21, it was only a gender biased that held in one judgment. Therefore, that section has been, I may give you for your academic interest, that section which was held to be 497 . Yes, please. If you want, Joseph Saini versus Union of India, 2019-3 SCC, page 39, wherein the Supreme Court held that this provision is against the constitutional principles of equality because it is gender biased. Therefore, they held that it is against the constitutional principles. It was held in 2018. Therefore, in the new code, such type of sections which were already held as ultra virus to the constitution have been taken away. For example, section 377. I will discuss with you 377, some controversy is still left over, which I will come to you. But 377 is also taken away, unnatural offenses. Offenses against the order of the nature. But I need a small discussion with you for your academic interest. So certain types of sections have been totally taken away. Section 124A, most what you call controversial provision, sedition. Sedition is taken away, but it has been introduced in a different format. So what I want to tell you is, from old code to new code, old code was having 511 sections, whereas the new code is having only 358 sections. Why? Because almost 151 sections were taken away. From definition chapter, 50 sections were taken away. Remaining sections, 4 sections were concised into one section. For example, IPC 410 to 414. I was just telling to you, stolen property, receiving of the stolen property out of robbery, receiving of stolen property in another offense, etc. They have been concised into and made as section 314, 1, 2, 3, 4, 5, like that. So that is how entire 500 sections are shrunken into section, only 358 sections. This is one of the salient features of this BNS. Then at this juncture, it is important to know what is the new introduction into the new code. Very important introduction is in the form of punishments. Punishment is generally in IPC, if you read, you will find in section 53 IPC, isn't it? There are 5 types of punishments. One is death, imprisonment for life, imprisonment with the 2 different types of description. One is rigorous and simple imprisonment. 4th one is forfeiture of the property, and 5th one is the fine. Okay, these are the 5 types of imprisonment of the punishments. Now, if you see the present one, the most important addition to is the community service. This is the most important one, which has been there in the Western countries and some other countries. It is a new addition to our punishments. The list of punishments, community service. What is this community service? Is another mind-boggling one, because neither the penal code, that is BNS, Bharatiya Nyaya Samhita, or Bharatiya Nagarik Suraksha Samhita, neither the IPC, I mean new IPC, I'm just for easy sake I'm saying BNS or BNSS has defined this term. This is the difficulty. Understand? What is community service has not been defined, but it is made as a punishment. At least in 6 sections it has been made. You can find it out in BNS section 202, 209, 226, 3032, 355 and 356. These are the offenses, these are the sections, these are the sections in which you will come across as an alternative punishment, fine or imprisonment for a term, or fine or community service. 202, a public servant he has dealt with trading. It is against the service rules. He should not undertaking any business. Therefore, it is made as an offense. But one of the punishments is community service. So also other offenses 209, 226, 303, 355, 356. The commonality in all these 6 is all these are punishable up to 3 years. That means lesser offenses. These 6 offenses are punishable up to the 3 years, or with fine, or with community service also. Now the important aspect is, if a magistrate, all these are triable by the magistrates. If a magistrate wants to punish him with a community service, what type of community service he can impose upon? At least I put this question to myself, because I couldn't get anywhere. I'm happy if you found out, or if any one of you help me and raise and explain me. I have intensely searched all these 358 sections and also the BNSS. I could not find anywhere. First of all, there is no definition to understand what is a community service. Then, but it is made as a punishable offense. It is one of the modes of punishment. This is one difficulty. You will have only a small cue or clue if you go back to, or if you refer to Juvenile Justice Care and Protection Act. Okay? If you happen to read Juvenile Justice Care and Protection Act, which deals with Rule 2, Clause 6 of Juvenile Justice Care and Protection Act related rules, contains a definition of what you call community service. Means, if a juvenile is in conflict with law, he is found to be at all to be punished, then he has to be directed to do the community service, like maintaining a park, serving the elderly, helping local hospital or a nursing home, serving the disabled children, serving or as a traffic volunteer, etc. These 5 or 6 types of social serving punishment is given. But the question is, a penal code must be, it is one of the principles of interpretation of statutes, that a penal code must be read in between the lines only. We cannot borrow from other legislations. Penal laws and tax laws, they are a class apart. We should understand from the provisions then and there only for implementation. This is one of the rules. Of course, all these enactments are neonatal child. అంటే అప్పుడే పుడుతున్న సహజ శిశువులాంటివి. It is not good on us, at least on me, to make a big comment on it. But my view is that you cannot borrow the definition from another enactment to decide what is a community service is. This is one of the difficulties in implementing what you call community service, to impose a community service punishment to on a accused for these type of 6 offenses. The second problem that we may come across is, okay, the land magistrate taking a cue from this definition directed one of the accused, okay, I am imposing you the community service as a punishment. You go to public park and make the groundwork, clean the ground, take off the rubbish from it, and water the plants, etc. over there for 30 days, 1 month. This is punishment. Let us think for a while that he has imposed on him. This man, apart from imposing fine, okay, suppose the accused or the convict has paid the fine but did not do this community service. What is the alternative for the judge and the police? In case of the fine, if it is not paid, you all know section 53, if a fine is not paid, other relevant provisions in the IPC says that if the fine is up to this amount, the default sentence will be this much. I'm only giving an example. 1,000 rupees is the fine. The maximum default sentence is 6 months. You all know it is a simple imprisonment. So you can quantify the fine in terms of a sentence, corporal punishment in a jail. For fine, that facility is there. Am I clear on it? For quantifying a fine which is not paid, we can quantify in terms of the number of days to be punished by that accused. That is there, calculation is there. But if a social service is imposed on him, he did not follow. 1 month you have to serve in a hospital, let us say, or in a railway station, or some other public utility places. But he did not do it. What is the alternative? How to convert or quantify this, what you call social service, into a n number of days of punishment is another important problem. I suppose I have related you the issue. How to quantify it is the issue. So if he has not undergone that social service punishment, the burden will be again on the police to obtain a certificate from the concerned authority under whom this accused is asked to be served and produced before the magistrate or the concerned judge. Judge has to impose another punishment. This appears to be. But there is a remedy. There is a remedy. At least it occurs to me. At the time of punishment itself, at the time of first punishment itself, the court or the judge has to ask him, look, for this offense, for example 202, I can impose you fine as well as this, what you call, or end, either way, social service also. But I want to impose you on social service. Would you ready to undergo that social service? First of all, tell. Suppose he agrees for it, then only he has to impose the social service punishment, and upon fulfilling it, he may enlarge him. Suppose at the very first time itself, on the date of pronouncement of the punishment and judgment, at that time itself, the accused says that, no, I don't want to undergo a social service punishment. It will be ignominy on me. Please impose on me a punishment of corporal punishment of 2 months or 3 months punishment, whatever law prescribes, I will spend in the jail, or I will pay fine if you impose. So at the very inceptional stage, as on the date of pronouncement of the punishment itself, the concerned judge has to ask him, would you mind to, or are you ready to serve the social service punishment? If the accused is ready, then only he has to send him. This is the way probably one has to resolve this issue. But as on today, as the BNS and BNSS stands today, there is no such clarification. At least I could not get any clarification in this regard. The first ambiguity is there is no definition for social service punishment. We have to, if we enlarge this scope of social service, maybe these are all a very flea bite type of punishments, because the accused, we should not call them accused, because they are children, juvenile in conflict with law, these type of punishments are provided. But in terms of Indian Penal Code, that is BNS, a bigger type of punishments may be given. Suppose in that context, whether a magistrate or a judge can impose a social service punishment which is very menial. You have to undergo the sewerage plant and clean the sewerage over there. It is a menial job. Whether the accused have no rights, whether the accused has no dignity for himself, that is again a question. Can we, under the umbrella of, my straight question or my doubt is whether under the umbrella of social service, can any type of social service be imposed upon the accused, even if it affects his self-respect? You have to go to collectorate, stand over there. How many applicants they are coming for a period of 1 month every day? You have to clean off their shoes and their chappals. Suppose if this is the social service imposed, can it be? Should it be? Is again a question. So, under the realm of social service, what type of punishments that can be imposed is again a debatable one, because there is no clarification nor there is any definition. That is why I have taken much time on this punishment. But there is some ray of light in the form of this Rule 2 in the what you call Juvenile Justice Care and Protection Rules, but that is totally a different legislation intended for a different type of people who are small children. They should not be called accused at all. They should be called as juveniles in conflict with law. So I don't think that can be borrowed safely. This is one aspect. Of course, we have to stay with it. They have come to stay. This punishment is imposed by way of what you call Section 4. Section 4 of BNS, it has been introduced. This is one thing, please take note of it. Then another important feature in the BNS, coming to we all know, we are well versed with the 302, isn't it? IPC is a murder. Punishment is either death or life imprisonment and fine. Very good. It is there. Equivalent provision is, if you find the BNS 103. 103 is the provision. You will come across in it this is important one. Last slide 10. Slide 10. The thing is like this. A murder which is equivalent with 103, that is there incorporated as it is. There is no problem in it. But another provision is also included in it. It is called as mob lynching. Another a debatable one, very important one. Mob lynching is a punishment provided in 103 subsection 2. Okay. What it says is, when this is the definition and punishment. When a group of 5 or more persons acting in concert commits murder on the ground of race, caste, community, sex, place of birth, language, personal belief, or any other similar ground, each member of such group shall be punished with death or with imprisonment for life, and shall also be liable for fine. This is introduced because in the country these honor killings have become the order of the day in the name of the caste, particularly in love marriages, where intercaste marriages are being undertaken between the young persons. But those communities are not accepting it and killing the person only on the ground of caste or creed or religion, sex. So in such cases, a more pronounced punishment has been imposed and attached to 103(2). So mob lynching, it is styled as mob lynching. A mob lynching provision has been incorporated in 103(2). Okay, this was not there previously. We have only 149, what is called common object, 141 common object definition, 142 member of the common object, 149 constructive responsibility or vicarious liability has been pronounced under section 149. If a member of an unlawful assembly commits an offense, in order to what you call furtherance of the common object of that assembly, then each one of them is responsible for that act. In those lines, 149 goes on. So to that extent only we have had. But now a specific offense, if an offense is committed by 5 or more persons only on the ground of these what you call race, caste, community, sex, place of birth, language, etc., the punishment is provided with death or with imprisonment of life, and shall also be liable to fine. Okay. So this is a new offense which has been introduced. Then I already told you section 124A, sedition, has been taken away because that was the legacy of the British colonies. It was felt by our legislators, which will not serve any purpose because now we are a democratic country. Therefore, in those the wording is disaffection towards the established government. It is not the question of disaffection because we can in a democratic country question the government. We can democratically question the government. Therefore, it may mislead, and if 124A is retained in the statute books, therefore with those words, therefore it has been taken away. But at the same time, it was replaced in a different form under section 152 of BNS. It is there, but in a different form, where it is, the wording used is quite different. If a person or number of persons, in order to what you call affect the sovereignty of the country, if they challenge the sovereignty of the country by their acts, then that would be an offense under section 152. They felt that, legislators felt that questioning the sovereignty is different from causing disaffection in the manner of questioning the lopsided activities of the established government. There is a difference between these two. So 124A will not serve any purpose in this democratic country. Rather, 152 will be there, attack on the parliament, attack on the very sovereignly established government that will affect the very sovereignty of the country. Therefore, 152 is now established, is incorporated, which was not there earlier. So this we have to take note of it. Then another important question, it is a controversial one, because there is a controversy, we have to deal with it. Section 377, please return to slide 12. Section 377, you all know that an unnatural offense, which was defined as whoever voluntarily has carnal intercourse. Please pay your attention, this is a bit controversial. That is why, most importantly, all the advocates, I request, whoever voluntarily has carnal intercourse against the order of the nature, put the definition. Slide 12. Slide 12. And look up. Now, 377, okay. The definition goes like this in 377, whoever voluntarily has carnal intercourse against the order of the nature with any man, woman or animal shall be punished with imprisonment for life or with imprisonment of either description for a term which may extend to 10 years and shall also be liable to be punished. So unnatural offences were taken as a criminal act as against a man or woman or a animal. It was there in the statute books. But all of you know, in the decision in 2019 1 SCC, that is Navtej Singh Johar versus Union of India, 2019 1 SCC, criminal, page 1. The apex court, while dealing with the issue of the rights of LGBT, we can call it lesbians, gays, bisexual and transgenders. They are collectively called as LGBT, you all know. The Supreme Court in the judgment held that if 377 is retained in the statute books, it will directly affect the rights of them. By nature, nature has cursed them. Naturally, there are only two sexes, male and female, but a third gender, with qualities of a third gender, God has created. By nature, because of their physical nature, their mental cognitions, they may lead to have a cohabitation with the same sex. This is, the nature has cursed them. We don't have a right to ostracize them by taking their acts as a punishment. I suppose I have clarified this issue. So 377 was struck down in this judgment, Navtej Singh Johar versus Union of India, 2019 1 SCC, criminal 1. So 377 is no more an offense. They intended, you have to carefully catch this point, this judgment is only with reference to a free consenting adults. A free consenting adults predominantly for LGBTs, with the hope that LGBTs will have a cohabitation because their order of the physical and mental attitude. So if two adults consensually had the sex, even it appears to be other society, it is against the nature of the order of the nature, but it is not against the order of the nature because it is natural for them. God has such created them. So it is not an offense they have held. Again, they have given a caution that no, it will be again an offense if it is committed against a person below the age of 18, that is minors, maybe female or male. Understood? This will be again an offense if it is committed against the minors and against the, what you call, animals. So they have given an exception to these two categories. So the essence of the judgment is an intercourse among the elders or adults though it appears to us as against the nature, but it is not an offense, because there are a third community in the world, third community in our country also. We have to respect their sentiments. Therefore, that is not an offense. But it will be an offense if it is against the minors. Whether consent is there or not is a difficult thing, because minors' consent is not consent in every legal aspects. So also in this one. And against the animals. This exception has been carved out. Now that is the gist of the judgment I have explained you. Now what happened is, the 377 has been totally removed from the statute book by the BNS. Understood? Bharatiya Nyaya Samhita has no akin provision or relative provision or similar type of provision in that code. Now you may ask me, what is the, what if it is not there? Because Supreme Court has already held 377 is against the Article 14 or even Article 21 also. Therefore, if it is omitted from the new code, what is the wrong in it or what will be its adverse impact? But there will be an adverse impact. That has been, the legal experts have been clamoring. Now look the judgment. If it is a free consent between the two elders, it is not an offense. If it is against minors, it will be an offense. It will be against the animals, it will be an offense. Now 377 is taken away, but POCSO Act is there, it is gender neutral. Therefore, against the minor, by virtue of that enactment, POCSO law, even if 377 is not there, the offense can be booked against the perpetrator. Against the women, even 18 years more, under 375 rape, it will be a rape. Against her consent, she is an adult, but it is committed against her will, so law protects her interest. Okay? Now the only section left out is a male person who is an adult, against his interest, suppose an illegal and unnatural offense is committed, how he is protected is the question. Because 377 is removed, there is no akin provision has been introduced in this, what you call, BNS. The vulnerable section is a male aged above 18 years, an adult male, against him an offense is perpetrated of this nature against his consent or will. What is the legal remedy for him? You have to think of yourselves, isn't it? If you find any solution for it, well and good. I have verified, but I couldn't get any it. So that is why legal experts are now clamoring. The law is now lopsided in this regard. Total removal of 377, even though Supreme Court has carved out certain exceptions, those exceptions should have been put in a new section in a different format, but that is not there. Totally 377 has been removed, which may be a, what you call, create a unhealthy situations in the society in the coming years. Please read it. We are only discussing as an academic point of view. We don't know what type of interpretations will be given by different high courts and Supreme Court in future. But as the law stands today, we are only discussing. Please understand. I hope you understood this controversial aspect, 377, which has been removed totally. Then another important aspect is BNS. Of course, this is slide 13 and 13, slide 13 and 13. Next slide. There are section 33 offenses, offensive sections, enhanced punishment is given. Okay? Previously, these 33 sections in a different mode, they are there in the IPC also. They have been now incorporated in another manner in another sections, but they are there. The only difference is all these 33 sections, enhanced punishment is prescribed. That we have to carefully observe. no enhanced punishment is provided for. It's only for information sake I'm telling. Next slide, 13E. Hit and run. I was discussing some time back. Hit and run cases were not, there was not a specific offense for it. Now, hit and run was made as an offense. Suppose if a driver hits a person on the way without stopping it and without reporting it to the police, he escapes it. Tomorrow if he is found out, he will be booked under 106(2). What this section tells us, I will, whoever causes death of any person by rash and negligent driving of the vehicle, not amounting to culpable homicide, and escapes without reporting to the police, this is most important phrase, escapes without reporting it to the police officer or a magistrate soon after the incident, shall be punished with imprisonment of either description for a term which may extend to 10 years. Very serious offense it has made as 10 years, and shall also be liable to fine. So if a person on the way hits and goes away, in future if he is found out and he is booked for an offense, he will have to undergo 10 years of imprisonment, up to 10 years. But this provision, as I already told, section 1, if you have BNS, section 1 says that the code will come into force as the central government notifies. Central government notification has been given, and with effect from 1/7/2024, the entire code comes into operation except this provision. 106 subsection 2 will not come into unless another notification is given. Why this is? Why this is it appears transport companies have given a representation. It is only my information, you can find out. A representation that under the umbrella of 106(2), tomorrow the transport operators also may be added as co-accused. Of course, the section is not that much clear, it only tells about the driver. But the transport operator may know that his driver committed an offense. He too keeps silence generally. Oh, you have escaped, don't tell anybody, keep silent. He will advise in normal course. Therefore, tomorrow, whether the driver informs to his master or not, there is a tendency of police booking a case against not only the driver, but also his owner of the vehicle. In sometimes the owner might not be knowing that his driver committed the offense. He was not an active abettor of the offense, but there is a tendency, they felt it. Therefore, the central legislation, it seems they are reviewing this part of this provision, whether to keep it or whether to bring it into operation or to modify it or what to do. It is now we have to wait and see. But as of now, 106(2) is an offense pronouncing that a hit and run case, a driver will be booked for this offense. Please take note of it. Another important aspect. Punishment. An accused is undergoing a life imprisonment. He has committed a murder. He is undergoing life imprisonment. Already undergoing life imprisonment. That life imprisonment, the life convict we will call him, that life convict has committed another murder in the jail, or while he was in the parole, he committed another murder. So what is the at best punishment that can be given to him is a life convict. If he commits a murder, the only punishment under section 303 was to give a death penalty. Is not it? But in 1983, a judgment has been pronounced by the Supreme Court. For your understanding, please note down Mittu versus State of Punjab. Very interesting point was raised. Mittu versus State of Punjab, 1983, 2 SCC, page 277. Next slide, 14A. This is the judgment, wherein the Supreme Court has observed, taken a cue from a very prominent, very renowned judgment. What is it? Bachan Singh versus State of Punjab, isn't it? if for a capital punishment, for a life imprisonment or a capital punishment for 302, life punishment is the order and capital punishment is an exception only in the cases of rarest of the rare, isn't it? Rarest of the rare phraseology was introduced only with the Bachan Singh versus State of Punjab in the 1980 or 81, the decision. Then applying the rarest of the rare principle to a life convict who committed murder, the punishment under 303 was only death. There is no other alternative. So where is the question of employing the rarest of the rare theory over there? There is only one punishment, that is death penalty. The Supreme Court in this judgment held that without giving an alternative scope, without giving a scope for punishing that offender with an alternative punishment, only prescribing one punishment, that is death penalty, is against the Constitution. This is what they felt, that the rarest of the rare theory pronounced in the Bachan Singh cannot be employed in case of 303 because the judge has no other alternative except to impose it is a mandate is he has to be imposed with death penalty. This should not be. Therefore, they held that this 303 is ultra virus to the Constitution. Okay, so this, but it was continuing our statute book. Recently, what happened is in the present BNS, this provision has been taken away. Okay, but in another form it is introduced. That you have to please keep in mind. Section 104 of BNS has been introduced. Next. 104 has been 104, please note down. BNS has introduced section 104 saying that if a life convict has committed a murder, instead of imposing only death penalty, an alternative punishment is also prescribed. What is the alternative punishment? Is death or life throughout the natural part of the life. That is how they have introduced death or life imprisonment for the rest of his natural life. Why this rest of the natural life? Why? Because we have a provision in this CRPC 431, 432, etc. The government, after rendering a certain years of punishment, can extend the, what you call, he has to, remission can be given. For example, if a life convict serving for 14 years, the government may consider his good conduct, may extend remission. But that remission should not be applicable to this man. Who is this? A life convict who committed murder. So, alternative punishment is a death or life throughout the natural part of his life. That is how now alternative punishment is available to the judge to impose. That is how they remediate the situation. So, in the realm of section 303, concisely telling, by virtue of the judgment in Mithu's case, now a new provision has been introduced in the form of section 104 in BNS, stating that in such situation, death or life imprisonment, which means life for the rest of the natural life of the accused or convict. This is what the importance of this 104. Then the next important provision is 497. Okay, section 497 was the offense of adultery. Okay, adultery was an offense for which only a man could be punished, and it was previously held as intra vires to the Constitution. But later, in the judgment, Joseph Saini versus Union of India, Joseph Saini versus Union of India, 2019 3 SEC, page 39, it was felt by the apex court that it was a discrimination. Only male could be punished, though adultery is committed by both male and female. It is a gender-oriented one. Therefore, it violates the Article 14 and other provisions of the Constitution. Therefore, they struck down 497. Now the thing is that but they held that if it is an adultery is committed, it can be a ground under civil law for a concerned spouse to obtain divorce or other related reliefs. But it cannot be made as a criminal offense. Understood? In a consensual parties or both, adultery cannot be made as an offense, criminal offense, but it can be a ground for the concerned spouse, wife or husband, to obtain divorce or other related reliefs in a civil law, but not under criminal law. This is the essence of judgment in Joseph Shining. 497 was taken. 497 till recently it was there in the statute book, but by virtue of this Supreme Court judgment, it is not being implemented. No punishment could be given. Now what happens is, in this one, in the BNS, 497 is totally taken away. 497 is no more prescribed even in a different mode or different format. So 497 we can call it a totally deleted provision from the BNS. So friends, these are some of the important provisions. And one more thing, the operability of operative sphere of BNS. That also I have to tell you. The operative sphere is such that it is essentially a penal law, isn't it? A penal laws always should be operated prospectively because they can't be operated retrospectively. This has been made clear. No one need to be worried. From the date of coming into operation of this enactment or code or Samhita 17/2024, any offense has been committed, from that day only the new law will come into force. All the actions taken, prosecutions launched, investigations were under the way as per the old code, they will continue. They will not be affected because we have the provision ex post facto law. There can't be any ex post facto law punishing a person with a retroactivity, retrooperability. That is not there in it. It has been enunciated in a number of judgments. One is, if for your comprehension, AR 2004, Supreme Court, page 2608. What was held is, taking a cue from Article 20, Subarticle 1 of the Constitution against ex post facto laws, held that no person shall be convicted of any offense except for violation of a law in force at the time of the commission of that act. This is most important. As on the date of commission of that act, what is the prevailing law? Under that law only he has to be tried and punished if at all his guilt is proved. This is the fundamental law of the land under Article 21. The new code BNS is also not an exception to it. To that extent, care has been taken. But the case law is AR 2004 Supreme Court, page 2608, Dayal Singh versus State of Rajasthan. Is only for your academic interest. So, this is the care that has been taken by the new code also. You will find the provision therein that the law will come into force prospectively but not retrospectively. One more section only I will tell and I will complete it. Again, attempt to commit suicide. Attempt to commit suicide hitherto was an offense. It was there, isn't it? 309. But that has been taken away from this new BNS, but put it in a different format. What is that format is? Attempt to commit offense per se is not an offense, but this attempt is made or ostensibly made by a person so as to threat or coerce another public authority. We will see sometimes a particular person going on to the rooftop, and unless this is not done, that is done by the concerned public office, he will jump from the top of it and commit suicide. We will come across these type of cases. If such type of things are committed by any person, it will be an offense, isn't it? you have a democratic way of giving a representation or protest against the public authorities, but not by way of overawing them or coercing them. This is an offense. Now it is made. I will give the relevant provision where it is made. Section 226, you can find it out. 15A. 15A. Yeah. So whoever attempts to commit suicide with the intent to compel or restrain any public servant, it is only threatening the public servants from discharging their activities, from discharging his official duty, shall be punished with simple imprisonment for a term which may extend to so and so. So this is a new provision altogether. But attempt to commit suicide is no more an offense. Simple attempt to commit suicide is no more a offense. But it is coming, or it is coming into the new statute in this format. No one can threat the public servants with the what you call threat of I will commit suicide if you do not do, or if you do it. That is not acceptable under the present BNS. So the attempted suiciders should be careful hereafter. Anything more? I have to learn from you 5 minutes. Anything you want to question me? If I have come across, I may try to share with you. Or any doubt left over so far as I discussed with you, anything left over? If I am unable to, I could not able to share with you in a proper manner, I will try to repeat, but quickly within 5 or 6 minutes. Any of you? Sir. Terrorist Act. Yes. That is there. That is there. That is there. That is why a series of provisions, though 124A has been taken away, another format has been introduced. If a person is overhaving the government or established government or sovereignty, and this UPA Act related provision is also, it has been incorporated therein. We have to see how it will be implemented. The date of commission has to be taken into 113, new one.
Yes, Your Lordship.
I don't have readily the book, if anyone. You are referring to, isn't it? Yes, terrorist acts. UPA Act.
And the police, this Swapanda police has a right to decide under which UPA Act or this new act has to be prosecuted as per the explanation for this 113. What is the necessity of this 113 if already UPA Act is there, a special act? For what purpose this is incorporated in the present procedure?
Explanation has been given, isn't it?
Yes, Your Lordship.
Is hereby declared that the offender not below the rank of superintendent of police shall decide whether to register the case under this section or under the unlawful activities UPA Act. A discretion has been given to the concerned superintendent of the police. Yes, that is what.
What is the necessity? Already a special act covers the same section. Why again in the
In the punishment, in the realm of course, I have not intensely studied this provision, whether in the punishment, mode of punishment or investigate to be done by a particular level of office, is there any difference between these two provisions? No. In the matter of providing punishment under this section and UPA Act, is there any difference?
No, Your Lordship.
No.
And this one and the 124 is amended and 152 is there, Your Lordship.
That is there.
That is sedition plus.
Not
removal of sedition.
124A is not a sedition plus, we may straight away call it.
152.
Wording is quite different.
Yeah. Even excites. Even excites, that's an offense. If I gave a speech exciting the people, that is also an offense. And imprisonment is life imprisonment.
let us study and see it. So far as we have not come across, but the explanation provides that a discretion has been given to the superintendent of police, whether to go with that one or this one, whether to register the case under this section or under unlawful activities, PO Act. Let us read it. Thank you. Any other? Okay. Thanking you all.
Hello, sir. Actually, this is attempt to commit suicide. Attempt to commit suicide. Actually, public place and all, it is reflected. What about abatement to commit suicide? Abatement to commit suicide. Sir, one more is 377. We have it was taken away by BNS. In that also, sir, this POCSO is conflicting, sir. Actually, 18 years age, committing 18 years against a woman, it is attacks POCSO. POCSO Act 2012. So it will be recorded as this one or that one, sir. Actually, 377 here, 370 unnatural offences. They have attracted, no, sir. Here, 377 taken. POCSO Act, the two acts are there, sir. It is conflicting.
Special Act always prevails.
Sir.
Offense is there, it is there, isn't it?
Yes, sir. Actually, the POCSO is there, very serious. This thing, Section 6 and all.
Where, one question, where you found any controversy between the two provisions? Will you please explain?
Not controversial, sir. Actually, here, 18 years, under 18 years age, if a person commits some offense, it attracts. There, it is a very serious act, which is POCSO, 2012 Act, which prevails.
For that, I may give you a cue, isn't it? You have to read the General Clauses Act. There is another enactment called as General Clauses Act. If a particular act means not act means charya or panchase, falls as an offense within the definition of the two enactments, he can be liable to be prosecuted under both the enactments also. But in imposing the punishment, the court may take into consideration. That is how the General Clauses Act reads. So the same act, now the Land Council was also explaining, of course there is some provision explanation is created there. But generally, sometimes what happens is, the same act will be defined as an offense in one provision of another one enactment. Sometimes it so defines in another enactment also it is a offense. In such a case, General Clauses Act comes into the place saying that I cannot readily tell which provision that is. For your comprehension, you can read it. If that is the case, if his act falls within the definition of both the enactments, he can be prosecuted under the two enactments also, but only while punishment is imposed, the court can take into account those situations. That is how it is. Now your question is, it is already there in the POCSO. Why in 377 or 376 it should be?
Yes,
we can't question the wisdom of the legislature. We can't question the wisdom of legislature. This is not the isolated instance. There are other instances also. There. For example, till recently, IPC contains a bribery also, some 161 to 165 or so. It is a special enactment was provided under PC Act, Prevention of Corruption Act. It can be an offense under both the enactments. There are few such instances. We can't question the wisdom of the legislatures. That is, we have to cope up with both. That is. Please, for your comprehension, you can study General Clauses Act. There are two General Clauses Act. One is AP General Clauses Act, Central General Clauses Act. Both you can read. You will get some comprehension over the issue. Okay.
Thank you.
overview of the interpretation of this particular Bharati Samhita. I hope so you all enriched by the Honorable Justice interpretation of this particular law. I request all of you to give a big ovation to our chief guest. Thank you, sir, for enrichment of the entire advocate community who has come from all over the Andhra Pradesh, all corners of the Andhra Pradesh. Now I request Nagareddy Garu and other Bar Council members, all members of the Bar Council to come over to the dais and felicitate the chief guest. Please. V.R. Reddy Garu, Chandrasekhar Reddy Garu, Rajendra Prasad, Subbarao Garu, Srinivasarao Garu, and Brahma Reddy, and Narsingh Rao, and also my colleague Chidambaram, and also Krishna Mohan, and the Ram Rao, including myself. I request all the participants to be here itself. There is one more speaker.
I request everyone to be seated in their places. I repeat, Uncle Atalpera. I request all the advocates to be seated in their places. I repeat, all the advocates to be please seated in their places. I repeat, I request all the advocates and all the participants to be seated in their places. We have a very important guest who needs to address the gallery. I request everyone to be seated in their places. Please kindly cooperate. Sri Akula Venkata Seshasai Garu, born in an agriculture and freedom fighters family and developed practice within a short span of time and extensively dealt with number of cases covering all the branches of law. He was an advocate for the state of Andhra Pradesh in the suit pertaining to Polavaram project instituted by the state of Orissa by Honorable Supreme Court and was standing counsel for Municipal Corporation of Hyderabad and was panel advocate for Bar Council and appointed as judge of the High Court of Judicature at Hyderabad for the state of Telangana and the state of Andhra Pradesh in the year 2014. I request the guest of honor, Honorable Sri Justice A.V. Seshasai Garu, former judge of High Court of Andhra Pradesh, to come to the dais and adore the chair. I request Sri Y. Nagireddy Garu, Member Bar Council, to present a bouquet to His Lordship.
Honorable Justice Akul Venkatesha Garu now will present an interpretation of particularly the Civil Procedure Code with special reference to execution of degrees and orders. Sir, it is your place.
We are now traveling from non-vegetarian IPC to vegetarian executions. President of this wonderful event, the respected chairperson, Andhra Pradesh State Bar Council, Sri Dwarakanath Reddy Garu, former chairperson, Sri Ganta Ramarao Garu, Vice Chairman, Sri Krishna Mohan Garu, members of the Bar Council, President, AP High Court Advocates Association and Learned Senior Counsel Sri Chidambaram Garu, Dear advocate friends, my heartful pranams to one and all. At the outset, for organizing the event of this magnitude, Andhra Pradesh Bar Council deserves lots and lots of appreciation. I am also fortunate enough to be an integral part of this great program. It's a known reality, and I have no hesitation in saying also that unless the bar is competent, vibrant, good and dynamic, we cannot expect good judges also in the system. Basically, this program is intended for the purpose of interaction and introspection. These two things are highly essential in our system. All of you know that the only thing that multiplies on sharing is the knowledge, which can never be stolen also. The laudable and primary object, rather motto of this event is give what you have. Give what you have and take what you want. This is the motto of the program. Today, I have been called upon to interact with you on the subject execution of decrees and orders. Let us start this wonderful program or session by offering our salutations to great sons of this soil, two great sons of this soil. One is Jatipita Mahatma Gandhi ji, and other Bharat Ratna Sri B.R. Ambedkar. Before actually going into the topic, we should know the meaning of certain phrases also. What are those phrases? Judgment. What is meant by judgment? What is meant by decree? And what is meant by order? These three things we should know first of all. First of all, let us take the judgment. What is meant by judgment? Is it defined anywhere from the learned young advocates? Is it defined anywhere? The term judgment, is it defined? Please interact, sir. Be bold enough. You are learned advocates, you are dynamic advocates, I know that. Telugus are basically brave people. Yes, sir. Yes, Amma. Please, what is meant by judgment according to you? Bit louder, Amma. Put it closer.
It was interpreted in section 2, subsection 9 of CPC that judgment is a statement given on decree, reasons on
You are
decree or
coming
order.
closer, please. Statement.
Statement given on the grounds of
Ah.
a decree or order,
Ah.
and it was just interpreted enough, not defined anywhere.
It can be in a simple terms also. It means, please be seated. You are correct to that extent. Anybody else? From the young Turks? From the young Turks, anybody? Yes, Amma, please. Please, Nana. Please, please. What exactly the meaning of the judgment?
Summary of all that heard by the judge is the judgment.
Yes, sir. Yes, sir. Anybody else?
Opinion of judge.
Opinion of the judge. Yes, sir. Is it statutory opinion or personal opinion? Yes, sir. Final order of the court is also judgment. Yes, Amma, please. Formal decision by the court. Yes. You are very closer, very closer to the definition or the meaning given under subsection 9 of section 2. Yes. It means subsection 9 of section 2, according to that provision of law, it means statement given by the judge for a of the grounds for a decree or order, or statement given by the judge for a decree or order, the necessary grounds. This is called judgment. Then, in other words, in normal parlance, it means the formal and the final and end product of any case is called judgment. End product of any case is called judgment. Then decree. What is meant by decree? Is it defined anywhere? Yes, sir. Operative portion of the judgment is called decree. Then
It is a formal expression given by the judge
formal expression given by the judge.
in the
Is-
suit.
Is it illustrated is it defined anywhere under the CPC?
Yes, sir. Section
Amma?
2.
2-9 judgment, Amma. We are dealing with the decree now. So subsection 2 of section 2 takes care of this, isn't it? A formal expression of an adjudication which finally or conclusively determines the rights of the parties. Then, what about the order? Is there any definition for order under CPC? Yes, sir. Somebody is saying.
Sir, in a decree there are several orders,
Yes, sir.
but all orders are not decrees.
All orders are decrees according to you. Yes. Anybody else? Decree is not it is not a decree but an order. So what exactly the difference? Order and judgment. Order and judgment. Is there any difference between these two? Correct, sir. Yes, sir. So what is the provision of law which deals with this definition? Subsection 14 of section 2 means the formal expression of any decision of a civil court which is not a decree. Today, we are concerned with the executions. This execution, it is highly crucial and difficult task in the process of adjudication. What are the relevant provisions of law under the CPC? Substantive provisions of law under the CPC which deal with the execution. Substantive provisions I am asking. 36 to 74.
Sir, 74.
Yes, somebody is saying, sir. 36 to
74.
74. These are substantive provisions of law. Then where is the procedure prescribed? Order?
21.
Order 21 takes care of the procedure for enforcement of the decrees. Most of the litigation revolves around this execution only. All of you know the well-known saying, as observed by the Privy Council a century back. Would anybody say that? There was some opinion expressed by the Privy Council during British regime about the execution. Privy Council said a century back. Yes, sir. Somebody is saying something, sir. Please. Code in a code. Yes. Anybody else? Yes, Amma? Yes, to some extent you are correct. Yes. Anybody? What exactly the Privy Council said? Privy Council said the woes or difficulties of a decree holder start from the date of decree. Start from the date of decree. ఎన్ని తెప్పలు పెట్టాలో అన్ని తెప్పలు పెడతారండి ఈ టైంలో. ఎన్ని తెప్పలు పడాలో అన్ని తెప్పలు పడతారు, అన్ని కష్టాలు పడతారు డిగ్రీ హోల్డర్స్. కాబట్టి ఎగ్జిక్యూషన్ అనే విషయం మీద మనకి పూర్తి అవగాహన ఉంటే చాలా కష్టాలను మన క్లయింట్స్కి తప్పించవచ్చు. దెన్ వాట్ ఈజ్ మెంట్ బై ఎగ్జిక్యూషన్? ఈజ్ ఇట్ డిఫైన్డ్ ఎనీవేర్? వాట్ ఈజ్ మెంట్ బై ఎగ్జిక్యూషన్? ఈజ్ ఇట్ డిఫైన్డ్ ఎనీవేర్? Yes, sir, please. Please interact, sir.
Implementation of decree by the
Implementation of decree.
court. By the court.
By the court. Yes, sir.
Through the garnishee order, attachment before
Yes, sir.
judgment,
There are all modes.
attachment after the judgment,
Yes, sir. Yes, sir. Somebody is saying from that.
seizure and arrest.
Enforcement of decree or giving effect to a decree or order of the court. That is called execution.
Execution.
Then when can we say that the execution is complete? When can we say that the execution is complete?
The judgment holder should be satisfied.
Yes, sir, he is correct.
Decree holder.
Yes, sir. When can we say that the execution is complete? I know you are hungry. When the decree holder gets satisfied in terms of the decree, or the decree holder gets the fruits of the decree completely, then only we can say that the execution is complete. Then, my doubt is, you know the difference between judgment and decree now, judgment and order. Am I correct? Then, whether the procedure stipulated under order 21 of the CPC is applicable for enforcement of orders also, you may get a doubt. Is it applicable or not?
Yes, sir, because appealable orders are there.
Is it applicable? Is there any provision which takes care of that? What is the provision? Section 36. According to section 36, all the provisions of order 21, they are mutatis mutandis. they are applicable to enforcement of the or execution of the orders also. Then who are the persons who can file EPs? Who are the persons who can file EPs?
Judgment holder can file the EP petition before the court.
Decree holder can file. Yes, Amma. Inka? Legal heirs also can file. Agents. Then
Co-accused.
co-accused. You are still a non-vegetarian, sir. Lunch time. Huh?
Co-petitioner.
Order 21 Rule 10 is the provision relevant. Order 21 Rule 10. Decree holder, LRs of decree holder, if decree holder dies,
Agent.
representative of the decree holder, any person claiming under the decree holder, transferee or assignee of the decree holder, one or more of the joint decree holders. These are various categories. Then who cannot apply for execution? Who cannot apply for execution at all? Who cannot apply? Yes, sir. Both the parties, they cannot apply. You cannot, sir. Not can. Who cannot apply for execution? A person who is neither a decree holder nor has a right to execute a decree. Supposing a receiver is appointed in a given case, he dies. He dies pending proceedings. Can his legal heirs come on record? A receiver is appointed. No, they can't come on record. Then against whom EP is maintainable? Judgment debtor, LRs of judgment debtor, to the extent of the property in the hands of judgment debtor, then sureties of the judgment debtors. Then another issue is, what are the provisions of law which deal with the transfer of decree and powers of the transferee and transferor courts? What are the provisions under the CPC? Emma? Section? 39, 42, and 46. Supposing a decree is made and the judgment debtors, they reside at a place outside the jurisdiction of the court which passed the decree, and property is also located outside the jurisdiction of the court. Now the issue is whether that court has jurisdiction to execute the decree. Can it? Yes, sir? Transfer of decree can be sought. Then, anybody else? Anybody else, sir? Precept. You are correct, sir. Decree the court executing can entertain, but it has to transfer it in view of introduction of subsection 4 of section 39 of the CPC. That came into being when? Outside the jurisdiction of the court. Then this decree has to be sent. Transferee court. That is called transferee court. ఏ ప్రాపర్టీ అయితే మనం అటాచ్ చేయాలనుకున్నామో అది డిక్రెట్ల కోర్టు పరిధి జ్యూరిడిక్షన్లో లేదనుకోండి, ఏ కోర్టు పరిధిలో ఆ ప్రాపర్టీ ఉందో ఆ కోర్టుకి ట్రాన్స్ఫర్ అడగాలి. ఇది సమ్ అండ్ సబ్స్టెన్స్. Another doubt you may entertain is, all of you know the principle of res judicata. All of you know the principle of res judicata. What is meant by principle of res judicata? Section 11 of CPC deals with that. What does it say? What is the object behind that? Amma?
Res judicata means already decided case should not be filed in another competent court.
What is the object behind that?
One should not be.
One should not be.
One suit, one dispute, one resolution.
You are correct, Amma.
Ex capicio.
You are correct.
Res judicata ex capicio.
Correct, sir. In precise terms, that is the object behind that. No person should be vexed twice for the same cause of action.
It is the interest of the state.
So, but there is a provision under the CPC which deals with the situation. That is explanation 7 to section 11 of CPC.
Res judicata.
As per this provision of law, res judicata principle is applicable for EP proceedings also, subject to the condition that the earlier application must have been heard and decided finally. If it is dismissed for default, is there any embargo on filing the second application? Yes, sir. No. If we decide on merits, then only the problem crops up. అంటే ఈపీ మెరిట్స్ మీద డిసైడ్ అయితే రెండో అప్లికేషన్ వేయడానికి లేదు. Then, is there any provision under CPC, especially under Order 21, which empowers the execution court to stay the execution of the decree? Normal rule is EP court cannot go beyond the decree, isn't it? And there you are correct. We cannot go beyond the decree. But there is an exception, a slight deviation from that. What is that provision of law which deals with the situation? Under two circumstances, EP court can entertain an application for stay of execution. What are those conditions? And what is the provision of law which deals with that?
151 section.
151?
Section, CPC.
151, section 151 of CPC, Jinda Tilisma. Right, sir?
Right.
Then, any other provision? You are coming nearer, sir. You are coming nearer. Then reverse change, sir, 29. 9 reverse change.
9 to 2.
Dan reverse
62.
kadandi. 9 reverse change.
9 reverse.
Order 21 rule 26. దేని ఇప్పుడు పరిస్థితుల్లో ఆర్డర్ 9 రూల్ 13 అప్లికేషన్ వేయడానికి అపలేట్ కోర్టుకు వెళ్ళడానికి ఫర్ ఎ రీజనబుల్ పీరియడ్ ఎగ్జిక్యూటింగ్ కోర్ట్ కెన్ గ్రాంట్ స్టే ఆఫ్ ఎగ్జిక్యూషన్ ఆఫ్ డిగ్రీ. Then all of you know the various modes of execution. 2130 for recovery of money. This is by detention in civil prison or by attachment or sale of property. Movable property are the 21 rule 31. Seizure of movables by delivery, by detention in civil prison. Then restitution of conjugal rights by detention, attachment of property. Immovable property are the 21 rule 35 by delivery, by removing any person bound by the decree from the property. Then another crucial aspect is one of the modes of execution is by arrest and detention. Is by arrest and detention. This involves personal liberty. Courts are required to be very, very cautious while exercising this jurisdiction, since it offends Article 21 of the Constitution, a fundamental right guaranteed under Chapter 3 of the Constitution. The leading case on this is Jolly George case, all of you know. Jolly George case is the leading case. AR 1984 Supreme Court, 1984 Supreme Court 477. This is the leading case on that. Sir, very often you come across a term garnishee. Somebody was also telling.
Yes, sir, garnishee order.
Yes, sir, you said, sir. What is meant by garnishee? Would anybody enlighten this August House? Debtor of?
Debtors, debtor.
Debtors, debtor.
That is correct word.
Yes, sir. Debtors, debtor. Judgment, debtor of a judgment debtor, with whom the money of JDR is available. For example, bank accounts, other things. What is the jurisdiction of the court under this provision of law? What is the power of the court under this provision of law? EP court can direct the garnishee to withhold the amount and to send the same to the EP court. Supposing garnishee does not respond, what is to be done? Garnishee does not respond at all. He doesn't. Yes, Amma? Show cause notice. Despite the show cause notice, garnishee does not respond at all. What is the remedy for the aggrieved?
It is a bank seizes the account.
He stands on the same pedestal as JDR. What are the steps available against JDR? They are equally applicable for the garnishee also. Then another crucial provision of law which you come across daily is section 60 of the CPC. What is this section? What is the significance of this section? Would anybody tell? Yes. Yes, sir, from that corner. Yes, sir, you are saying something, sir. Please, sir, use the mic.
Garnishee salary attachment చేయొచ్చు.
Section 60.
60.
Items which are attachable and which are not attachable. Section 60 deals with that. Then another issue is, for how much period attachment of salary can be effected? "24 months only. Thereafter, what is the remedy? Supposing decree is not completely satisfied, what is the remedy? Emma? Maximum period for enforcement of one decree, it is 24 months. Beyond that, you can't. Then what is the remedy open for the decree holder? Same decree I am telling you. Same decree, it can't exceed 24 months. Other modes are available. If property is available, immovable property, decree holder can certainly proceed against the JDR. Then other thing is whether gratuity amount payable to a retired employee
No, sir, no, sir.
can be attached.
No, sir.
No.
No.
Why?
It is not attachable.
Why, sir? What is the reason? Is there any provision under any statute?
Though there may not be a provision for it, but it is paid out of gratitude. Gratitude by the government towards the servant, public servant.
So any amount paid out of compassion,
A gratitude cannot be denied. A gratitude cannot be denied. That's what I feel.
Very good, sir. Any other person, any other learned advocate? Is there any provision of law which precludes or prohibits a decree holder from attaching the gratuity?
Section 60 of CPC,
Ah.
which property cannot be attached. Under that, the gratuity, military services, pensions, exceptions are there, sir.
Apart from section 60, is there any other provision of law or statute which prohibits the
Gratuity.
attachment of gratuity. Amma? Gratuity, Amma. Payment of Gratuity Act. You are correct, sir. Then, to what extent salary can be attached is another question. To what extent salary can be attached?
According to minimum wages set. Minimum wages set.
1,000 plus? There is one exception to that. What is that exception? First 1,000 andi, tarvata 2/3, they can't be attached. They are completely exempted. Then there is one exception to this. What is that? For enforcement of a maintenance decree, this prohibition may not apply. Is not applicable at all. Then what is meant by salary? Is it gross salary or net salary? Gross salary or net salary?
Net salary.
Is it defined?
Yes, sir. In elections.
60 says gross salary only, excluding the exemptions under this, section 60. Then while dealing with these provisions of 21, certain doubts also may crop up, which are crucial. We should know the periods of limitation also for enforcement of various types of decrees. For execution of a decree, other than a decree for mandatory injunction, what is the limitation time? For execution of a decree, other than a mandatory injunction decree, 12 years, you are correct. What about the mandatory injunction decree? Yes, 3 years. Then partition suit? No limitation for partition suit at all. Very good. Yes. Any other? Any other learned advocate? For partition suit, what is the limitation for enforcement of the decree? Is it date of preliminary decree or from the date of final decree?
Final decree, sir. From the date
Correct.
of final decree.
Correct, sir. You are correct. Then, what is the maximum period of limited detention which can be ordered by the EP court?
6 months, sir. 3 months, sir. Detention.
There is slight distinction, sir. You are correct up to some extent. 3 months if amount exceeds 5,000. Then not exceeding 6 weeks if amount exceeds 2,000 but does not exceed 5,000. Below 2,000, detention is permissible. Not permissible. You are correct. Then, we should also know the limitation for filing application to set aside the sale. What is the limitation for filing an application to set aside the sale under Order 21 Rule 90? 60 days. Correct. You are correct. Then what are the circumstances under which an application to set aside the sale can be filed? Application to set aside the sale can be filed under what circumstances? Yes, anybody? That is one aspect. Then, yes, when third party has a right, there is one more provision, 2158. Kadama? Supposing JDR is aggrieved by the process of sale, what are the circumstances under which this application can be filed? When there is material irregularity, and fraud in publishing or conducting the sale. Another doubt of mine is whether the decree holder is entitled to participate in the sale. Decree holder, can he participate in the sale?
No, no.
Yes, sir?
No, sir.
No. One says no. He cannot at all. He is completely prohibited. With the permission of the court, under Order 21 Rule 72. 72, sir. Supposing in a given case, maintenance is granted. Maintenance is granted. And in execution, husband is sent to prison. Now the issue is whether it completely absolves the husband from the liability. Supposing he undergoes the punishment and comes out,
No, no, no.
then what is the remedy? Other remedies?
Attachment of the
Yes,
property belongs to
it
judgment
does
debtor.
not completely absolve the judgment debtor husband. Then, in a money decree, which is a joint and several decree, very often you come across this.
Yes, sir.
Whether decree holder can proceed against the sureties or guarantors, leaving the principal borrower. Can he proceed against the sureties?
Yes, sir, you can proceed.
No. According to you, no, he cannot. Unless the principal borrower is also added as a party to the EP proceedings. EP is not maintainable, according to you. Emma? You are correct. Yes. Anybody else? There is one provision under the Contract Act. Yes, sir, you are saying. Then, unless there is a contract contrary to, there is one provision under the Indian Contract Act. According to section 128 of the Code of this Indian Contract Act, liability of the surety is coextensive and immediate. So you may kindly note down these judgments. AR 1969, AR 1969, Supreme Court 297, 297, AR 1992, Supreme Court 1742, 1742, then 2014, 4 Andhra Law Times 163. In execution proceedings, it's a money decree. Supposing judgment debtor is residing outside the jurisdiction of the court, we pass the decree. Then an application is moved by the decree holder. EP is filed by way of attachment of salary of the JDR. Can this court execute the decree? Not the property, Amma. Salary attachment. If it is by way of salary attachment, can it be executed by the court which passed the decree, though the JDR resides outside the jurisdiction? Yes, sir, you are correct. There is one judgment of warrant can be sent to the disbursing officer. 2008, 2008, 5th volume, Andhra Law Times 17. Of course, following the Honorable Supreme Court judgment, AR 2005, AR 2005 Supreme Court 3353.
Trying and disposing officer can do it.
Yes, sir, you are correct. My yet another doubt is, pursuant to a money decree, EP is filed for recovery of 1 lakh rupees. Now the issue is, by way of attachment of a property worth 10 lakhs. Can this property be put to sale? Entire property? Entire property, can it be sold in execution for recovery of 1 lakh of rupees? What is that provision of law which deals with that? Order 21 rule 64. Supposing in a given case, property is indivisible, what is to be done?
Should
Proper-
be sold out. It should be sold
So
out, sir.
entire property can be sold. Another situation is a suit for perpetual injunction. It ended in dismissal. Matter was carried in appeal to the appellate court, first appellate court. Appeal was allowed, ultimately decreeing the suit. Then, after dismissal of suit and pending appeal before the first appellate court, certain constructions were made by the judgment debtor or the defendant. Then EP was filed in that case for removal of those constructions made pending proceedings. An objection was raised by the JDR saying that it is inexecutable because there is no decree at all for mandatory injunction. Is that objection sustainable? Or these constructions can be removed? Can be removed. Then please kindly make a note of this judgment, sir. 2132 Rule 32, 2019, third volume, Andhra Legal Decisions, 587 and AER 1996 Supreme Court 780. Then another crucial aspect is, all of you know the claim petitions. What is the provision of law which deals with the claim applications? Order 21, rule claim petitions by a third party. 58, sir. 21. Then supposing a claim application is decided in one way or the other by the court, EP court, then what is the remedy for the aggrieved? Is it a revisable order or an appealable order? This appealable order, court said regular appeal lies, but not the revision or the CMA. Another thing is, after passing a decree, if a new court is established, then where the EP is to be filed. After passing decree, new court is established somewhere covering a particular area where the property is located. Yes, you are correct. You are correct, sir. AR 1984, Allahabad 169. Finally, we should not forget one thing. In the name of mere technicalities, there should not be any dismissal of EPs. And the decree holders should get the fruits of the decree, and the primary duty of the courts is to ensure that the decree is executed finally, completely. Then I would like to conclude this session with the words of great sage Swami Vivekananda, which may be relevant also. He said, I quote, లక్ష్యం కోసం అలుపెరుగక శ్రమిస్తుంటే నేడు కాకపోయినా రేపైనా విజయం సాధ్యమవుతుంది. జై హింద్, జై ఆంధ్రప్రదేశ్.
Thank you, sir. Honorable Justice Akul Venkateshwar Garu, for an enunciation of this particular law, which the entire advocate community who are gathered here has taken into consideration of your interpretation of this particular execution petition. Now I request all the Bar Council members to come over onto the dais and to facilitate our Honorable Chief Justice Akul Venkateshwar Garu. Hello. Dear advocates, we are now at that time we're gathering here by 3:15 p.m. Have your lunch at your place. The buses are also there. You can go in the bus. And please be here by 3:15 sharp. Thank you.
The buses are arranged right at R&D block open air theatre. I repeat, the buses are arranged right before R&D block entrance. We have 45 minutes allotted for lunch break, and I hope everyone returns back by 3 o'clock. The session starts at 3. I repeat, I request all the participants to be seated in their places. A small announcement. We request each and every one of you to turn your phones onto silent mode. I repeat, we request each and every one of you to turn on your phones onto silent mode. And also, please leave the first 2 rows for the judges. I repeat, please leave the first 2 rows of seating for the judges. I request the Honorable Sri N. Dwarkanatha Reddy Garu, the Chairman of the Bar Council of Andhra Pradesh and the President of today's function, to come to the dais and adore the chair. I request Y. Sudeshna Garu to present a bouquet to the Honorable Chairman, Sri N. Dwarkanatha Reddy Garu. A small announcement. We found a lost ID card. The name of the person is Syed Mohammed. We request Syed Mohammed to come to the dais and collect his ID card. Honorable Justice V.R.K. Krupasagar Garu, esteemed Judge of the High Court of Andhra Pradesh, epitomizes judicial brilliance and unwavering integrity. His astute legal acumen and profound dedication to upholding justice have consistently garnered respect and admiration. Renowned for his incisive judgments and steadfast commitment to fairness, Justice Sagar's contribution have significantly shaped the contours of contemporary jurisprudence. His discerning interpretation of the law and commitment to judicial propriety have fortified the legal framework. Inspiring both peers and aspiring legal minds, Justice Sagar's exemplary service continues to be a beacon of wisdom and integrity within the judiciary. I request the guest of honor, Honorable Sri Justice V.R.K. Krupasagar Garu, Judge of High Court of Andhra Pradesh, to come to the dais and adore the chair. I request Sri Subbarao Muppala Garu and Sri V. Brahma Reddy Garu, members of Bar Council, to present a bouquet to their lordship. I request Sri N. Dwarkanatha Reddy Garu, the Chairman of the Bar Council of Andhra Pradesh, to preside the program.
Hello. I request Mr. Muppala Subbarao Garu to join with us along with Justice Krupasagar. Yeah, and also Mr. Brahma Reddy Garu, and also the former public prosecutor of the state, Mr. Nagareddy Garu, to come over to the dais. I also invite our Vice Chairman, and also Ganta Ramarao Garu, Chidambaram Garu, Okay. Justice V.R.K. Krupasagar Garu is a dynamic personality. Apart from the law, he is a very able-bodied man in other languages also. I know him since a long time. Now today's he is speaking on law lives the lawyer's way, and this presentation will be a new subject. Carefully listen it, go through it, search it, and afterwards, on that point, prepare your own note. Okay? Thank you.
అందరికీ నమస్కారం. My teacher used to tell us, which I often repeat, the labels are misleading. Those who have been into the legal profession, doing cases of drugs, cases of seeds, and several other cases, should be certainly knowing that many labels are really misleading. Perhaps that applies to us also, where the organizers have complimented me in such felicitous words. Then the topic, as I understand, is a topic that is actually in a session where the lawyers are to be oriented. So it's not exactly a topic, I mean, a session where I believe that unlike in a law college for a law student, it cannot be and shall never be a session to actually tell you whether a man includes a woman, whether doing this amounts to that, and all that. So therefore, consider that what I am trying to tell, or rather share with all of you, need not necessarily be so accurate in terms of statements of law. And the topic that I have actually coined, maybe sometimes see, by looking at the cinema trailer and the way the people participating in the movie in the pre-release give so much hope to you, we call it as hype, and thereafter the so-called blockbuster remains a dumb. So therefore, while the topic that I suggested, the name that I have given to you is the law lives the lawyer's way, I actually shared it with one of my friends, and I asked him, you suggest me what I have to say under this topic. He thought that somebody else has given me the topic, so therefore he thought that okay, I have to do it. And then it seems the first three paragraphs that he shared with me were not from the intelligence, but from the artificial intelligence, and the rest of the paragraphs he has given are something that they started actually preaching. So that gave me one doubt. Should a judge actually be standing here to preach or teach a lawyer? Talking to a lawyer gives an innate satisfaction. Do you know why? Because it is the lawyer that is the only one who always speaks to us. This is one occasion that where we get an opportunity to speak to a lawyer and ask you to keep silence always, right? So therefore, it is that pleasure actually that actually prompted me to share this dais. And then, but finally, as they say, Sabha Maryada antaru chusaru. సరే ఆ సినిమా యాక్సెప్ట్ చేసిన తర్వాత దెర్ షల్ బి సమ్ వర్క్. అండ్ దెన్ ఐ థాట్ దట్ ఇట్ కుడ్ బి what you call a friendly discourse. Then I was all of a sudden informed that we are going to be framed through cameras and it will be preserved. So that is one occasion where I was telling the lawyer who spent time with me that when he said that ఇదంతా కూడా వీడియోగ్రాఫ్ చేస్తారు సార్, దాచెట్టు పెడతారు, అందరూ కూడా తర్వాత చూడొచ్చని. Then there was some shiver. But anyhow, having come here, it has to be done, and therefore I will do it. I am a judicial officer. I am a law college student. I got my employment into a bank. I cleared my UPSSC. In all these occupations, there is some system where your knowledge would be so molded that the knowledge would be translated into some skill, a skill that would be useful and adequate for discharging his duties. When it comes to a lawyer, we don't have any formal academy or institution, and it ends, whatever training that is there is that ends normally with the law college, and then lawyer has to live on his own. So it is that loneliness that actually keeps some trouble for any new entrant into the profession. And who is to tell what? Now he is out of the law college, he can't have access to a book, he can't have access to a teacher. Now he has got only competing lawyers who could be generous, who could be treacherous, they could be anything. So it is that kind of profession where one has to really thrive. And when you are in your struggle, evolving as a growth soul requires a lot of components. My endeavor here is only to just to touch, give a glance, allow you to have a little introspection, and then proceed further. It is only with that idea, it is neither a teaching nor a preaching that I have prepared for myself. Only a few topics, only a few things, and all these things are known to all of you. It is not as though that I for the first time solemnly declare that these are very important. No, all that is known to all of us. It is this assumption that all that is available is known to all of us is what everybody says. Law presumes that everybody knows law. And the fallout of that principle is liberalized legal education. Therefore, unlike a doctor being trained, unlike an engineer being trained, a lawyer is being trained without much inputs that are required for a lawyer. Because everybody the law says that law is known to everybody. Then for me to study law, perhaps, is only a rigmarole. Then the question is, why is it that there is a law college and now there is a law student, a teacher and a lawyer, then becomes then there is a judge? They say, though everybody is presumed to know law, it is only law that is known, but not the niceties of the law. Therefore, you require somebody who spends his life in finding out those niceties in law. You have got the Advocates Act, you have got the advocate's profession. One thing that where you have only monopoly. I am a doctor, I am an engineer, I can't practice. And I am a lawyer, I alone can practice. Not anybody else can practice. So this monopoly that is given to us, it is that monopoly profession where we are now trying to find our foothold. As a matter of introduction, I suggest to you that all of you must be practicing law for quite a while. Today, all of a sudden God sends 1,000 clients. Each holds one brief and they stand up in front of your house asking your advice. Now conceive for a while 1,000 people queuing up. Then tell me, each one brings a different type of subject. One brings a pronote, another brings a mortgage, another brings a crime of murder, another brings a copyright, another brings a design. These are all the kind of varied type of cases. Once you start actually preparing your files, you will have to travel to several places perhaps in terms of jurisdictions. And you will have to write dozens, hundreds and thousands of pages. How do you believe, how do you think the life would be? One lawyer, 1,000 clients. Don't you think that is too much? Everybody is now asking, "Sir, Toraga sir," right? అరే ఈ ఎగ్జాంపుల్ సరదాగానే ఉంది సార్, బయట కూర్చుంటే మాకు ప్రాక్టీస్ అలా రావట్లేదు యాక్చువల్గా అన్నది. దెన్ హౌ డు వీ రియల్లీ గ్రాస్ప్ ద థింగ్స్? అంటే సార్ ఎవరికి ప్రాబ్లమ్స్ లేవన్నా సార్ ఎవరు లాయర్ దగ్గరికి రావట్లేదు. అదేంటి సార్ దేశంలో ఎటు చూసినా ప్రాబ్లమ్సే. అరే ఎటు చూసినా ప్రాబ్లమ్స్ ఉంటే ప్రాబ్లమ్ సొల్యూషన్ నా దగ్గర ఉంటే కనుక మరి నా దగ్గరికి ఎవరు రావట్లేదు. సో దీస్ ఆర్ సమ్ ఆఫ్ ది థింగ్స్ దట్ స్టాండ్ ఎట్ కాంట్రాస్ట్. Now you have got all the developed countries 1:300, the lawyer population ratio. And you have got in India 1:1800. So, large population, large number of lawyers, and you have got lot of books written, litigious Indian. Whether Indian by nature is litigious or non-litigious, and debates have gone up. Books have been written. So 1:1800, 1,800, I said to you, 1:1000, 1,000 clients and you hold, సో ఓన్లీ 50% నేను చెప్పినట్లు. సో 1,000 బ్రీఫ్స్ మీరు ఒకసారిగా ప్లెయింట్లు, రిటర్న్ స్టేట్మెంట్లు, లేదా ఛార్జ్ షీట్లు, కంప్లైంట్స్, మరొకటో ఏమన్నా అనుకోండి, మీరు అవన్నీ తయారు చేయడానికి ఎంత మీరు వర్క్ చేయాల్సి ఉంటుంది. నో, ఆల్ దిస్ ఈజ్ ఓన్లీ టు బోల్స్టర్ అవర్ కరేజెస్. సో నెవర్ గెట్ డిసప్పాయింటెడ్. అండ్ దెన్ we have got independence long back, and so much is known to all of us as to what was there prior to independence, what happened after independence. All that is there. Now, but we are more aware of what is available today, how the life goes on. It is in this scenario how to become a successful advocate. That is one thing towards which all of us should actually now strive together. And solution is very simple. Successful life కి ఏం కావాలని ఎవరన్నా మీకు చెప్పాల్సిన అవసరం ఉంటుందా? నిజంగా మనందరికీ తెలిసిందే కదా. ఎందుకంటే మన ఎవరన్నా అడగగానే మనం చెప్తాం సక్సెస్ఫుల్ లైఫ్ అంటే ఇలా ఉండాలి. Therefore, all psychologists, one of the best classes that is awaiting, really to tell you how to mold your personality. And the next important class is how frugal you are. You could not consume your own wealth, you have to die writing a will. And these are the next classes that are actually coming up. And before that there is a prelude in the form of my class. Then, so the psychologist says, every man is ignorant until he is questioned. So he tells you a simple technique. మీరు నేను ఎదురుపడ్డాం, మీరెవరో నాకు తెలియదు, నేనెవరో మీకు తెలియదు. ఏమీ తెలియనితనం మాత్రమే ఉంది అక్కడ. ఇద్దరిలోనూ సస్పెన్స్ ఏమవుతుందో అని. నమస్తే సార్ అని నమస్తే అన్నారు. సో నమస్తే పెడితే నమస్తే మళ్ళా పెట్టాలి అన్నది ఒక జ్ఞానం ఆల్రెడీ ఉంది మనలో. అప్పటిదాకా ఉందని మనకే తెలియదు, వాడు పెడితే కానీ మనకి తెలియలా. మీ పేరెంట్ సార్, నౌ ఐ హ్యావ్ కమ్ అక్రాస్ ఎ క్వశ్చన్, Until then, I never knew that I could answer a question. I was hesitant. Do not have confidence. Now, when he asked me, sir, what is your name? I was very happy. I am able to answer a question. That's how the psychologist actually narrates and tells us, and never get disoriented. Hold your confidence. So believe in yourself is what Vivekananda says, and it is that belief which is there within every one of us. It is only about that belief I would only like to ignite a little more with whatever that I could really gather, which I believe would really help you. There is nothing that would really harm you in this. So therefore, there is a positive class that nothing harms you. At least it helps you, if at all it helps you, right? And then for everything now you require a good example. Why do we require a good example? Because weakest of the species on earth, which I always recount, is human being. They say we are the most matured species, but some gentleman says that you are the weakest of the species. He refers us to Jungle Boy. He tells you, do you have a dog? Yes. How does it behave? It behaves like a dog. It is among all the humans. He is the only one. Still it barks, wags its tail, behaves like a dog. And then you take a man, put him among dogs, then he also starts crawling on four legs, wagging his tail, barking, forgetting for a moment that he is a human. So that's what Jungle Boy story tells us. So he knows, see, what he wants to tell us is, many a time it happens in your life that you grow only by imitation. You go only by imitation. So this imitation is nothing but following the footsteps of wise and great. Following the footsteps of wise and great. So therefore, one thing that all of us, either as students or as lawyers or as judges or as good children in our home, we are always told, and as parents, we always tell everybody, read something that is good. So find out the best of the literature that is available. A good book really is the one that changes your life. This I 100% believe, my dear friends. And it is the good books that were to which we were exposed that really brought happiness to us, a lot of excitement in us to read law. Therefore, where does these good books are available and all that? Now you are in the heart of a university hosting such very big function, and you have got eminent lawyers as bar council members, and this is the right time for you to note down, to find out what are those good books. So I don't want to recite to you what is good book, because with a lawyer I should never debate. And moreover, please remember, my dear friends, one wise man said, never ask a judge and never follow the advice of a judge, because he is ill-equipped to advise you. It is a lawyer to whom you have to consult, and not a judge. So therefore, you take my word, but never ask me what is that good book, sir, because we will indulge in discussions, right, friends? And then, what is the most important quality a lawyer should possess? This was one question in legal education, and I was a student of legal education in my post-graduation of law. And about this, books have been written by great people. What is that one most important quality that would really make you a good lawyer? Each one must be holding one opinion, but this is not a place or time to count these opinions. But this information that is passed on to us from wise people, it tells interviewing, the power to interview. So you have got a lot of books written about interviewing techniques. This interviewing is not interviewing a judge, and it is to interview your client. I come to you with a lot of nonsense, and you have to bear with me with a lot of patience, and then finally you must find out what you really want. And what a lawyer wants is, what really the client really wants is what the lawyer wants to know. ఆ టస్లు చాలాసేపు పడుతుంది. కాబట్టి ఇంటర్వ్యూయింగ్ టెక్నిక్ ఈజ్ వన్ వెరీ ఇంపార్టెంట్ థింగ్, and that you must follow. Because I am among lawyers, I must tell you only a few things about importance of lawyers. And for the importance of lawyers, how do we realize our importance? Before we actually go further, may I really ask you a question? That having been enrolled as advocates, how many of you, because I also enrolled myself way back in 1986, therefore this question applies to me also, but for a matter of felicity I am just questioning you. So how many of us have really read, apart from a course in the law college, having enrolled into a profession as a member, the Advocates Act 1961? So మనలో ఎంతమంది నిజంగా అడ్వకేట్గా అయిన తర్వాత top to bottom we have read Advocates Act 1961? How many of us have tried to contribute? Say for example, I do not know of late whether the journal is being published or not, Bar Council of India's law journal or some other law journal, online or offline, whichever is the convenient mode to you. What does it mean really? I am not really talking in terms only of money, it is in terms of our aptitude only I am talking. If I don't want to contribute to a journal and look at it every day, it simply means that I don't want a companion who tells me what to do, what not to do. So therefore, we must also hold some sort of that desire to possess something valuable. If it is available, you will touch, you will grow. If it is not available, if you never thought that it is required, then that is a difficulty. Now, because it is said to be a class where even law students are sitting, and a class where even junior lawyers are sitting, I have prepared a few citations. I do not know whether it is appropriate to share any citations in that way or not, but being a class, perhaps we are required also to give you a few citations, because this is not a time and place to have a great deal of deliberation looking at all the nuances. So therefore, AR 1978, Supreme Court 1019, I will give you the journal number. The name is Harishankar Rastogi versus Giridhari Sharma. This is one judgment. So why should we actually read this judgment? This judgment is one judgment which tells with one important statement from Justice Krishna here also. See, నా గురించి నా విలువ నాకు ఎప్పుడు తెలుస్తుంది అంటే, ఇతరుల కన్నా నేను ఈ విషయంలో స్పెషల్ అన్న సంగతి నాకు ఎవరన్నా తెలియజేస్తే అప్పుడు నా విలువ నాకు తెలుస్తుంటుంది. అరే నాకు ఇంత ఇంపార్టెన్స్ ఉందా అన్నది. సో ఫర్ ఎ న్యూ ఎంట్రెంట్ ఆర్ ఏ లాయర్ హూ ఈస్ నౌ ఫీలింగ్ ఏ లిటిల్ ఫ్రస్ట్రేషన్, reading of these small things would actually help them to come out of any of such troubles. This is one case where the question has come up. See, I am a citizen, I am presumed to know law, and this gentleman who is an accused, I will come and do the case on his behalf. The question is, a non-lawyer, could he perform the duties of a lawyer? So what are the things that fall up for consideration? Should we allow, should we not allow? Who decides it? Judge decides it. What is to be decided? What is debated is what is to be decided. Who is to debate? It is a lawyer. So the lawyer's arguments in these small things, that gives us bright idea as to how to formulate an idea and all that. And this is one case where finally the Supreme Court says a private person who is not an advocate must get prior permission of the court and other things, and finally it says we can grant you permission provided we are satisfied with certain things, and halfway through while you are actually performing I can stop you, ask you to go out, and I can do that because sometimes quacks can prove fatal friends. ఈ ఫ్రెండ్కి ఏదో సహాయం చేద్దామని వచ్చావు కానీ నువ్వు యు ఆర్ నెవర్ ట్రైడ్, యూ కుడ్ నెవర్ యాక్చువల్లీ understand, appreciate the various theories that are available in law, and you believe that out of your affection, you could protect your friend. Finally, you will destroy your friend. So that is one good theory that is stated. And then from our own High Court, AP 2002, 3 law summary, 242, J. Papara versus Government of Andhra Pradesh. And this is one good judgment where you will find, see, what as a lawyer I am supposed to do, and how I am totally different from what a normal other person who performs the duties of a lawyer. And this tells us a lawyer is one who argues for his client, and more importantly, he is an officer of the court, and discharging the duty as an officer of the court, either on his own or at the intervention of the judge, he would also present all those facts and law which may stand against his own client's interest. It is that quality that a lawyer should possess. It is that quality that a lawyer should actually possess. So these are two small items that actually tells us the importance of a lawyer. Now, my dear friends, subject to correction, you are the only one who is referred in the Constitution as a profession. There are lawyers, there are doctors, there are engineers, there are so many other people. But Constitution has referred the legal profession. And you know Article 22, Clause 1 of the Constitution of India. So among so many professions that are available, it is about lawyers and lawyers' profession that finds merit and a mention in the Constitution itself. As all of us know, no person shall be denied the right to consult and to be defended by a legal practitioner of his choice. A legal practitioner of his choice. Now you have got a lot of lawyers who actually went on to litigate on the question of his choice. Jatmalani garu kavali sir, naku Nariman garu kavali sir, veeru Subbaravani Venkatraoni icharu. Now you have got reported judgments. Of course, this is not the time. So now that is another extreme where his choice అని అంటే మిమ్మల్ని లాయర్గా కనుక ఆయనకి పెడితే నాకు ఆయన కాదు సార్ వేరే కావాలని అంటే ఆయన నాకేం పని నేను రానంటే నా చాయిస్ అనేది ఫండమెంటల్ రైటు, therefore you must oblige. This debate goes on. When that goes on, it has to go on because that is the only way you actually sharpen your logic. So that is another point that you require to see. And then these lawyers, they appear for a client, and when the case is called, they disappear. And what to do? That is one difficulty. Now this appearance and disappearance, he awaits for his appearance very eagerly. The moment he gets this, he files the paper, then he disappears. Now you have got cases where a lawyer filed an application for dispensing with the presence of a client, and even without actually listening to, without even participating, he goes out, and for him court waited, the opposite lawyer waited for a long time. Finally he did not turn up, and then the judge disposed it of dismissing it. This dismissing his application had to be carried to Supreme Court also, because ఆ ఒక్కదానికి సంబంధించి రిపేర్ చేయకుండా అయినా he started indulging in lot of words that others considered very bad, and especially the judge and the other members of the bar. So 205 అప్లికేషన్ ఏదో అంటాం సిఆర్పిసిలో, అది పోయింది. ఆ క్లయింట్ ఏమయ్యాడో తెలియదు. ఈ వీటికి సంబంధించి ఇది కంటెంప్ట్ అవుతుందా లేదా ఇట్లా కేసులు జరిగిపోతూనే ఉంటుంటాయి. సో నౌ దిస్ అపియరెన్స్ అండ్ డిసపియరెన్స్, సో ఫar as the trial court is concerned, disappearance causes a lot of pain so far as criminal case is concerned. Now Parliament thought that no, such pain should not be there. Even in their absence, you must proceed. We have got the new enactments where trial in absentia and all those things are there. Now when it comes to appeals, we are just only referring to a criminal appeal. The Criminal Procedure Code provides that they invite both sides to argue, and it leaves it to their wisdom. If they believe there is nothing to be argued, they don't come. If they don't come, don't worry, you go on disposing of the case. That's how 12 people were convicted by the High Court, each for 10 years. That was done by the trial court. A matter was there in the High Court, and the judge was waiting for the lawyer who was appearing for these 12 convicts, and finally lawyer did not appear, and acting in accordance with the statute, the judge disposed of the cases. Now after it is disposed, perhaps somehow somebody questioned the lawyer, then the matter was carried to Supreme Court. Now the point here that you have to really appreciate is, apart from the procedural nuances that are available there, this is one judgment where you will also find good references as to why the lawyer's presence is demanded. Why lawyer's presence is demanded. If this lawyer who filed his appearance has not appeared before you, try to find out some other lawyer, have him as your friend, amicus curiae, and dispose of the case. So good references about the lawyer and the need for holding a lawyer, and the need, pursuing the need further, following the same virtue, that even if the lawyer who has accepted the brief has not turned up, never leave the client alone, provide him a lawyer. Now you have got 1999, 8 Supreme Court cases, 644. You have got umpteen number of citations. There is only something to just hang on today and proceed later. So this is Rishinandan Pandit versus State of Bihar. So that is one area where you will find good references about the importance of a lawyer. And then this is one citation that I would like to give to you. And this is one area where each of you, after you go back, sit with your other colleague ball members and formulate a plan of action. Now all of us say we have read Article 22, 1 of the Constitution of India, right to defend that, this, everything, that's good. Then tell me, how many of us are really prepared to do so many good things? Things, I call them as good because law says that is the thing that is to be done. So when the law commands, that is a virtuous thing, and your choice, my choice doesn't exist, it's a good thing. So it is, what is that good thing that is there? This good thing the context for this good thing is only this. There is a crime, and this crime has to be investigated into by police, and the police have got the right to call anybody as part of their investigation to know what has happened, who is responsible, etc. So an inquiry we call as the investigation. It is that investigative process that is going on. So X is called, and when the police officer asks him a question, the next question is, should he really answer or he need not answer? And whether he has to answer truthfully or he can answer anything. My name is X. The police asks me, who are you? I say A, B. I never say I am X. This happens. So, should I respond? And if I have to respond, have I to respond truthfully? ఈ సిలబస్ అంతా మనకు లేకుండా సిఆర్పిసి సెక్షన్ 161 క్లాస్ 2 సిఆర్పిసి వాటిలో చెప్పారు. Everybody who is questioned by police must answer truthfully. Then, if the gentleman is a prospective accused or that speaking something would incriminate him either in this case or in any existing case or in a case that is quite possible to come up, which he knows, though others do not know. Then Article 20, Clause 3 of the Constitution of India says, no person shall be compelled to be a witness against himself. So the right to silence, right against self-incrimination, so on and so forth. And then you also have got Section 179 IPC, where you are required to speak truthfully to a public officer, and if you do not speak, or if you do not speak the truth, that's an offense. So So these are the three important formulations of principles. They are there in the statute and the constitution. It is their combined effect that came up for consideration. This is a broad subject that you will read, you will actually perform well, and for that, so many good things are there. And now I am not actually on that point. That point is only stated for a context. And within that context, now the Supreme Court said, those who are in police custody and or those who are called up for police interrogation, they have got the right to have an advocate. They have got the right to have an advocate. One point for which the lawyer's presence is demanded is that the police are known for utilizing techniques that are considered to be rude, inhuman, barbarous. Therefore, to circumvent such reality, the law is actually hedged in such a way that you hold a lawyer so that he is there. Now the question here is, you dramatize for yourself that all of a sudden your client wants your presence, lawyer of his choice, he could call up, and you are his chosen lawyer. He asks you to come to the police station because he is going to be interrogated by police. Number one, how many of you really prepared to go? And there was a lot of statistics that were conducted, my dear friends, and it was disheartening to learn. And finally, the author has reported that respectable advocates have never chosen to go to a police station. No, a respectable client doesn't go to a police station is good. No, a respectable lawyer never expresses his willingness to go to a police station. This is where the legal stand and the moral stand that we have to evaluate. You have to evaluate. Choice of a profession, once you have taken, I intended to do my medicine, means I am prepared to spend rest of my life with sick people. I intend to become an engineer, means I am prepared that rest of my life I will work with machines, not with men. I am prepared to study law. I am prepared to carry on my shoulders all the agony the humanity carries, and virtuously I prepare for them my brief, the defense, the prosecution. And in that context, the survey was conducted and it was found no good lawyer was ever willing to go to police station, leave it aside. And then write, I am prepared to go to police station, sir, and he is my client, I feel it is my duty. Right. Police officer akkudunaru, client ekkada కూర్చున్నారు, hardcore accused, and you are his lawyer. ఇప్పుడు మీరు చేయవలసిన సలహాలు కానీ పనులు కానీ ఏమిటి? ఉత్తిగా చూడటం ఏమాటైతే వీడియోగ్రాఫ్ కూడా చేయొచ్చు. మనమే వెళ్ళి కూర్చో, ఒక లాయర్ గారే అక్కర్లా కదా. పోలీస్ అట్రాసిటీ ఆపడానికి వీడియోగ్రాఫ్ సరిపోతుంది. మరి లాయర్ గారు ఇంకెందుకు? దెన్ సమ్ బ్యూటిఫుల్ పారాగ్రాఫ్స్ in which the Supreme Court has enunciated. Time doesn't actually permit us to have a good a reading of it, listening of it and all that. So I advise my friends, see, this is small area. Why I have actually been trying to suggest, what I am trying to suggest is, as a lawyer, when I intend to perform, am I prepared, am I equipped myself with what is required for my performance? If I am not prepared, this is the occasion that I shall take, that this is the time I shall have some discourse with my friends and prepare a formula. ఏం ప్రశ్న అడిగితే మీరు అబ్జెక్ట్ చేయొచ్చు, ఏం ప్రశ్నని మీరు అబ్జెక్ట్ చేయకూడదు, మీరు అబ్జెక్ట్ చేయదలుచుకుంటే ఎలా అబ్జెక్ట్ చేయవలసి ఉంటుంది, మీరు వచ్చేలోపే ఆయన చేసేస్తే ఇంట్రాగేషన్ ఎలా, మీరు ఎంతసేపటికి రావచ్చు, నా ఇల్లు నా ఇష్టంలాగా పోలీసులు లాయర్ క్లయింట్ పిలిచిన తర్వాత వస్తాను, సినిమా హాల్లో ఉన్న 2-3 గంటల తర్వాత వస్తానంటే ఎవరన్నా ఆగవలసిన పని ఉందా? స్టాట్యూటరీ ఫంక్షనరీస్. రీజనబుల్ టైం అంటే ఏంటి, రీజనబుల్ opportunity అంటే ఏంటి, what do you mean by reasonable? What is reasonable in a given context? Would it be reasonable in another context? So these are all some of the fundamental questions that do arise. And finally, what is my knowledge on a question and answer in the context of incrimination? In the context of incrimination. So some wonderful paragraphs are there, and please go through them. And the citation is 1978, 2 Supreme Court cases, 424. So, the most celebrated case, Nandini Satpathy versus P.L. Dani. So, these are some of the few things that I would like to share. And then, a few more things for the new entrants. We wait for clients, and client comes, he tells us certain things, and then Nariman was referring. మంచి వండర్ఫుల్గా హార్స్ రేస్ జరిగింది, ప్రపంచవ్యాప్తంగా జరుగుతుంటాయి. ఒక గుర్రం గెలిచింది, దాని పేరు గోల్డ్ మెడల్ ఏదో ఉంటుంది. ఏ స్టేబుల్ నుంచి వచ్చింది సార్ అని అడుగుతారు. ఒక గొప్ప లాయర్ చాలా గొప్పగా పర్ఫామ్ చేశాడు, 7-8 years స్టాండింగ్ ఉంది, చాలా వండర్ఫుల్ పెర్ఫార్మెన్స్. నారిమన్ సేస్ ఏ ఛాంబర్స్ నుంచి వచ్చారు సార్ అని. సో ద పెడిగ్రీ దేసే, ఎక్కడి నుంచి వచ్చారు మీరు? ఇట్ సింప్లీ మీన్స్ గురు అండ్ శిష్య, a senior and a junior. See, hear, perceive, learn, progress. These are the only techniques that are available for a junior lawyer to become a senior lawyer. And then in between, if you don't really study, you become senior in age, not senior in perception. So, this is a wonderful life where you get a lot of need to read, and there is a lot of possibility to have access for reading also. So hold that aptitude. And then about legal knowledge, ఎప్పుడు కావాలి సార్ నాకు లీగల్ నాలెడ్జ్ అన్నది ప్రశ్న. నెక్స్ట్ కేసు వేసినప్పుడు కదా సార్, క్లయింట్ వేసినప్పుడు, రిటర్న్ స్టేట్మెంట్ వేసేటప్పుడు అప్పటిదాకా ఏముంది, వాడు వచ్చాడు చిన్న నోటీస్ ఇస్తే చాలన్నా ఇచ్చాం సార్ నండి. నో దట్ ఈస్ ఏ స్లో పాయిజన్ ఆర్ ఏ బాంబ్, నోబడి నోస్ whether the notice that you have given is sufficient or not, because some cases you can file, my dear friends, as all of you know, without giving notice to anybody. Some cases against some clients you cannot file unless you give a notice. Example, section 80 CPC, when you sue a government, right? Now this is one important citation, please. AR 1963, Supreme Court 424, 424, Amarnath Dogra versus Union of India. And gives you a good reading because it speaks about alcohol, vending alcohol, and government is unable to supply enough alcohol. People are eager to consume lot of alcohol, and when you promised that you would supply me a ton, a barrel, and you have been supplying me only half. My clients are waiting, you are not sending, I am suffering lot of monetary loss. This is the context in which this case has come up. And the gentleman had approached a lawyer who very enthusiastically gave a section 80 notice, and finally fought up to Supreme Court and lost it only because what was supposed to be there in section 80 notice was not there. What was mentioned in the plaint did not find its relevant places in the notice, and how at the end he lost all his nisha. This is one judgment. So legal knowledge is very important. This citation is given among thousands that are available. This is one that where, see, I am only talking about a new entrant, a new client, where some need, I know that a statutory notice is required. ఇది నా క్లయింట్ చెప్పి 4 మొక్కలు నేను రాసేస్తే అయిపోయినట్టేనా, లేకపోతే అంతకు మించి నాకు తెలిస్తేనే నేను నిజంగా ప్రొఫెషనల్ సర్వీస్ అందజేసిన వాడినా? It is that where you have to equip yourself, what type of knowledge acquisition that you are required to hold. And the next one is 2001, 6 Supreme Court cases, 163. Viswambhar versus Lakshmi Narayan. This is another wonderful judgment. My dear friends, remember, ఈ పర్టికులర్ జడ్జ్మెంట్ ఆఫ్ ద సుప్రీం కోర్ట్ ఫైనలా ఈ పాయింట్ ఆఫ్ లా మీద? వీఆర్ నాట్ ఫర్ దట్ యాక్చువల్లీ. I have not prepared any of these things, only to tell you the final word of the Honorable Supreme Court of India, or for that matter any other court or any proposition of law. It is not for that purpose all these citations are given. These citations are given essentially for our own orientation. It is only about that for which I have been actually citing them. Now this is wonderful judgment where the suit is with reference to certain property. Father, mother and children, normal family setting. Father got some ancestral property, he died. Now mother is the one who is looking after. Children are small, tender-aged, minors. And then mother sold out some of the properties. And then the children have grown up using that money. They have become majors. Then they found mother sold the property without proper financial need. And she did not obtain permission from the court because she was only a guardian for the property so far as their shares are concerned. So this good principle of law was brought to a good lawyer who perhaps in haste or overconfidence prepared a plaint challenging so many things where until you read the judgment you will never really realize అరే అంత చెప్పింది సరిపోయింది కదా, చెప్పింది ఎందుకు సరిపోలేదని వాళ్ళు చెప్పింది చదివిన తర్వాత అర్థమవుతుంది ఎందుకు సరిపోలేదు అన్నది మనకి. సో దేర్ ఆర్ సెవరల్ ఎలిగేషన్స్ దట్ ఆర్ రిటన్ ఇన్ ది ప్లేట్ and they have sued the opposite parties within 3 years of attaining their majority. And then ముందల్లో ఏం చెప్పారంటే the alienation made by the mother is void, therefore ignore them. They made everybody party. ఈ ఎలిగేషన్స్ రాశారు, చివరి సూట్లో ప్రేయర్ ఏదో అడిగారు. 5-6 ఏళ్ళు పోయిన తర్వాత ఒక లాయర్ లాయర్ గారిని కలిసినట్టున్నారు సలహా అసలు విషయం వచ్చేటప్పటికి. అరే బాబు అసలు ఇందులో మనం యూ మస్ట్ ఆల్సో ఆస్క్ ఎ ప్రేయర్ టు సెట్ అసైడ్ దోస్ సేల్ డీడ్స్ బికాస్ హీ గేవ్ సమ్ రీజనింగ్ which was finally approved by the Supreme Court and which finds its contradictions in some other judgments of the Supreme Court perhaps. Then they moved an application for amendment and the amendment was allowed. Everybody is happy. Then when the matter ultimately went to trial and judgment, every court dismissed including the Supreme Court because the prayer for challenging the alienation deeds, sale deeds, that was found time barred by the time the amendment was brought. So ఇందాక నేను మన ఫ్రెండ్స్తో చెప్తూ ఉన్నాను, లాయర్ అంటే ఎవరనంటే విశ్వనాథన్ ఆనందం గుర్తుపెట్టుకోవాలి. 60వ మూవ్ చెస్లో అపోనెంట్ ఏం వేస్తాడో ఊహించి నేను ఇప్పటి నుంచి ఆలోచించాలి. ఇట్ ఈస్ దట్ స్టామినా ఇన్ యువర్ లాజికల్ థింకింగ్, యువర్ ఎబిలిటీ టు స్టాండ్. ఇట్ ఈస్ ఓన్లీ దట్ మేక్స్ అస్ ఎ గుడ్ లాయర్. సో దట్ ఈస్ వన్ సైటేషన్ సార్. అండ్ దెన్ this is another thing. 2003, 5 Supreme Court cases. 2003, 5 Supreme Court cases. 315. Rajni Kumar versus Sumesh Kumar Malhotra. ఇందాక అనుకున్నాం కదా, లాయర్ appears, disappears and all that. Similarly, client appears, disappears. Client receives summons, appears sometimes, doesn't appear in response to it. సో సూట్స్ అండ్ సమ్మరీ సూట్స్, రెగ్యులర్ సూట్స్ అండ్ సమ్మరీ సూట్స్, ఈ డిస్టింక్షన్ మెయింటైన్ చేయకపోతే ఏం జరిగిపోతుంది అన్నది. మ్యాటర్స్ హ్యావ్ టు బి క్యారీడ్ అప్ టు సుప్రీం కోర్ట్ టు హ్యాడ్ టు సే సో మెనీ థింగ్స్. సో ఇన్ ఏ నార్మల్ సూట్ if you find a client set ex parte seeking to set aside that Article 9 Rule 13 CPC, and how does it actually differ from Article 37 Rule 3 and 4 CPC? What more is this is a case where Supreme Court approves the cause of his absence. That is, the assumption of the court that the opposite party received summons was found to be incorrect. He did not receive the summons. In a normal suit where the summons is found to have been received, is found not served, everything else will be set aside. People will be brought back once again. Fresh litigation commences. But in a summary suit, that itself is not sufficient. Your sufficient cause for non-appearance is not sufficient to set aside an ex parte decree in a summary suit. And why, how, and all that. So, ఒక ప్రిన్సిపల్ తెలిసినంత మాత్రం చేత that would be adequate అనుకోవటానికి లేదు. మనకి ఉల్లి చేసిన మేలు తల్లి కూడా చేయదు కాబట్టి ఏ జబ్బు వచ్చినా నాకు ఉల్లిపోయే చాలు, కరోనా వస్తే కంట్లో వేసుకుంటాం, ఇంకోటి వస్తే ముక్కులో వేసుకుంటే సరిపోతుంది అనుకుంటే చచ్చిపోయారు. సో ఒకటే రెమెడీ అన్నిటికీ సరిపోదు కాబట్టి చాలా రెమెడీస్ ఉంటాయి అన్నది వాస్తవం. కాబట్టి ఎక్కువసేపు వాటన్నిటి ఇంకా చూడటం అనేది చాలా అవసరం కాబట్టి ఇట్లాంటివి చూడటం మనం. అండ్ దెన్ ద అదర్ వన్ ఇస్ ఐ విల్ క్లోజ్ ఇట్ ఇన్ 5 minutes సార్. AR 2004 AP 82. In the AR 2004 AP 82, Botsa Appal Narsaya versus Srimati Raghumanda Lakshmi. Perhaps some of these citations must have been handled by some of the good lawyers sitting here. I find some of the names. And then this is one judgment where, see, మనం ఇంటర్వ్యూ అనుకున్నాం సరిగ్గా ప్రిపేర్డ్నెస్. ఈ ప్రిపేర్డ్నెస్ సరిగ్గా లేకపోతే ఏం జరుగుతుంది? విట్నెస్ కేమ్, క్వశ్చన్ ఇన్ క్రాస్, విట్నెస్ వాజ్ డిశ్చార్జ్డ్. ఆ తర్వాత మళ్ళీ కూర్చుని ఇంటికాడ ఇప్పుడు మెడిటేషన్ చేసిన తర్వాత ఇవన్నీ అడగాల్సింది అడగలేదనుకున్నారు. సో నేను చాలా ఆనెస్ట్ సార్, స్ట్రైట్ ఫార్వర్డ్గా రాస్తాను పిటిషన్లో. సార్ ఇవన్నీ అడుగుదాం అనుకున్నాను, అప్పుడు అడగటం మర్చిపోయాం. ఎందుకు మర్చిపోయామంటే లాయర్ క్లయింట్ మధ్యలో మాట్లాడుకున్నప్పుడు వీడు సరిగ్గా బ్రీఫ్ చేయలేదు సార్, చేతికి 10,000 ఉన్నాయని చెప్పలేదు, నేను 6 ఉన్నాయి అనుకున్నాను, అందుకని ఇప్పుడు తెలిసింది రీకాల్ చేయండి పోరా అన్నారు. క్వశ్చన్ ఏంటంటే, నువ్వు వెన్ ద విట్నెస్ ఈజ్ ఇన్ బాక్స్ యూ కెన్ మేక్ ఆల్ ద థింగ్స్. వన్స్ ద జడ్జ్ హ్యాస్ డిశ్చార్జ్ ద విట్నెస్, ఆస్క్ హిమ్ టు గో బ్యాక్. దెన్ ఇఫ్ యూ వాంట్ హిమ్ టు సమన్ బ్యాక్, రైటింగ్ దీస్ థింగ్స్. డిఫికల్టీ ఏమిటంటే సార్, 70-80 ఏళ్ళు ప్రాక్టీస్ చేసిన తర్వాత సిపిసిని మనం 2004లో కూడా అదే చేస్తున్నాం. అది క్వశ్చన్ ఏంటంటే, నాట్ దట్ ఐఎమ్ ఇంటెలిజెంట్, నాట్ దట్ ఐఎమ్ ఇగ్నోరెంట్, నో, దట్స్ నాట్ ది క్వశ్చన్. యాజ్ సంబడి వాజ్ రైటింగ్, 1939లో మోటార్ వెహికల్స్ యాక్ట్ ఒకటి వచ్చింది, ఇంకా అంతకు ముందు కూడా ఉంటుంది. ఆటోమొబైల్స్ 100 ఏళ్ళ పైన వచ్చినాయి. ఇప్పటిదాకా మనకు రోడ్డు మీద నడవడం చేత కావట్లేదు, మాట్లాడితే యాక్సిడెంట్స్ అవుతున్నాయి, చాలామంది యాక్సిడెంట్స్ వల్ల సఫర్ అవుతున్నారు. క్వశ్చన్ ఈజ్ హౌ బెస్ట్ యాజ్ ఎ సివిల్ సొసైటీ వీ హ్యావ్ గ్రోన్ అప్. Judges and rule of law versus public competence. Rooms full of voluminous literature has been published. మీరు నేను కోర్టులో కూర్చొని ఆర్గ్యూ చేసుకుని ఓ జడ్జిమెంట్ రాసుకుని ఇది ఫండమెంటల్ రైట్ అయ్యా, ఇది ఫండమెంటల్ డ్యూటీ అయ్యా, ఇది రైట్ అయ్యా, ఇది రాంగ్ అయ్యా అన్నది ఉందే, దట్ గవర్న్స్ ఓన్లీ 2 gentlemen who are there. But it is the lawyer's participation in the society. It is that which actually brings real public conscience. It is that really that enlivens the constitution, and not one single judgment. It is the participation of the lawyers, and that has been the unanimous stand across the globe. So now మనం ఇంకా 100 ఏళ్ళ తర్వాత 80 ఏళ్ళ తర్వాత కూడా ఆ పాత విషయాలే రాసి ఆ పాత జడ్జిమెంటే సంపాదించి ఆ పాత తిట్లే తిట్టుకుంటూ ఉంటే ఉపయోగం లేదు. Modern practice and a good lawyer must actually go forward. And then one more, and I will close this particular item. 2007 1 ALD 101. 2007 1 ALD 101 AP. This is wonderful lawyer. There are 2 neighbors. ఇటువైపు చెట్లున్నాయి, అటువైపు చెట్లున్నాయి, అంత స్థలం, అటువైపు స్థలం, ఇటువైపు స్థలం. అవతల వాడు వచ్చి వీడి దాంట్లో చెట్లు కొడుతున్నాడు. He believes that it is his property and he is not entitled to come and cut the trees here. This happened on January 1st, 1980. Example. He filed a suit for injunction, appropriate relief, appropriate plaint, well drafted, wonderful. That was going on. Then 1వ తారీఖు జనవరి నుంచి జూన్ 10వ తారీఖుకి వచ్చాం. వాడు మళ్ళా ఇంకో చెట్టు కొట్టాడు. లాయర్ గారి దగ్గరికి వచ్చేప్పుడు అలా చేసావా అని మళ్ళీ ఇంకో సూట్ వేశాడు. అనదర్ సూట్ ఫర్ ఇంజంక్షన్, అంటే ప్రతి చెట్టుకి ఒక సూట్ వేస్తాడు ఈయన. నా అవతల లాయర్ గారు సేమ్ క్లయింట్ సేమ్ గొడ్డలి. సో ఆయన వచ్చి, సార్ అదొకటి వేసాడు సార్, ఇదొకటి వేసాడు. ఏమిటంటే సార్, లుక్ ఎట్ ది కాజ్ ఆఫ్ యాక్షన్ సార్, అది 1వ తారీఖు జనవరి, ఇది 10వ తారీఖు జూన్ అన్నారు. 2 సూట్లు కొట్టేశారు. అండ్ ఇట్ టుక్ 20 years ఫైనల్లీ. సో ఈయన చెట్లు పోతూనే ఉన్నాయి ఈ లోపు. సో వేర్ డస్ ది ఫాల్ట్ లై? అండ్ దిస్ ఇస్ వన్ జడ్జ్మెంట్. యూ విల్ సీ what is that somebody else has done wrong, and how should I actually avoid committing the same wrong. And then 2002 1 ALT 466 Andhra Pradesh, Sanjana Granites vs. Mando Srinivasa Rao. I am a lawyer, entitled to file documents, protect my client, everything is fine. రెడీగా ఒకసారి చదువని. ఇది చదవలేకపోయాడు, అందులో రాసింది ఏమీ అర్థం కావట్లా. 2 కారణాలు, తీసిన ఫోటోస్టాట్లు ఏవి గజిబిజిగా ఇదిగా ఉన్నాయి, రాసిన వ్రాత జిలేబీలాగా ఉంది. Now if a lawyer can't read it, how could he ask a judge? So what is to be done? How valuable litigation is lost. And finally the judge had to lament, అరే ఉన్న డిస్ప్యూట్ ఏమిటి, ఇంత వల్యూమినస్ ఎవిడెన్స్ ఏంటి, ఈ బండిల్ టన్నులు వచ్చేసి దేనికన్నా ఉపయోగపడుతుందా మీరు ఎక్స్ప్లెయిన్ చేయండి సార్ అని అడిగితే, రోనోడ్ మీద దావా అయితే కనుక ఇది 11వ తారీఖు సార్, ఆ రోజున RRR సినిమా రిలీజ్ అయిందంటూ అది కూడా చెప్తే, అది కూడా రాస్తాం ప్లేట్లో. RRR సినిమా రిలీజ్ అవడానికిను వీడిచ్చిన 100 రూపాయలు పొందిన 100 రూపాయలకి సంబంధించి సంబంధం లేదు కదా. సో వల్యూమినస్ ఎవిడెన్స్ బర్డనింగ్ ది కోర్ట్, యూ విల్ ఫైండ్ సో మెనీ అన్నెసెసరీ థింగ్స్. మై క్లయింట్ ఈజ్ ఎ మ్యారీడ్ మ్యాన్, ఇది కూడా వెడ్డింగ్ కార్డ్. దేని గురించి అండి ఇది ఎస్టేట్స్ అబాలిషన్ యాక్ట్ మీద కేసు సార్. అరే దానికి మీ వాడి పెళ్ళికి సంబంధం ఏమిటి, దాంట్లో వెడ్డింగ్ కార్డు ఎందుకునంటే, నో సార్, యూ హ్యావ్ టు మార్కెట్. సో దట్ ఈస్ వన్ థింగ్ దట్ యూ హ్యావ్ టు సీ. అండ్ దెన్ 1988 one Supreme Court cases 105. 1988 one Supreme Court cases 105, Shobharani versus Madhukar Rao. I'll just read a small paragraph because ఒకటి సార్లు ఒకసారి భోజనం చేసి 2 సార్లు టీ తాగినప్పుడు మేము అందరం కలిసి కూర్చుంటూ ఎస్టీమ్డ్ బార్ మెంబర్స్తో బాధపడ్డాం కొన్ని విషయాల్లో. సో అందుకని ఈ పారాగ్రాఫ్ చదివితే బాగుంటుందని నాకు అనిపిస్తూ ఉంది. భార్యాభర్త. భార్య పోస్ట్ గ్రాడ్యుయేట్ ఇన్ బయాలజికల్ సైన్సెస్, భర్త డాక్టర్. తీవ్రంగా పోట్లాడుకుంటున్నారు. ఫస్ట్ కోర్టుకి వెళ్ళారు, డైవర్స్ అడిగింది భార్య. నో ఎందుకమ్మా అంటే, చాలా క్రూయల్ సార్. అది క్రూయల్టీ ఏంటమ్మా అన్నారు. నెక్స్ట్ కోర్టుకి వెళ్ళింది, వాళ్ళు విన్నారు, అదేం క్రూయల్టీ కాదమ్మా అన్నారు. సార్ నేను ఇంత చూస్తుంటే వీళ్ళందరూ క్రూయల్టీ కాదన్నారు. సుప్రీంకోర్టు దాకా వెళ్ళింది. వెళ్తే వాళ్ళు అన్నారు, ఏది క్రూయల్టీ కాదు నిర్ణయించేటప్పుడు 2 విషయాలు గుర్తుంచుకో. ఒకటి, ద కోర్ట్ ఇన్ మ్యాట్రిమోనియల్ కేసెస్ ఈజ్ నాట్ కన్సర్న్డ్ విత్ ఐడియల్స్ ఇన్ ఫ్యామిలీ లైఫ్. భార్యాభర్తలు అంటే ఇలా ఉండాలరా అంటామే, ఉండని అలాగే ఉండాలి, కరెక్టే. కానీ వీళ్ళ కేసుకి నువ్వు ఆర్గ్యూ చేసేటప్పుడు కానీ, వీళ్ళ కేసుని నువ్వు అపోజ్ చేస్తున్నప్పుడు కానీ, వీళ్ళ కేసు నువ్వు ఎడ్యుడికేట్ చేస్తున్నప్పుడు కానీ, ఈ ఐడియల్స్ని ప్రతిబింబించు. మాకు ఉన్న విషయం ఏమిటో అర్థం చేసుకో, దాన్ని నిర్ణయించడం గురించే చెప్పు. కానీ వాళ్ళని మార్చడం గురించో ఇలా ఉంటే బాగుంటుందని అది కాదు కోర్ట్ అన్నది, అది కాదు కేసు అన్నది. సో ద కోర్ట్ ఇన్ మ్యాట్రిమోనియల్ కేసెస్ ఈజ్ నాట్ కన్సర్న్డ్ విత్ ఐడియల్స్ ఇన్ ఫ్యామిలీ లైఫ్. ద కోర్ట్ హ్యాస్ ఓన్లీ టు సీ అండ్ అండర్స్టాండ్ ది స్పౌజెస్ కన్సర్న్ యాజ్ నేచర్ మేడ్ దెమ్. వీడు ఇంతే సార్, ఆవిడ అంతే సార్, అది దట్స్ హౌ దే ఆర్ మేడ్ ఆఫ్. అది తీసుకోండి, దాన్ని నిర్ణయించండి. And consider their particular grievance. The cruelty alleged may largely depend upon the type of life the parties are accustomed to, or their economic and social conditions, and their culture and human values to which they attach importance. Therefore, courts and lawyers should not import their own notions of life. So, వాడు డైవర్స్ అడుగుతుంటే ఈ లాయర్ గారికి వచ్చి ఇట్లాంటి అట్లా కూడా ఇస్తారా సార్, ఏమిటి సార్ మీరు ఆలోచించండి, ఒక గుడ్ హస్బెండ్గా ఒక గుడ్ వైఫ్గా అని అనమాకండి. సో నార్ షుడ్ ఇట్ డిపెండ్ మచ్ అపాన్ ది ప్రెసిడెంట్. సార్ సుబ్బారావు గారు 1966లోనే చెప్పారు ఇట్లా చేస్తే చేయండి అని అంటే, ప్రెసిడెంట్ ఇస్ ఓకే, అసలు ముందు వీళ్ళ ఫ్యామిలీ చూడవయ్యా, దీన్ని సర్దవలసిన అవసరం, సర్దితే సరిపోయే అవసరం ఉన్న ఫ్యామిలీనా, సర్దుబాటులతో సంబంధం లేకుండా పంపించేవలసిన ఫ్యామిలీనా, ఇవి ఇట్లాంటివి మనం ఇవన్నీ చదువుతానికి బాగానే ఉంటాయి. Now, unless you replicate so many examples for yourself, simulate yourself, seek certain things, start reasoning them out, reading a little more about these aspects. అవన్నీ మనం ఎక్సర్సైజ్లు చేయకపోతే కష్టం. ఆ ఎక్సర్సైజ్లన్నీ చేస్తూ మనం చేయవలసి ఉంటుంది. అండ్ దెన్ 2 more citations I will wind up. 2001 6 SCC, 2001 6 Supreme Court cases 135. పాపులర్ కేసు ఎన్జీ దస్తానే వర్సెస్ శ్రీకాంత్ ఎస్ శివడే. విట్నెస్ వచ్చారు, చీఫ్ ఎగ్జామినేషన్ ఉంది, క్రాస్ ఎగ్జామిన్ చేయబాబు అని అంటే లాయర్ గారు లేదు లేదు సార్ అందరు రావాలన్నాడు. సరే అని అందరినీ పట్టుకొచ్చాడు. అందరినీ పట్టుకొచ్చిన తర్వాత దిస్ జెంట్మెన్, ది అక్యూజ్డ్ ఈజ్ ఎ వెరీ వైజ్ అక్యూజ్డ్. హీ at once engaged 2 lawyers together, they filed common wakalat, joint wakalat. So ఇద్దరు లాయర్ని పెట్టుకున్నాడు, వాళ్ళిద్దరూ కలిసి వచ్చి చేసినవి. దిస్ ఈజ్ ఎ నెరేషన్ యాజ్ వాట్ నాట్ టు డూ. సో వండర్ఫుల్ నెరేషన్ అబౌట్ adjournments, and finally how the magistrate has succumbed to the mere request, how the client is so disheartened. ఫైనల్గా ఇద్దరు లాయర్లు, ఒక లాయరు రెండో లాయర్ గారు రాలేదు ఇవాళ, ఈయన చేయాలి. మొదటి లాయర్ గారు కొంచెం థ్రోట్ ఇన్ఫెక్షన్ రావటం వల్ల మాట్లాడలేకపోతున్నారు కాబట్టి అడ్జర్న్మెంట్ ఏమన్నా అడిగితే అలాగే అన్నాడు. మరి నువ్వు ఉన్నావు కదా అంటే నో ఆయనే చేస్తాడు సార్. అంటే ఈరోజు వాయిదా అయితే నేను చేస్తాను సార్, రేపు వాయిదా అయితే ఆయన చేస్తాడు సార్, ఇది ఎల్లుండి వాయిదా అయితే ఈయన చేస్తాడు, ఇది ఏదో పెట్టుకున్నారు వాళ్ళు. సో ఆ రకంగా జడ్జి వాజ్ కన్విన్స్డ్ ఆల్వేస్. అయిపోయింది. అప్పటిదాకా కూడా ఎవ్రీ అకేషన్ దిస్ కంప్లైనెంట్ హ్యాస్ బీన్ క్యారింగ్ ఆల్ హిజ్ విట్నెసెస్, but every time adjournments are sought despite 2 advocates being there. So how we should not ask is one part of it, and then how a judge should not be there is another part of it. And final ga inta kashtapadutu veedu last adjournment is about throat infection. అయిపోయి ఆ రోజున వాయిదా పడింది, ఏడుస్తూ వెళ్తున్నాడు, కారిడార్లో వెళ్తుంటే అదే బిల్డింగ్లో ఇంకో కోర్టు హాల్లో వెరీ ఫ్లూయెంట్గా ఈ లాయర్ గారు ఆర్గ్యూ చేస్తూ కనపడ్డారు. దట్ took out spirit out of him. Then he addressed a complaint to Bar Council of the state. They said that they called for a report. They said no, frivolous complaint, dismissed. He did not stop there. He went to Bar Council of India. They said that no, we find no reason to interfere. Easy. Because there is no prima facie case what the Bar Council of State says. Now, when it came to Supreme Court said we find strong prima facie case. The question is, for finding prima facie case, a gentleman had to travel up to Supreme Court now. A prima facie case is one where on its face you will see primarily. Kada? అది చూడంగానే అరే ఈయన చైనీస్, ఈయన ఆఫ్రికన్, ఈయన ఇండియన్ లాగా అది చూడంగానే కనిపించాలి మనకి, అదే కదా ప్రైమా ఫేసీ అంటే. ఆన్ ఇట్స్ ఫేస్ ఇట్ మస్ట్ బి దేర్ కదా. సో ఇది ఫైండింగ్, దెన్ దే స్పీక్ సో మచ్ గుడ్ అండ్ బ్యాడ్ అబౌట్ అవర్ ప్రొఫెషన్, అండ్ దెన్ లాట్ ఆఫ్ paragraphs are written. And then last one is AR 2005 SC 344. SC 344. So this is about a judge, lawyer complaining and finding good judge, finding bad judge. These complaints leading to a lot of troubles, and finally Supreme Court said, well, Baba, అనవసరమైన కంప్లైంట్లు పెట్టమాకండి అని వాటి మీద. And then what we are not doing, one citation, 1981, 1 SCC 447, and the other citation is 1989 Criminal Law Journal 1213, 1989 Criminal Law Journal 1213, Himachal Pradesh. The first one is a small one. As lawyers, all of us owe a duty towards ourselves, duty towards the client, duty towards the court, duty towards the public. And then most important thing is that I must respect myself and I must respect you. These are the two things. And then what do you mean by respect? Another namaskaram pettukotrena kaadu. My sincere participation, putting my best effort in the role that is assigned to me. When judge is to formulate his charges against the accused, I must be there. When the judge is trying to frame the issues, I must be there. How many of us are actually there? And then after the trial is over and the judgment is to be pronounced, finally it may end in acquittal or conviction, but before that, after finding guilty, there is some sort of sentence hearing. How many of us are really participating in it? And then how many of us are really actually reading and then asking and telling the judge, arguing before him, the virtue of application of Probation of Offenders Act? That is lamented by Supreme Court, where it says that the bar is at fault and bench is at fault. Necessary material is never adduced, never collected. Finally, మనమే కట్టేసుకుని మన కొమ్మలు మనమే నరికేసుకుని అంత లాడబుల్ లెజిస్లేషన్ మనం పుట్ టు డిస్యూస్. Therefore, what is practiced alone flourishes. What is not practiced doesn't flourish. The most acclaimed legislation passed in 1958, it is limping, dying, and none of us is caring. Why? Because look, see, learn. When I looked, nobody is practicing, therefore I don't practice. No, that's not what exactly. Copying doesn't simply mean that only if somebody does, you do. No. Do you think that you have to eat only when somebody eats? No. You never go to your neighbor asking him, భోంచేసావా లేదా అని. ఏం సార్ అంటే నేను కూడా భోంచేద్దామని అడిగారు ఎప్పుడన్నా? లేదు కదా. సో మనం కొన్ని పనులు మనం ఏది మంచిది అనేది మనకు కూడా తెలుసు. తెలియక కాదు ఇవేమి. తెలిసిన దాని మీద మనం ప్రజ్ఞ సంగతి అలా పెట్టి ముందు మనం దాని మీద మన ఆసక్తిని ఏం కనపరిచామన్నది. అండ్ దెన్ ద అదర్ వన్ ఈజ్ ఇంపార్టెంట్. డెకాయిటీ. లాయర్ గారు వచ్చారు, జడ్జి గారితో సార్ కాంప్రమైజ్ అయిపోయారు సార్. ఏమయ్యా అంటే అదే అంటున్నారు కానీ సార్, సో ఇవన్నీ మనకి తెలిసిన నార్మల్ సీనే కదా. సో వెరీ గ్రాఫిక్ నెరేషన్ ఆఫ్ దెమ్ ఆర్ దేర్. ఫైనల్లీ జడ్జ్ అదర్ క్లయింట్స్ అందరూ కలిసి ఏంటంటే అమ్మవారి దగ్గర నువ్వు కనుక హారతి మీద ప్రమాణం చేస్తే అప్పుడు ఓకే ఓకే ఏమంటావు? ఎస్ సార్. లాయర్ గారు మీరు వెళ్ళండి ఆయనతో. ఓకే, అందరు వెళ్ళారు. తర్వాత కమిషన్ రిపోర్ట్ వచ్చింది. సార్ నిజంగా ఇక్కడ చెప్పినట్టుగా అక్కడ చేశారు సార్, హారతి మీద ప్రమాణం చేసి ఇంకెప్పుడు చేయమన్నారు. వీళ్ళు వాళ్ళకి ఇచ్చేశారు, వాళ్ళు ఓకే అన్నారు, అంతే. ఓకే, దెన్ కేస్ స్టాండ్స్ డిస్మిస్డ్. దిస్ ఏ జడ్జి హ్యాస్ రెడ్, హిమాచల్ ప్రదేశ్, read in the newspaper, so shocked, shocking judicial conscience, a term that you will find in several enactments. And a reading of this judgment as to how the lawyers and the judge together hijacked the whole law, all virtuous principles, rights, duties of everybody. And when that hijacking, when read in the newspaper, how a judge reacted, how a suo motu revision was taken place, what he chastised, what he did. Finally, the moral that we have to learn is today I can manipulate, but tomorrow it will come back. Therefore, let us not indulge in manipulation. I don't want to give you all those citations about manipulations and all that, because it is too much to me to eat away your valuable time for valuable justices and other doctors who are actually there. Thank you very much.
Thank you, Justice V.R.K. Krupasagar Garu. His presentation of law lives, lawyer's way, really lived in the hearts of our advocates. Some other day we will arrange the honorable judges' Telugu speeches also. Thank you very much, sir, on behalf of the advocate community and on behalf of the members of the Bar Council of Today. Now I request all the Bar Council members to come over to the dais and felicitate the guests. Namarao garu, rendi.
I request everyone to be seated. I request everyone to be seated. We need to commence the session. I repeat, I request all the advocates to be seated. We need to commence the session. I request Professor Arvind Nutulapati Garu, President, Center for Social Psychology, AP, to come to the dais and adore the chair. I request A. Swarupa Reddy Garu to present a bouquet to the professor. I request Professor Arvind Nutulapati Garu to address the gallery.
Good evening, everyone. At the outset, I thank the Bar Council of Andhra Pradesh and all the stakeholders of KL University for inviting me. I would like to talk about stress management. That's what I'm asked to talk about. And one more thing, I appreciate everyone here for a lot of patience and absolute attention. Of course, I'm still working in an engineering college as a professor and psychologist. We don't find this much of attention in classes. Everyone will be in one's own world there. So I'm really feeling happy to be here. As schedule began late. It's okay. Am I audible to everyone? Thank you. Is it ready? కాలేజీలో మా దగ్గరికి స్టూడెంట్స్ వస్తుంటాయి కౌన్సిలింగ్ రూమ్లోకి వచ్చి ఈ సమస్య థర్డ్ ఇయర్లో వస్తుంది, బీటెక్ థర్డ్ ఇయర్. చాలా డిప్రెషన్లో ఉన్నాను సార్ అంటాడు. ఎందుకు అంటే అసలు విషయం తప్ప వేరే అన్నీ మొదలు పెడతాడు. ఫైనల్గా వచ్చాడు, ఫైనల్గా కాసేపు అయిన తర్వాత ఒక అరగంట తర్వాత వస్తాడు. ఎక్కడికంటే సెకండ్ ఇయర్లో ఒక అమ్మాయి పరిచయం అయింది సార్ అంటాడు. ఆ తర్వాత చెప్తాడు. ఇక అక్కడి నుంచి we understand the situation because name is different, case is the same. What's the case? మరి సెకండ్ ఇయర్లో పరిచయం అయితే హ్యాపీగా ఉండొచ్చు కదా, ఏమైందా? అమ్మాయి వేరే వాడితో మాట్లాడతాను సార్ అంట. సో దిస్ ఈస్ ద సినారియో. పేరెంట్స్ వస్తారు. ఎట్లా వస్తారంటే, ఇది ఆడిటోరియం కాబట్టి ఇక్కడ పిల్లర్స్ లేవు, మామూలుగా పిల్లర్స్ ఉంటాయి మధ్యలో. ఆ పిల్లర్స్ చాట్ నుంచి దాక్కొని టపక్కన రూమ్లోకి వచ్చేస్తాడు. వచ్చి ఫస్ట్ చెప్పే డైలాగ్ ఏంటంటే, సార్ నా పేరు అరవింద్, మా అమ్మాయి ఉంది ఇక్కడ మానస అని సెకండ్ ఇయర్లో, నేను వచ్చానని మా అమ్మాయికి చెప్పాకండి అంటారు. ఏమైంది చెప్తే అని అడగం, ఎందుకంటే మాకు తెలుసు. తర్వాత ఇక స్టోరీ మొదలవుతాయి. ఆ అమ్మాయిని పిలిస్తే ఏంటి నీకు ఇబ్బందులు అని ఏం చెప్పారు సార్, ఈ ప్రపంచంలో మా అమ్మ అంత రాక్షసు లేదండి అంట. వాళ్ళ అమ్మ అంత రాక్షసు ఈ ప్రపంచంలో ఎవరు లేరని మొదలుపెట్టింది అమ్మాయి. ఎందుకు అంత రాక్షసత్వం ఎందుకు వచ్చినా? ఎందుకేంటి సార్, మొబైల్ ఫోన్ లేకుండా అసలు ఎవడన్నా బీటెక్ చదువుతాడా? సంవత్సరం నుంచి అడుగుతున్నా, డొక్కుది కొనిపెట్టింది. అది రాక్షసి. ఇంకొక ఆయన వస్తాడు, ఫస్ట్ డైలాగ్ నేను వచ్చానని మా అబ్బాయికి చెప్పాకండి అంటాడు. ఎందుకు చెప్పొద్దు? తర్వాత బాండి పిలుస్తాం, ఏంటి సంగతి? అసలు సార్ మా నాన్న నన్ను ఎందుకు కన్నాడో తెలియదని మొదలు పెడతాడు. ఇట్లా కన్ఫరంటేషను కాలేజెస్లోనే కాదు, స్కూల్స్లో. ఒక గుంటూరులోనే ఒక కవి పాపినేని శివశంకర్ అని ఆయన రాశాడు. ఏం రాశాడంటే, మనిషిని మనిషి వికర్షిస్తూ ఎవరికి వారు ఏకాంత ద్వీపాలైపోతున్నారు. No two human beings go together today. ఎందుకని ఈ పరిస్థితి ఉంది? ప్లీజ్ ఎందుకని ఈ పరిస్థితి ఉంది? భారతదేశంలో ఉన్న 140 కోట్ల మంది జనం సైకాలజిస్టులే. భారతదేశంలో ఉన్న 140 కోట్ల మంది జనం ఎడ్యుకేట్సే. 140 కోట్ల మంది జడ్జీలే. మీరు ఏదైనా అడగండి, వాళ్ళకు జడ్జిమెంట్ ఉంటుంది. మీరు ఏదైనా చెప్పండి, దానికి ఒక ఆర్గ్యుమెంట్ ఉంటుంది. నరేంద్ర మోడీ 3 వ్యవసాయ చట్టాలు పెట్టాడు కదా అంటే ఎమ్మటి ఒక ఆయన జడ్జిమెంట్ ఇస్తాడు, వాడి 100 అవి పనికిరావు అంటాడు. ఆ 3 చట్టాల పేరు తెలుసా నీకంటే నాకేం తెలుసు అంటాడు. ఇది పరిస్థితి. సో premature freedom, independence, I don't know. But the scenario is, once a very closely knit Indian society has become highly individualized today. Center for Social Psychologyలో మేము రీసెర్చ్ చేస్తున్నాం. దేని మీద రీసెర్చ్ చేస్తున్నాము అంటే సైకాలజీ స్టడీస్ what causes human behavior and how thinking influences behavior and what causes thinking. In social psychology we study how thinking of groups of people influence the thinking of individuals and how individuals thinking influence the groups. This is what we study. So ఈ స్టడీలో we understand everyone is under stress, but they do not know. లాయర్ ప్రొఫెషన్లో ఉన్న వాళ్ళకి స్ట్రెస్ ఏముంటుంది అని చెప్పని నేను కొంతమంది మిత్రులను అడిగితే అసలు ఈ ప్రొఫెషన్లోకి వచ్చే ముందే పెద్ద స్ట్రెస్, ఎప్పటికి సెటిల్ అవుతాము అని. అయితే ఐ అష్యూర్ యూ, ఇవాళ ఏ ప్రొఫెషన్లోనైనా ఇదే పరిస్థితుంది. ఇట్స్ లాంగ్ జెస్టేషన్ టైం. Stress is inversely proportional to happiness. Is the PPT ready? Yeah. Stress is inversely proportional to happiness. Stress cripples you, happiness empowers you. How and why? This is what I would like to briefly present before you. మన ఆలోచన, మనం ఏమనుకుంటామంటే నేనే గౌతమ్ బుద్ధుడిని, నేనే ప్రశాంతంగా ఆలోచిస్తా, ఈ ప్రపంచంలో జనం అంతా తీవ్రవాదులే అని ఎవడికాడు అనుకుంటాడు. ఇది సమస్య. స్ట్రెస్ ఎక్కడ స్టార్ట్ అవుతుంది అంటే when you have a task and you think your capabilities are not enough to cope up, stress levels begin. And this will have a crippling effect, whether it is in case of students, in case of teachers, in case of lawyers, in case of judges. And before I go to this, I would like to ask one question. Is Indian Penal Code science or a subject of humanities? I'm asking you. Is Indian Penal Code, justice delivery, is it science or is it a discipline of humanities? What do you think? Blend of both. How many of you agree with him? He says it's a blend of both humanities, sciences. I come across this doubt having listened to 3 honorable judges. Recently, one politician broke the EVM. One court says he is entitled to bail. Another court says he is not. If it is science, both courts might have felt the same. If it is humanities, there is an element of discrimination. So, human discrimination is involved in justice delivery system. And discrimination, if humane, discrimination, if based on reason, compassion, humanity, it is invited, and otherwise it is not. So, ఎవ్రీడే లైఫ్లో ఒక ప్రొఫెషన్లో సక్సెస్ కావాలి అంటే ఏ క్వాలిటీస్ అవసరం, దట్స్ ద టాపిక్ ఐఎమ్ గోయింగ్ టు ప్రజెంట్ బిఫోర్ యూ. మేము కాలేజీల్లో చూస్తాం, కొంతమంది ఎంటర్ అవటంతో ఏ ముఖంతో వస్తారంటే చూసిన ప్రతివాడు పశ్చాత్తాపడతాడు. అంత దరిద్రపు ముఖం, అంత కోపం, అంత రంది, ఒకటి ఇట్లా చూస్తుంటాడు, ఈ మొత్తం నాకే అన్నట్టుగా. ఒకడిని చూస్తే ప్రపంచంలో ఉన్న విచారం అంతా ఆడి ముఖంలోనే ఉంటుంది. ఈ ప్రపంచ భారం మొత్తాన్ని నేను ఒక్కడిని మోస్తున్నా చూడండి అంటాడు. మరికొన్ని మోకాలు వాడు నవ్వడు, ఎవడన్నా నవ్వితే ఊరుకోడు. అసలు ఎంట్రన్సే చూసుకొని నన్ను చూసావంటే సచ్చావే అన్నారు. These people with these faces never succeed in life. Faces which are pleasant, faces which are cheerful, faces which are compassionate, they are welcome. నేను చదువుకునే రోజుల్లో స్టూడెంట్ డేస్లో రకరకాల యాక్టివిటీస్లో ఉండేవాడు. మార్కండేయులు గారు ఒక పోలీస్ ఆఫీసర్ ఉన్నాడు. ఆయన మీద అటెంప్ట్ మర్డర్ చేశానని నా మీద కేసు పెట్టారు. అప్పుడు నా వెయిట్ 40 కేజీలు, ఆయన వెయిట్ 80 కేజీలు. ఆయన బాడీ బిల్డర్. నేను అడిగా, ఏమండి ఈ కేసు న్యాయంగా ఉందా అని. సరే ఇది తీసేసి గంజాయి కేసు పెట్టేదా అన్నాడు. వద్దులే, ఇదే కాదు గౌరవంగా ఉంటుందా అన్న. ఎంత లోపల వైకే గారని వచ్చారు. ఆయన అప్పుడు యాక్టివిటీస్లో ఉండేవాడు. వచ్చి నువ్వు ఆయన కేసు సంగతి అడగబాక నేను చూసుకుంటానన్నా. ఎందుకు చెప్తున్నాను, ఇంకో కేసులో జడ్జి గారు నీకు బెయిల్ ఇస్తున్నాను, ఇద్దరిని షూరిటీస్ తెచ్చుకోమన్నాడు. నాకు ఆ రోజుల్లో తెలియదు లా వీటి గురించి. ఈ షూరిటీలు అని తెచ్చుకొని ఇస్తే బెయిల్ ఇవ్వు, లేకపోతే జైలు పంపాను. అట్లా అనకూడదా, నేను జడ్జిని అన్నాడు ఆయన. ఇంకొక ఆయన నుండి లాయర్ గారు చిన్నోళ్ళు తెలియదు అని బెయిల్. ఆయన పేరు పెద్ద వెంకటేశ్వరరావు గారు. ఎందుకు చెప్తున్నానంటే ఇట్లా గుంటూరులో చాలామంది లాయర్లు, నాకు వీళ్ళకి డబ్బులు ఇవ్వటానికి నా దగ్గర ₹1 కూడా లేదు అప్పుడు. దే themselves కేమ్ ఫార్వర్డ్, ఆఫర్డ్ సర్వీస్, ఫ్రీ ఆఫ్ సర్వీస్. ఎవరైతే గుంటూరులో లీడింగ్ ప్రాక్టీషనర్స్గా ఉన్నారో వాళ్ళందరూ కూడా సోషల్ సర్వీస్ చేసిన వాళ్ళు. వాళ్ళందరూ కూడా పీపుల్స్ మూమెంట్లో ఉన్నవాళ్ళు. వాళ్ళందరూ కూడా సోషల్ కమిట్మెంట్ ఉన్నటువంటి వాళ్ళు. సో ప్రొఫెషన్ని సంతోషంగా ఎప్పుడైతే టేకప్ చేస్తామో, సంతోషం ఎప్పుడు ఉంటుంది ప్రొఫెషన్లో? వెన్ వీ డూ సంథింగ్ గుడ్ ఫర్ అదర్స్, వెన్ వీ థింక్ బియాండ్ మేకింగ్ మనీ, వెన్ వీ థింక్ బియాండ్ getting power, when we think beyond getting fame, when we do really something good for others without expecting anything in return, that releases serotonin. Our brain releases serotonin. I'll come to that. So our thinking, our face reflects. Our thinking, our eyes reflect. మన ఆలోచనను బట్టి మన ముఖం ఉంటుంది. మన ఆలోచనలో దరిద్రం ఉంటే మన ముఖంలో దరిద్రం ఉంటుంది. మన ఆలోచనలో కోపం ఉంటే మన ముఖంలో కోపం ఉంటుంది. ఒకటి ముఖం చూడంగానే అట్లేసే పెనం గనక దాని మీద చినుకు పెడితే సుయ్యమని ఎట్లా ఎడుతుందో వాడంక చూడంగానే షాక్ కొడుతుంటారు కొంత. అట్లాంటి వాళ్ళు లాయర్స్గా ఇంతకుముందు సక్సెస్ అయ్యారు కానీ ఇప్పుడు కావరు. యంగ్ లాయర్స్ ఉన్న కొంతమంది నా స్టూడెంట్స్ ఉంటే అడిగాను, అదే పలాయన దగ్గరికి వెళ్ళి ప్రాక్టీస్ నేర్చుకో బాగుంటుంది, ఆయన బాగా చెప్తాడు. ఆయన భలేవాళ్ళు సార్, వాడి దగ్గరికి వెళ్తే నోరు తెరిస్తే బూతులే, ఒక్క పూట కూడా నాతో సరిగ్గా మాట్లాడాల అన్న. హౌ కెన్ ది సక్సీడ్? When you feel happiness in your thought, your face reflects it. When you feel compassionate in your heart, your face reflects it. When you feel friendly with your client, your face reflects it. When you are cunning in your thought, when you are greedy in your thought, your eyes reflect it. Your client will easily identify your feelings. Most human beings can sense other human beings' thoughts when they look into your faces. That's why we need to be happy, and there are ways to be happy. There are ways we can be happy. This is the reason we need to beat the stress in life. Stress ఎందుకు వస్తుంది? కోపంలో నుంచి కోపం అదుపు తప్పినప్పుడు స్ట్రెస్ బయలుదేరుతుంది. పక్కడు పెరిగిపోతున్నాడు అన్న దురద ఎక్కువైపోతే అది స్ట్రెస్గా కన్వర్ట్ అవుతుంది. ఈ మధ్య నాకు ఒకటి కనపడ్డాడు, నేను 10 ఏళ్ళ నుంచి ప్రాక్టీస్ చేస్తున్నా, నా జూనియర్ ఒక జడ్జి అయి కూర్చున్నాడు అని. అయితే ఏంటన్నా నష్టం, సంతోషపడవచ్చు కానీ కాదు, వీడి బాధ. నాకంటే చిన్నోడు ఆడ పైన కూర్చున్నాడు. how can that feeling helps you? How can that help you? So it is important we regulate our thinking. There are ways to do it. Nirasha, ఈర్ష్య, డిసప్పాయింట్మెంట్ ఇవన్నీ కూడా స్ట్రెస్కి దారితీస్తాయి. స్ట్రెస్ అనేది మనల్ని క్రిపిల్ చేస్తుంది. సో వీ నీడ్ టు కౌంటర్ ఇట్ with the help of happiness. Is this right? ఇదేనండి. So this is our objective. We research, formulate, develop, propagate policies which empower common man. Common man ante that includes women also. Don't think that I have gender bias. Stress is psychological, but it leads to physiological problems as well. చాలా మందికి చాలా ఎర్లీగా గ్యాస్ ట్రబుల్ రావడానికి కారణం మనకు తెలియదు, స్ట్రెస్సే. బయలుదేరుతాం, పెద్ద స్పీడ్గా బయలుదేరుతాం, కాస్త ముందు బయలుదేరం. ఇంతకుముందు ఏంటంటే ఎవరికన్నా ఎవడు ఎదురొస్తే రోడ్డు మీద ఆగి తిట్టుకునేవాళ్ళు. ఇప్పుడు ఆ టైం కూడా ఎంటర్లా, ఇటు పోతా ఒకడు అటు పోతా ఒకడు బూతులు తిట్టుకుంటూ ఉంటారు. ఇమోషనల్ బ్యాలెన్స్ ఉంటుందా? స్ట్రెస్కి కారణాలు ఏంటి? లైఫ్ చేంజెస్, చాలా మార్పులు వచ్చేసినాయి. రిలేషన్షిప్ డిఫికల్టీస్, ఏ ఇంట్లోనూ ముందు ఎట్లా ఉంటుందండి, ఇక్కడ పిల్లలు కొంతమంది కనపడుతున్నారు. ముందేంటంటే ఆడపిల్లలు మగపిల్ల ఇద్దరు మాట్లాడేది ఇద్దరికి నచ్చుద్ది. కొద్దిగా పెళ్లి చేసుకుందాం అనుకున్నప్పుడు 6 నెలల ముందు వరకు అమ్మాయి చెప్పింది అబ్బాయి వింటాడు. పెళ్ళైన సంవత్సరం వరకు అబ్బాయి చెప్పింది అమ్మాయి వింటుంది. ఒక 2 సంవత్సరాల తర్వాత వీళ్ళిద్దరు మాట్లాడుకునేది ఊరంతా వింటారు. రిలేషన్షిప్ డిఫికల్టీస్, చాలా బిజీ, పిల్లలు ఇందాకే చెప్పాను కదా, పేరెంట్స్కి పిల్లలంటే భయం. భయం లేని ఇక్కడ పిల్లలు ఉన్న పేరెంట్స్ చాలామంది ఉండుంటారు. క్రానిక్ వరీస్, తర్వాత పెసిమిజం. ఒక్కోడికి మీరు ఏదైనా చెప్పండి, అబ్బాయి అవదండి అంటారు. నీ దగ్గర మంచి నాలెడ్జ్ ఉంది, నువ్వు లాయర్గా సక్సెస్ అవుతావా, భలే వాళ్ళు సార్, అసలు అయ్యే పనేనా ఇప్పుడు అంటాడు. పలానా గైడ్ చేస్తాడు, బాగా మంచి ప్రొఫెషన్లోకి వెళ్ళొచ్చు. అబ్బాయి అవదండి. నెగటివ్ సెల్ఫ్ టాక్. నువ్వు బాగానే మాట్లాడుతున్నావు కదా, కొద్దిగా లాజిక్ కూడా యాడ్ చేస్తే మంచి అడ్వకేట్ అవుతావు. నా బొంద, అసలు నేను పుట్టినప్పుడే పిల్లి వెనక్కి తిరిగిందంట అని వాడికి ఆ రోజు నుంచి ఈ రోజు వరకు ఏమేమి బ్యాడ్ జరిగినాయో అది మొత్తం రీల్ వేస్తాడు అన్నమాట. నెగటివ్ సెల్ఫ్ టాక్. అన్రియలిస్టిక్ ఎక్స్పెక్టేషన్స్ ఇస్ అనదర్ రీజన్. ఇప్పుడు సినిమాల్లో చూస్తారు, వాళ్ళు లాయర్ అవ్వగానే కోట్ వేసుకొని వస్తే ఇట్లాంటి ఆడిటోరియంలో జనం అంతా కూర్చొని ఉంటారు, క్లయింట్స్ వెయిట్ చేస్తా, ఈడో రూమ్లో ఉంటాడు, అయ్యేనా సచ్చేనా ఇది. దెర్ ఆర్ నో షార్ట్ కట్స్, బట్ people have unrealistic expectations. Rigid thinking. మనం చాలా స్నేహపూర్వకంగా నేను ఒక లాయర్ మిత్రుడికి చెప్పా, ఎందుకు మోకం అట్టు పెట్టుకుంటా ప్రశాంతంగా ఉండొచ్చు కాన్న, నేను ఇంతే అన్నాడు. ఇంతే అంటే రిజిడిటీ అంటే వాడికి నువ్వు బండకి ఇంక తేడా ఏముంది? మనిషి మారాలి. అంటే వాడి నేను బండ, ఇంకేం చేస్తా, ఎవడేం చేయగలడు? ఆల్ ఆర్ నథింగ్ యాటిట్యూడ్. యాటిట్యూడ్ అనేది ఇట్స్ వెరీ క్రిటికల్. యంగ్ పీపుల్లో కనపడుతున్న యాటిట్యూడ్ ఏంటి అంటే దే ఆర్ మోర్ సెల్ఫ్ సెంటర్డ్ అండ్ మోర్ సెల్ఫ్ ఓరియంటెడ్గా ఉంటున్నారు. మీరు ఏ ప్రొఫెషన్లోనైనా చూడండి, వెదర్ డాక్టర్స్ ఆర్ లాయర్స్ ఆర్ ఎనీ అదర్ ప్రొఫెషనల్, ఎవరైతే సోషల్ లైఫ్లో ఉంటున్నారో, ఎవరైతే కంపాషనేట్గా ఉంటున్నారో, దే ఆర్ సక్సెస్ఫుల్ పీపుల్. ఐ టోల్డ్ యూ అబౌట్ ఫేసెస్. మీరు ఒక్కొక్క ఫేస్ గమనిస్తామంటే ఒక్కొక్కటి కనపడతా ఉంటుంది. ఇవన్నీ మనకి మన దగ్గర కనపడతానే ఉంటాయి. ఇప్పుడు వీడి ఇంటి దగ్గర పొద్దున్నే వాళ్ళ అమ్మాయితోటో తిట్టించుకొని బయటకు వచ్చాడు అనుకోండి ఒక లాయరు, ఆఫీసు రాగానే క్లయింట్లతో యుద్ధం, అట్లాగే చిరాగ్గా కోర్టుకు వెళ్తాడు. వాట్ హ్యాపెన్స్? ఏం జరుగుతుంది? I drive the one point, that is our mind, our thinking. దాన్ని బట్టి మోకాళ్ళన్నీ వస్తాయి. కొంతమంది అనుకుంటారు, ఐఎమ్ నాట్ టాకింగ్ అబౌట్ ఫిజికల్ ఫీచర్స్, ఐఎమ్ టాకింగ్ అబౌట్ మెంటల్ ట్రైట్స్. Feeling happiness is the only way we can beat the stress. And why should we be happy? A profession, mostly in case of lawyers who mostly interact with people, they should be happy. Why? A happy person is a healthy one. A healthy person is physically, mentally, and is socially strong. A happy person is a creative person. A creative person is a resourceful one. A resourceful person is a productive and successful one. Creativity, ఇందాక the judge in the earlier presentation also made it clear how important it is to be creative in our profession. We can be creative in our profession when we are happy, when we are healthy, when client కనపడంగానే what's the first phase? That phase will connect you. రెండోది, మనం ఏడుపు గొట్టు మొక్కం తొడిగుంటే వాడు వీడి దగ్గర అనవసరం అనుకుంటాడు. మూడోది భయం. ఒకడు చూపులోనే ఏం చూసినా భయమే, ఎందుకో తెలియదు. తర్వాత సర్ప్రైజ్, అరే మోడీ మూడోసారి ప్రధానమంత్రి అయ్యాడు, న్యూస్ వచ్చింది, అవునా? వాట్ ఈస్ దేర్ టు బి సో మచ్ సర్ప్రైజ్డ్ ఇన్ ఇట్? సమ్ ఆర్ యాంగ్రీ ఫేసెస్. ముఖం చూడంగానే 500 వాట్ల మెగావాట్ పవర్ పాస్ అవుతూ ఉంటుంది. ఎవడు మాట్లాడినా మాడి మసి అయిపోవటమే. A professional has no right to be angry with his client, his customer. కోపాన్ని జరిగిన నష్టం పట్ల, జరిగిన లోపం పట్ల ప్రదర్శించక కానీ మనిషి పట్ల కోపం ఉండకూడదు. ఒక ఎగ్జాంపుల్, మీరు మీ క్లయింట్తో డీల్ చేస్తున్నారు. అతను చెప్పిన టైంకి ప్రతిసారి 10 నిమిషాల్లో పావు గంట లేటుగా వచ్చాడు అనుకోండి. రాగానే ఎప్పుడు చూసినా లేటుగా వస్తావు, అసలు నీ ముఖం చూస్తేనే దరిద్రం అన్నారు అనుకోండి. యు ఆర్ యాంగ్రీ విత్ ద పర్సన్. నువ్వు మంచివాడివే కానీ ఎప్పుడు లేటుగా వస్తున్నావు, అది నాకు నచ్చలా. వెన్ యూ సే, వెన్ యు ఆర్ యాంగ్రీ విత్ ద రాంగ్, యు ఆర్ రైట్. So this is the health scenario in the country. We see most obese people, we see people with hypertension, we see people with diabetes. Most of these have their root in stress. And here is the solution to this. This is neuroscience. Both psychiatry and psychology have researched and found out this scientific result. There are 4 neurochemicals or happy chemicals, we call them, which keep us happy. First one, please. It's dopamine. Second one, serotonin. Third one, oxytocin. Fourth one, endorphins. These are the neurochemicals our brain releases and which keep us happy. And how do they work? First one, it is dopamine that controls many functions including behavior, emotions and cognition. Cognition ante enti? మనం ఒక విషయాన్ని ఎట్లా అర్థం చేసుకుంటున్నాం అనేది కాగ్నిషన్. దీనికి ఒక ఎగ్జాంపుల్ చెప్తాను, దట్ విల్ మేక్ ఇట్ వెరీ క్లియర్ వాట్ ఈస్ కాగ్నిషన్. ఒక డాక్టరు తాగుబోతోళ్ళకి తాగుడు మానిపిద్దామని ఒక ఎక్స్పెరిమెంట్ చేశాడంట. వాళ్ళని పిలిచి 2 గ్లాసులు పెట్టి, ఒక గ్లాసులో మంచినీళ్ళు, ఒక గ్లాసులో ఆల్కహాల్ పోసాడు. ఇది చాలామంది మీకు తెలిసే ఉంటుంది. 2 పురుగులు తీసుకొని ఒకటి మంచినీళ్ళు దాంట్లో వేసాడు, ఆరోగ్యంగా ఉంది. ఇంకో పురుగుని ఆల్కహాల్లో వేసాడు, అది చచ్చూరుకుంది, గెలగెల కొట్టుకొని. తర్వాత డాక్టర్ అడిగాడు, అర్థమైందా మీకు అని. భలే అర్థమైందా అన్నారు వాళ్ళు. వాళ్ళ చేత చెప్పించాలని నేను రంది. సరే ఒకరిని పిలిచి అడిగాడు, ఏం అర్థమైంది చెప్పని. ఈ డాక్టర్ మహానుభావుడు మన కళ్ళు తెరిపించాడు, మన తాగుబోతు వాళ్ళకు ఒక మంచి వార్త చెప్పాడు. బ్రాందీ విస్కీ ఆరోగ్యానికి చాలా మంచిది, పొట్టలో పురుగులన్నీ చచ్చిపోతాయి. దట్స్ వాట్ కాగ్నిషన్ ఇస్. Cognition, how you, we see, we smell, our senses send signals to the mind, and in the mind these signals are processed, and outcome of that process is cognition. అంటే మన ఆలోచన సరిగ్గా లేకపోతే, మనకి మన ఆలోచనలో సెలెక్టివిజం ఉంటే మనం సరిగ్గా అర్థం చేసుకోలేము, మనుషులను అర్థం చేసుకోలేము, కేసు అర్థం చేసుకోలేము, విషయాలను అర్థం చేసుకోలేము. సరిగ్గా అర్థం కావాలి అంటే ఇట్ ఈస్ ఎ న్యూరోకెమికల్ కాల్డ్ డోపమైన్ దట్ ప్లేస్ ఎ వైటల్ రోల్. అండ్ హౌ ఇస్ దిస్ డోపమైన్ రిలీజ్డ్? మన బ్రెయిన్ డోపమైన్ ఎట్లా రిలీజ్ చేస్తుంది అంటే వెన్ వి గెట్ అప్రిషియేటెడ్. ఒకసారి ఆలోచించండి, ఎవరన్నా మిమ్మల్ని కలిసి మిమ్మల్ని చూస్తే నాకు సంతోషంగా ఉంది, మనం పలానప్పుడు కలిసి మాట్లాడుకున్నాం అన్నారు అనుకోండి, మనం సంతోషపడతాం లేదా? సో ఏం పోయింది దాంట్లో? ఒక ఎప్రిసియేషన్. మాకు కాలేజీలో అప్పుడప్పుడు బర్త్డే అని ఒక కొత్త చీర కట్టుకొని ఒక ఆమె వస్తుంది, అటు ఇటు తిరుగుతూ ఉంటుంది చూడమని. ఏం పోయింది? ఒక మాట బాగుందమ్మా అంటే ఐఎమ్ హ్యాపీ, మీరు హ్యాపీ. అబ్బే ఆ పని చెయ్యం, ఎక్కడ కొట్టుకొచ్చి ఉంటుంది అంట. ఏమన్నా అర్థం ఉందా? A word of appreciation, it costs nothing. It creates dopamine in you and in others. This is why many housewives are not happy, because they are not being appreciated for all the hard work they do at home. నేను ఒక వాట్సాప్లో ఒక వీడియో చూసా. కొత్తగా పెళ్ళైన ఆమె హార్ట్ ఆకారంలో ఆమ్లెట్ వేసి ప్రేమగా భర్తకు తీసుకొని వచ్చి ఇట్లా అందిస్తుంది. వాడు ఏం చేస్తాడంటే ఈ చేతితో ఫోన్ చూస్తా ఈ ఆమ్లెట్ని ఇట్లా మడతపెట్టి నోట్లో దొక్కుతాడు. కమ్మడు ఉంటుంది రాక్షస బల్లి, దానికి కనుక మేకపిల్ల దొరికితే ఆప్ అని ఎట్లా లాగేస్తుందో అట్లా తిన్నాడు వాడు. ఇక ఆమెకి ఏమనిపిస్తుంది? వాళ్ళిద్దరికి మధ్య ఇక మొదలే కదా, చూడొచ్చు కదా, చూసేది భలే ఉందంటే ఆమె ఎంత సంతోషం. సో వీ డూ వెరీ స్మాల్ మిస్టేక్స్, వీ డోంట్ అప్రిషియేట్. అక్కడ అవసరం లేదనుకుంటాం. ప్రతి మనిషికి అవసరమే. ఒక మహారాజు అస్సలు పొగడ్తకి లొంగడంట. ఆయన దగ్గరికి వెళ్ళి ఒకడు, ఓ మైటీ కింగ్, యు ఆర్ అబౌవ్ బీయింగ్ ప్లీజ్డ్ అనగానే డామన్ పడ్డాడు. నోబడీ ఈస్ అబౌవ్ బీయింగ్ ప్లీజ్డ్. ఎవ్రీబడి వాంట్స్ రికగ్నిషన్, ఎవ్రీబడి వాంట్స్ టు బి అప్రిషియేటెడ్. ఇట్స్ బికాస్ ఆఫ్ ద ఫ్యాక్టర్ డోపమైన్. So don't take it for granted that your wife has got to be happy because you are her husband. Don't take it for granted that your husband got to be happy because you are his wife. Even wife and husband need appreciation. Children need appreciation. Colleagues need appreciation. Every human interaction shall end with a note of appreciation. అయితే ఎప్రిసియేషన్ వేరు, పొగడ్తలు వేరు. పొగడ్తలు అంటే ఏంటి? అబద్ధాన్ని చెప్పటం. అదేదో సినిమాల్లో బ్రహ్మానందాన్ని అసలు నీకు మించిన బలమైనోడు లేడు అంటాడు ఒకడు. వాడు ఇట్లా అనగానే అబ్బా అని వాడు బయటికి పోయి తన్నులు తింటాడు. అప్రిసియేషన్ మస్ట్ బి రియల్. ఏమన్నా నువ్వు బాగున్నావు అంటే బాగానే ఉంటుంది, కానీ మహేష్ బాబు కంటే నువ్వే బాగున్నావు అంటే వాడికి అనుమానం వచ్చు. And this one is oxytocin. This is also called a love hormone. You just imagine, ఎవరన్నా పసిపిల్లలు ఏడుస్తున్నారు అనుకోండి, తీసుకొని ఇట్లా హత్తుకుంటే సంతోషం ఉంటుందా ఉండదా? సంతోషం ఉంటుందా ఉండదా? మాకేం పని సంతోషపడటానికంటే చేసేదేం లేదు. It is because of oxytocin, the love hormone. When you hug someone, when you are close physically with someone, your brain releases oxytocin. So hugging your near and dear for 20 seconds a day releases lot of oxytocin. Your brain releases it. It keeps you happy. ఇట్లా చెప్పానని ఎవరిని బట్టి వాళ్ళని వాటేసుకోబాకండి. అదే అంటూ వాడు చెప్పాడు ఆయన. Your near and dear. And this is serotonin. Another neurochemical our brain releases when we do something good for others. Every professional has ample opportunity to help others. A doctor, a lawyer, a teacher. Every professional has lot of opportunity to help others. ఒకసారి ఆలోచించండి, ఎవరన్నా నీడ్లో ఉన్నారు, వాళ్ళకి ఒక హెల్పింగ్ హ్యాండ్ ఇస్తే your brain releases serotonin that keeps you happy. And more important thing, this serotonin is released in the intestine, which helps us in our digestive system. కాబట్టి ఇతరులకి హెల్ప్ చేస్తే మనకేం లాభం అని ఆలోచించకుండా అది మనకు లాభం అని ఆలోచించేస్తే ఉపయోగం ఉంటుంది. దట్స్ వై వివేకానంద సేస్ be thankful to the people who give an opportunity to help them. And this one is endorphin. Endorphins are released when we exercise, when we laugh. సంతోషంగా ఉంటే ఎండార్ఫిన్స్ రిలీజ్ అవుతాయి, ఎక్సర్సైజ్ చేస్తే ఎండార్ఫిన్స్ రిలీజ్ అవుతాయి. ఎండార్ఫిన్స్ మనల్ని హ్యాపీగా ఉంచుతాయి. అందుకని అంటారు నవ్వటం భోగం, నవ్వించటం యోగం, నవ్వకపోతే అది. Endorphins help us when you are happy, and physical exercise of course got to be the one. ఫిజికల్ ఎక్సర్సైజ్ చేయమన్నాం కదా అని ఈ కింద చేయబాకండి, ఇరుగురు కొంటాయి. What your body permits, you do that. There are other ways to be happy. Indian system of yoga and Buddhist system of anapana meditation helps in controlling our emotions and to be happy. ఇదంతా విన్న తర్వాత కొంతమంది అడుగుతారు, మీ అబ్బాయి ఏం చేస్తున్నాడు అంటారు. వాడు ఉద్యోగం చేస్తున్నాడు, అందుకే నువ్వు ఈ కబుర్లు చెప్తున్నావు అంటారు. మాకు ఎన్ని కష్టాలు ఉన్నాయో తెలుసా అంటారు. ఎవడికి వాడు ప్రపంచంలో వాడు మాత్రమే కష్టాలు పడుతుంటాడు, మిగతా ప్రపంచం అంతా భారం అంతా వాడేమో ఇది అంటారు మన మైండ్ సెట్. ద ట్రూత్ ఈస్ problems are real. We have to find solutions to them. We have to work for them. Still we can be happy. Look at this elderly woman, how much trouble she might have faced in life. What amount of physical oppression she might have undergone. What amount of financial troubles she might have undergone. అయినా ఆ మొక్కల్లో ఆ చిరునవ్వు, ఆనందం. సో హ్యాపీనెస్ లైస్ విత్ ఇన్. ఇట్ హ్యాస్ నథింగ్ టు డూ విత్ ఎక్స్టర్నల్ థింగ్స్. And we can be happy by generating the 4 happy hormones, neurochemicals. We can appreciate others and trigger dopamine. We can love, be compassionate, and generate oxytocin. We can benefit others. As lawyers, we can do a lot of service and get serotonin. We can exercise and love and get endorphins. We can be happy. So be happy, be forgiving, greet always others. చాలా మందికి ఉన్న అభిప్రాయం ఏంటంటే మనం అవతల వాళ్ళకి నమస్కారం చెప్తే వాడు పెద్దోడు మనం చిన్నోళ్ళం అని. ఇది దిక్కుమాలిన ఆలోచన. ఎనీబడి కెన్ గ్రీట్ ఎనీబడి, వెదర్ బిగ్ ఆర్ స్మాల్, వెదర్ low or high, whether highly positioned or lowly positioned, whether highly educated or uneducated, irrespective of social position, economic position, anybody can greet anybody. చిరునవ్వుతోటి మనుషుల్ని పలకరించడం నేర్చుకుంటే, గ్రీట్ చేయటం నేర్చుకుంటే, మనస్ఫూర్తిగా గ్రీట్ చేస్తే అది మనకు మంచిది, ఒక ప్రొఫెషనల్గా మంచిది, లాయర్లకి మరీ మంచిది. లాయర్ ప్రొఫెషన్ ఒక అద్భుతమైంది. ఎందుకని అద్భుతమైంది? యూ కెన్ బి ద వాయిస్ ఫర్ ద వాయిస్లెస్, అండ్ యూ కెన్ అడ్వకేట్ ఫర్ ద అప్రెస్డ్, ఫర్ ద సప్రెస్డ్, ఫర్ ద మీక్, ఫర్ ద వీక్, for the crippled. So it's a wonderful profession that gives you ample opportunity to shape yourself. ఈ దేశంలో చాలా అభివృద్ధి జరుగుతూ ఉంది, అనేక రంగాల్లో అభివృద్ధి జరుగుతూ ఉంది, ఇంకా అనేక అన్యాయాలు జరుగుతూ ఉన్నాయి, దుర్మార్గాలు జరుగుతూ ఉన్నాయి. యూ కెన్ బి వాయిస్ ఆఫ్ దోస్ పీపుల్. వాటి నుంచి మనకేం వస్తుంది? ఒక మనిషిని చూపించినప్పుడల్లా వాడి నుంచి మనకేం వస్తుంది అనుకుంటే మనం ప్రొఫెషన్లో రాణించలేము. న్యూయార్క్లో వెళ్తా అడ్వకేట్ అని బోర్డు చూసి ఒక లోపలికి వెళ్ళాడంట. మీరు మీ ఫీజు ఎంత అని. 3 క్వశ్చన్స్కి $100 అన్నాడంట. అంటే ఐ థింక్ ఇట్ ఈస్ టూ హై అన్నాడంట వచ్చినాడు. ఎస్, వాట్స్ యువర్ 3rd క్వశ్చన్ అన్నాడు. అంటే 2 అయిపోయింది. మనం అట్లా ఉంటే మనం చూసి జనం పారిపోతారు. ఇక్కడ బార్ కౌన్సిల్లో ఉన్నటువంటి అందరూ కూడా వాళ్ళు రియల్ లైఫ్లో చాలా సోషల్ మూమెంట్స్లో, పొలిటికల్ మూమెంట్స్లో వాళ్ళు ఉంటున్నారు. వీ కెన్ గివ్ వాయిస్, వీ కెన్ ఛాంపియన్ ద కాజ్ ఆఫ్ ద డౌన్ ట్రాడన్. ఇవాళ జనాన్ని పట్టించుకునేటటువంటి మనుషులు, సంస్థలు చాలా తక్కువైపోయినాయి. ఏ గుడ్ హార్టెడ్ లాయర్, ఏ కంపాషనేట్ లాయర్, an advocate who rises the issues of the public, common people, has a lot of future. Be happy, be strong in your subject, have wonderful emotional balance, emotional intelligence, and you can be a wonderful advocate, you can be a wonderful lawyer, people's lawyer. Thank you very much.
Thank you, Arvind garu. Thanks for your presentation in such a way that every one of us understands and equip them with the stress management. I request the Honorable Chairman to present a memento, Sri Dwarkanath Reddy garu to present a memento to Sri Arvind garu.
Now I request the guest of honor, Honorable Sri Justice V. Srinivas Garu, Judge of High Court of Andhra Pradesh, to come to the dais and adore the chair. Now I request Sri V. Chandrasekhar Garu, Member of Bar Council, to present a bouquet to His Lordship.
I request Narsingh Rao Garu, the member of the Bar Council, to come over to the dais, and also Chandrasekhar Reddy to stay here itself. And I request the former Bar Council Chairman, Mr. Ramrao, to come over to the dais, and also the Vice Chairman, the Bar Council, and the former Public Prosecutor, Mr. Nagiredi Garu. Now we are going to hear the presentation on the wills and declaration and injunction suits by the Honorable Justice Srinivas Garu, who is present here, a young and dynamic man, and make a note of all the things which will be useful, particularly this particular thing as far as the wills. Many of the wills are prepared by the family members. Please take it into consideration carefully. Thank you, sir. Please.
Friends, first of all, I should thank all of you for patient hearing at this moment of time, 5:40. I hope you all just busted, and it has been relieved by previous speaker. By that, you are all now with open hearing. Of course, it's not for me take much of your time, because I know about 30 years back when I joined in the service, I went to an academy. I used to sit in the classrooms. I know what my mindset at that 5:40 p.m. So I don't want to bore more you.
Firstly, I accept two reasons for this moment is one is Dwarakanath Reddy, another is Ganta Ramarao. Why I am reminding is my first place of birth of judiciary is at Chittoor. He welcomed me into this profession. So I should accept his request. Number two, Mr. Gandaramaro. When my second posting at Parchur, by then I think in 98 or so, he started to come as member of association, Bar Council, I think 98. So these two people made me, no, I should attend it. Otherwise, I may not be ventured, rather I do not play time to you or I do not want to participate. Before to that, I should greet everybody in a good evening. My subject is asked to about wills, declarations and injunctions. First of all, first subject is will. I don't think that will is the first one. Will is the last one because unless we have a property, we may not, it is nothing but waste of declaration and injunctions. Unless we have a property, then we have to go for a will. So I first deal with the declaration. Thereafter, I go about the injunctions. Thereafter, wills. We all know Section 34 of Special Fact is contemplated as for a declaration with a consequential relief. That is the reason where under Section 34 there is a notwithstanding a relief is not sought for, you cannot be granted any declaratory relief. So, who are eligible for a declaratory or injunctive reliefs? Declaratory is concerned any legal character related to any property is denied or right is denied, can he seek for a declaration? Then who is competent, rather who is having right, a legal character, any person entitled to any legal character or right related to any property may institute a suit for declaration. Well, any person who had a legal character or right, yes, he has a legal right and his right was denied, he sought for. Then what is to be seen for a declaration? Then declarations of various kinds like property suits are concerned, we must go for known source of acquisition of title unless and until that is not seen, rather verified. Filing a declaratory suit becomes a futile exercise. So, before going for filing of a suit for declaration, you are expected to see source of acquisition of title such as succession, purchase, assignment, or by perfecting by title by adverse possession. So, these are necessary for declaration. Then what we have to think of further is one more interesting aspect is equity, because equity means justice and egalitarianism. Today, equity remains an integral part of our legal system, and it should be equitable principle to ensure justice and fairness, especially in cases involving property disputes, contracts, family matters, trusts. So far our origin is concerned, even in Smriti's oldest attempt for compilation of law, equity has its own origin. Smritis also have actually considered the principle of law. Now under Indian legal system, a branch of a legal system, equity refers to the essence of rules arising from administration process of justice, specifically in those cases where areas are not adequately covered by statute. So far as these declarations are concerned, comes in Special Relief Act, Trust Act, Succession Act, Transfer of Property Act. I think most of you have been received the subject regarding this declaration at the end of the day. However, to satisfy myself, rather to some of the people who are interested, I should take a very limited time. I do not want to take much time. Equity is considered a separate system from common law, its own rules and remedies. It was developed to address rigidity of common law and to provide fair and just remedies where common law could not. The methods relating to unbiased jurisdiction are basically derived from crucial truth of righteousness. The importance of maxims not to be exaggerated, it is really a far more from immutable principles. So, what are the equities? Those are the general principles which is broadened as: 1. He who seeks equity must do equity. I think everybody must have come across this maxim. What this maxim speaks, a directive on the applicant of equity. The maxim mainly put its main source on the rectitude of the court. The principle that the person who seeks equity must do equity is a fundamental concept. This implies to seek a fair treatment in a court of law, one must have acted fairly themselves. In Indian cases are concerned, there are so many judgments regarding this point of he who seeks equity must do equity, has lengthily discussed in a judgment reported in AR 2003 SCW 1561 in Canara Bank and others versus Debasis Das and others, in which the Honorable Supreme Court said, a person who seeks equity must come with a clean hands. He who comes to the court with false claims cannot plead equity, nor the court would be not justified to exercise equity jurisdiction in his favor. Thus, a person who seeks equity must act in a fair and equitable manner. The another maxim, so far as equities are concerned, equity follows the law. I think this is also many of you might have come across this maxim. Equity follows the law. It is a principle that suggests equity will not allow a remedy that is contrary to law. It indicates that equity supplements but does not supplement the law. This maxim means equity does not violate the law. In this regard, the Supreme Court had categorically ruled law should not prevail over equity, emphasizing that judges should not legislate as it would be a violative of democratic principles. Why this equity follows the law means this we should not violate the law. Law means lawmakers are there, lawmakers will make the law under the democratic principles. This is discussed by the Honorable Supreme Court in West Bengal State Electricity Board versus Patel Engineering Company, as well in Land Acquisition Officers versus Harinarayan in 1976 Supreme Court. And the Supreme Court time and again said the equity supplements the law and does not override the statutory provisions. The another maxim in this equity is equity will not be a wrong to be with or without a remedy. What does this maxim is it is developed as a common law which basically does not lay down any new remedies, but it has only nominal damages. This maxim often expressed in Latin as ubi jus ubi remedium, states no wrong should be go unaddressed if it is capable of being remedied by courts. Another principle in this equality is equity. This maxim means when two or more parties have their common interest, but due to some specific reason their interests have not been qualified, then equity is a source may divide their interest equally. There is its judgment of England when Flight versus Boland, whereas in India, recent judgment of 2017 3 SCC in Sandeep Khanuja versus Atul Dande, Another maxim in this regard is equity will not suffer a wrong to be without a remedy. What does it mean? It means equity won't allow a wrong to go unpunished. Equity intervenes to stop injustice in situations where a legal remedy is insufficient or non-existent. Now friends, I think so far as doctrine of declarations are over, and in the declarations the only limitation is that nobody can approach the court for a declaration on a chance or a mere hope to entertain. And declaration is required not simply because defendant has denied or was interested in denying the character or the title of the plaintiff. And the courts have to make a distinction between a right of property and right in a property. And it is also held in that in order to claim a declaration, plaintiff need not show a right in property. The declaratory decree binds the parties to the suit, the persons claiming two parties, where any of the parties are trustees, and the persons from whom, if he has been in existence, but the date of declaration such parties. Normally limitation period is 3 years, but in a law of adverse possession, declaration is 12 years. As already stated, in order to obtain a relief under 34, plaintiff must be entitled to a legal character or right to property at the time of this suit, and defendant must have been denied or shown interest in denying the plaintiff's character or title. And one more important aspect while filing a declaration is, court will not grant a declaration if plaintiff could not seek an additional fee which is so required, and beyond a mere declaration is also possible. If he is not sought for, the court will not grant any declaration. This is even settled even in 1960 itself, reported in AR 1960 SC 335 in between Rukma Bai versus Lala Lakshmi Narayan. In that case, plaintiff asked for a bare declaration, though he was in a position to ask for further relief. But since not sought for, the court said, is not entered for the declaration. Though the judgment is under the old act of 1897, but it's an analogous to section 34, which is also speaks that unless a person who is also in a position to ask for further relief, if he is not sought for, he is not entitled to seek a declaratory relief. There are several judgments in this regard, even prior to 1960. One is Surinder Singh Mullah Singh, 1938 PC 73, as well Humayun Begum versus Shah Muhammad Khan, 1943 PC. After amendment to the Special Relief Act in 1963, the scope is so discussed. This is reported in 1975 to SCC page 530. As well, another judgment, if Supreme Court in Vinay Krishna versus Keshav Chandra and another, it is reported in 1993 supplementary Supreme Court cases page 129. What is the application of declaration, the applicability of bar under the said provision? Friends, you all know grant of injunction is a discretionary relief. The exercise thereof is subject to the court satisfying that there is a serious disputed question to be tried in the suit, and that act on the facts before the court, there is a probability of his being entitled to the relief asked for by the plaintiff or defendant. In this regard, I already told you, a mere declaration without a consequential relief does not provide needed relief. This is again decided in Monilal versus Oriental Fire and General Insurance, 1996 SC 642, in which the Honorable Supreme Court also said the omission thereof mandate the court to refuse the grant of declaratory relief. Why I am telling all this is, recently I had a come across course a year back. Initially a suit for injunction is filed, later converted the suit for recovery of possession. I do not know, the defendant denied the possession title as well. Neither plaintiff filed any rejoinder, nor the defendant filed his claim over the suit property. There is a clear dispute between the parties. The role of advocate is very much required. And when a valuable property is before the court, the advocacy, rather advocates should indulge to see the party who approaches them shall not be troubled by their acts, because the foundation is from the trial courts. That foundational mistake cannot be cleared in the appellate courts, because if foundational facts are missing or foundational facts are not pleaded, even if whatever the material placed on record, if foundation is not there, naturally it collapses. That's the reason I am telling all the time, in particular practicing before civil courts, while filing the declaration suits, you should think twice or thrice what are the documents, how the plaintiff is seeking the relief, or when you are appearing for a defendant, to what extent a plaintiff had the right to seek such a declaration. It is on our shoulders to see. If not seen in the trial courts, ultimately the people who comes to us, we laugh at us, because we are not doing any justice to them. Some important judgments we wanted to tell in declarative decrees are 1964 2 SCR page 933, in between Adagada Raghavama and Andar versus Adagada Chanchamma and Andar, as well in 2003 SC, year 2003 SC 4548, in between RVE Venkatachal Goundar versus Armigu Veeraya Swami and VP Temple and another. This is very peculiar judgment where plaintiff cannot prove his title beyond a reasonable doubt, but can only prove his case through preponderance of probabilities. As plaintiff through our evidence, both oral and documentary, as discharge proof, the burden of proof shifts on the other side. This is a very beautiful judgment. It can be relied on by both the parties. The onus, whether shifted or not, can be. One more important judgment in this regard is Union of India versus Vasavi Cooperating Housing Society, 2014 2 SCC page 269, in which, in a suit for declaration of title, burden always lies on the plaintiff to make out and establish a clear case for granting of such a declaration, and the weakness, if any, of the case set up by the defendants would not be a ground to grant a relief to the plaintiff. Union of India versus Vasavi Cooperative Housing Society, 2014 2 SCC page 269. If you read two judgments, this RV Venkatachal Goundar case as well Vasavi Cooperating Housing Society, these two judgments gives a voluminous material for us, both for plaintiff as well defendant, to what is his strength, what is his weakness. In another recent judgment in 2019 3 ALT page 277 is also a Supreme Court judgment between Mallikarjunaya versus Nanzaya, in which mere continuous position, however long it may have been its a true one, is not enough to sustain the plea of adverse position unless it is further proved that such position was open, hostile, exclusive, and with the assertion of ownership right over the property to the knowledge of its true owner. This is a very beautiful judgment. One should keep in your notebook, because long position or claiming true owner, even adverse position claims, he has to prove open, hostile, exclusive, with the assertion of ownership. These are all the material points in this judgment. One more, another judgment of the Supreme Court in Ravinder Kaur Grewal versus Manjit Kaur. This is reported in 2019 5 ALT page 38. Ravinder Kaur Grewal versus Manjit Kaur, 2019 5 ALT page 38, in which the apex court said, a person in possession cannot be ousted by another except by due procedure of law, and once 12 years period of adverse possession is over, even owner's right to eject him is lost, and the possessory owner acquires right, title and interest possessed by outgoing person or owner, as the case may be, against whom he has prescribed. In this, the Supreme Court said, right, title or interest is acquired. It can be used as a sword by the plaintiff as well as a shield by the defendant. I think why this I used it. All times adverse possession is used as a shield, but this judgment of 2019 said it can be used as shield as well sword. One more interesting declaration is 30 years back I had an occasion at Chittoor itself, a negative declaratory relief. Many times you may not come across this type of negative declaratory reliefs are concerned. This negative declaratory relief is a legal term that refers to a situation where defendant seeks a declaration that they are not liable, because where in one village there is some a temple having some rituals has to be performed, and such rituals has to be performed by particular persons alone. But if the other persons who are not intended to seek that they are not to be do that rituals, he can file a declaratory suit. It is called a negative declaratory suit, in which also an injunction can be sought for. I think Mr. Dwarkanath Reddy might have appeared in that suit, it appears, if I remember right. First time I had come across that suit. Now, of course, it is for the court to see, use its discretion to grant a declaration that plaintiff is entitled to such a character or right, but it is you to appreciate the judge. The plaintiff is entitled to such a character or a right, then he is entitled to seek such a declaratory right, declaratory relief, and he is also should be cautioned to that. A further relief also can be asked for, if not asked, as already stated above. If not asked for, your relief, though apprised the judge, the court may reject to grant the declaratory relief. One more interesting judgment of Supreme Court regarding declaration, of course, not touching the declaration, but a part of a declaration is discussed in Antal Sudhakar case. I think it's a well-known judgment. A judgment reported in year 2008 SC 2033 in Antal Sudhakar versus P. Buchireddy and others, in which many times it has discussed about where injunction simpliciter is entitled, who is entitled, what type of injunction simpliciter can be filed. When title of the plaintiff is not disputed, still is necessary to file a suit for declaration or not. As well, where title of the plaintiff is not disputed, the plaintiff need not seek for declaration. And if plaintiff is not in position, his remedy is to file a suit for position but not for injunction. He has, in addition to declaration, he has to seek for position also. As well, a plaintiff is in position but his title the property is in dispute or under cloud, where defendant assesses title and there is also a threat of disposition from the defendant. Plaintiff will have to sue for declaration of title and a consequential relief. Where title of the plaintiff is under cloud or in dispute and he is not in position or not able to establish position, necessarily the plaintiff have to file a suit for declaration, position and injunction. These are regarding the declarations. Now coming to injunctions. A bare suit for injunction in the absence of declaration would be maintainable if there is an interference with the plaintiff's lawful position or threat of disposition. A suit for injunction simpliciter is sufficient. In this regard, a recent judgment of Supreme Court in 2019 17 SEC page 692 in between Jharkhand State Housing Board versus Didar Singh and other. In this, the Supreme Court absurd. Though a bare suit for injunction in the absence of declaration would be maintainable, and in each and every case where defendant disputes the title of the plaintiff, it is not necessary that in all those cases plaintiff has to seek the relief of declaration. It is further observed and held that, however, when the defendant raises a genuine dispute with regard to title, and when he raises a cloud over the title of the plaintiff, then necessarily in those circumstances plaintiff has necessarily to has to file a suit for declaration as well for injunction or position as the case may be, and plaintiff cannot maintain a suit for bare injunction. It's a very important recent judgment with regard to bare injunction suits or a suit where plaintiff is necessarily sought for a declaration or not. Sir, citation 2019-17 SCC, page 692. Another judgment is A. Subramanian versus R. Pannirselvam, 2021, 3 SCC, page 675, in which Honorable Apex Court held that a person in possession of land in the assumed character of owner and exercising peaceably the ordinary rights of ownership has a perfectly good title against all the world, but not against the rightful owner. So, he can file suit for injunction simpliciter. I wanted to go for another old judgment of Supreme Court in Dilbu versus Tanra Z, 2007 SCC, page 702, in which Honorable Apex Court, there is a dispute that a suit is filed beyond the period of limitation. The plaintiff would have to ever and prove that suit is within the period of limitation as prescribed, and in the absence of any averment or proof to show that the suit is within time, it is the plaintiff who filed. It is further observed in the said judgment, whenever a document is registered, the date of registration becomes the date of deemed knowledge. Why I refer this judgment is, many times registered deeds like title deeds are bringing to the notice of the court. In this Supreme Court judgment here, the Supreme Court observed that whenever a document is registered, the date of registration becomes the date of deemed knowledge. So, a document is registered, it becomes a knowledge for one and all. So, simply I do not know a document is registered, so that I am not sought for cancellation of document. And a limitation is also required. And why he has to belatedly file the suit? That is the reason the Supreme Court said, if a suit is filed beyond the period of limitation, he has to ever and prove the suit is within the period of limitation as prescribed, and in the absence of any averment or proof to show that aspect, then the suit is not within the time and the plaintiff loses his suit. The another judgment, another important judgment is, many times the courts used to observe due process of law. What is meant by due process of law? This is discussed by the Supreme Court in Margarida Squaria Fernandez versus Erascomo Jack D. Squaria, 2012, 5 SCC, page 370, in which the Supreme Court discussed what is meant by due process of law. In the judgment, the Honorable Supreme Court, due process of law means that nobody ought to be condemned or unheard. The due process of law means a person is in settled possession will not be dispossessed except by due process of law. Due process means an opportunity to be the defendant to file pleadings, including the written statement, and documents before the court of law. It does not mean the whole trial. Due process of law is satisfied the moment the rights of the parties are adjudicated upon by a competent court. This is the finding regarding due process of law. Many times we come across transfers of properties not evidenced by any registered document. What will happen? Because Section 54 of TP Act, read with Section 17 of Registration Act, would not confer any right or title or interest on the transferee. This is discussed in 2003 5 ILD 654 in between Konkana Ravindra Gaud versus Bhavana Rashi Cooperative Housing Building Society. Pardon, sir? 2003 5 ILD page 654. I'm forgotten to note the citation. However, in this regard, a judgment of the Supreme Court, Suraj Lamps case. Have you heard of anybody? The general power of attorney. Every advocate who is practicing in particular in civil side, filing suits basing on agreements, GPAs, one should keep in mind about Saurabh Lam's case. Before end of the session, I may try to tell about the citation. Right now, I've forgotten to mention the citation. At the same time, another judgment of Supreme Court, in the High Court, in Edler Ramesh Naidu versus Sub-Registrar, in which our High Court said a mere registration of a document by registering authority under the provisions of Registration Act does not confer any title, and that person cannot pass or transfer a better title in a property than that he possesses. You want a case law, sir? Yes. (2009) 1 ALD 337. Sir, now we'll come to wills. I don't want to take much time because already time is 6:20. A will is a legal document that outlines an individual wishes regarding the distribution of their assets, property, and personal belongings after death. What the components of a will is concerned: testamentary gifts, executor appointment, guardianship provisions, residuary clauses, and lastly and leastly, witnesses as well signatures of a testator. These are components of a will. And updating a will, life circumstances change, so it is essential to review and update your will periodically. But in particular, major life events like marriage, divorce, birth of children often warrant revisions. I am surprised to know there is a Will Act. It is a Will Act of 1837, which a growing need to reform this area of law due to rise in dispute. So, even 1837, the law developed on the wills. Friends, how many of you have come across, heard of holographic will? Can anybody say? Handwriting. So, if it is a handwriting of an executor, it need not be proved like any other will or required to be proved. Why? It is in the handwriting of the testator. It is not in mere signatures. The entire judgment, the entire writings are in his hand. It is his wish. Why should be proved? Entire handwriting can be fabricated. Entire mind can be fabricated, frustrated. Might be true. That's the reason I am asking. Holographic will. Normally, holographic wills are very limited. Yes, presence of the witness is right. Why presence of witnesses is a mandatory provision that the witnesses? By why we have to give weight to it? Yes, coercion. Can he write 5 pages? 500 pages also, or 5,000 pages also. Those are all exceptions, right? Normally, more weight to be given to allograph wills. Normally, when a holograph will is placed on record, a defense comes up with fabricated. What is fabricated? The first line, first third, first word are entered, all sentences, including full stops and commas also. So, no. What I wanted to tell about this holograph wills are concerned. Ideally, it should be given weight and it should contain all details. But it has to be proved like any other will. And recent trend, have you heard about a living will? Recently, a judge has written in Goa, a living will. It is also an advance decision. It is a legally binding document that allows you to express your preferences for medical treatment under certain circumstances. So, friends, if a client comes to you to write a will, you must take instructions from the client, specify the bequeathing property and which form and what form, and specify the bequeathing property both immovable and movables, and ask them with regard to the names and the shares as well. You also ask the client to speak about what is to be given as an income generated from the such property to a particular family member or all family members. Friends, will has a 4 essentials. One is, it must be a legal declaration of testator's intention. 2, the declaration must be with respect to his property. Number 3, the desire of testator that declaration should be effected after death of testator. Number 4, the other essential quality of testamentary disposition is in ambulatories of revocability during the executant's lifetime. Friends, a will need not be in a stamp under the any stamp act, need not necessarily be registered. You should the nomenclature given by the parties to the transaction in question is not a decisive, but the contents and intention of the execution is an essential, and intention of the testator must be ascertained not only from the words used but also from surrounding circumstances. Will is a compulsory attestable document, so that will must be signed by at least 2 witnesses, and if registered, sometimes the party may try to ask the court, rather the advocate, describe or identifying witnesses be examined to prove the will, but the law is very much straight on the subject that scribe or identifying witnesses of an attestable document including will cannot be recorded as attesting witness, because there is no animo attestandi. Friends, if you come across a will, you must read judgment of the Supreme Court in H. Venkatachala Iyengar versus B.N. Timmajamma, reported in AR 1959 SC 443. This is a judgment which gives any amount of requirements to qualify a will. This judgment gives what is required, what is not required, and what is to be proved and what is not be proved. This judgment followed by several judgments of the Supreme Court. In almost all judgments, when a will is discussed, the basis is from this Venkatachala Iyengar's case. So, you come across a will is concerned, you read the judgment, thereafter scrutiny to what extent it qualified to suit the case of the parties. It is a very big judgment. I don't want to disturb both of all of you. Besides it, I intended to tell one important judgment of the Supreme Court. Harpur Singh versus Shamsher Singh, it is an important judgment. One should read this judgment because there are 8 clauses in this judgment. If any one of the clauses is not fulfilled, the will automatically will be disbelieved. This judgment is reported in 2009 3 SEC page 687. In between Bharapur Singh versus Shamsher Singh. In any case, a will is presented before you, presented by you, or the other side. You should see these 8 clauses are completely overcome or not. Any of the clauses are not overcome, automatically the court disbelieves the will. 2009 3 SEC page 687. Bharapur Singh versus Shamsher Singh. So many judgments regarding shrouded in suspicion. Proofs is to be simple list between the plaintiff and defendant. And as well, onus probandi lies in every case upon the party who is propounding a will. These are all you day to day you will come across. In particular, another important judgment is Benichand versus Kamla Kunwar, 1977 SC, page 63 is also another important judgment. One more important judgment which I wanted to tell you is Bharatan versus K. Sudhakaran, AIR 1996 SC 1140. In this case, what happened? This judgment followed by a judgment of one Paliram's case. I will tell about judgment of Paliram also. That is the basic. State versus Paliram, AIR 1979 SC 14. What is the importance of this judgment is the court has taken a hazardous task of adjudicating regarding genuineness, authenticity of signatures, etc. In which the Supreme Court said, no, there are specialized persons to adjudicate the genuineness or authenticity of signatures with the assistance of a skilled and trained person whose services could be easily available. So these two judgments we repeatedly come across because many times the advocates used to, sir, section 45 is there or 73 is of Evidence Act is there. The court can compare the signatures, court can do anything, but these two judgments which I refer to definitely say court is not expected to. One more important judgment is Pinnaka Hanumantarao versus Garlapati Dhanalakshmi. See, Justice G. Bhavani Prasad Garu, while referring all the laws, called out various principles. There are about 9 or 10 principles laid down in this judgment, referring all the earlier judgments of Supreme Court. This is reported in 2007 to ALD 435 in between Pinaka Hanumantarao versus Garlapati Dhanalakshmi. Friends, one more important aspect with regard to the wills are concerned. When there are certain suspicious circumstances, but all or every allegation cannot be treated as a suspicion, and if allegations are well founded, the court has to subject the will to closer scrutiny. In another judgment of the Supreme Court in Seshikumar Banerjee versus Subodh Kumar Banerjee, AIR 1964 SC 529, in which the onus of proving a will is on the propender, and in the absence of suspicious circumstances surrounding the execution of the will, proof of testamentary capacity and signature of the testator as required by law is sufficient to discharge the onus. Where, however, there are suspicious circumstances, the onus is on the propender to explain them to the satisfaction of the court before the court accepts the will as genuine. Where the caveator alleges undue influence, fraud, and coercion, the onus is on him to prove the same. Friends, hologram will. You said undue influence, fraud, coercion. So, I think I myself answered the point. So not easy to say it is fraud or undue influence, etc. Before leaving the podium, I want to thank all of you for hearing me, the nonsense which I spoke all the time. Not for claps, only to speak that I am not satisfied because I prepared around 80 pages notes. Okay, thank you one and all for giving me this opportunity. Thanks once again, thanking you.
Just now, Justice Srinivas Garu referred my name. My snapshot goes to 25 years back when I appeared before him when he was a municipal magistrate. This advice is only for the young advocates My dear young advocates, evaluate Mr. Srinivas Garu. He started his life by hard work, night and day. At young age, he was selected as a municipal magistrate, promoted as a senior civil judge, now senior civil judge, then subordinate judge, then additional district judge, then district judge. Now he is in this position of the Honorable High Court judge. Do you think the young advocates, his success is a road to success is a one-day affair? No, not at all. Think over it, strive for it. There is much abundance of wealth. Thank you. Now I request all the Bar Council members who are on the dais to felicitate the Honorable Chief Justice.
With the permission, before this program, there are a couple of announcements. One is immediately after this program, already cultural program team arrived. We will have the benefit of the cultural program. Second, who are willing to use the bus services to reach Guntur and Vijayawada, whoever is there, buses are ready to depart, and they can use those services, one to Vijayawada, one to Guntur immediately. Then next announcement is tomorrow morning, whoever want to avail the benefit of yoga, you can reach the indoor stadium from 6:30 to 7:30 a.m. The yoga will be there, and immediately there itself you can also use the facility of badminton and table tennis there itself, and each one of will have an access to those facilities apart from other facilities. Thank you.
So, Guntur buses are immediately at the back of this theatre. They are ready to start, and the Vijayawada bus is nearby SDC complex where we had lunch. Just before that only you will see the buses. So within 5 minutes, if you are able to catch up those buses, they'll pick you up. Otherwise they'll go. I'm sending them a message to them. Wait for 5 minutes because you need to go from here. Thank you.
And another is tomorrow's program. I think all of you are having this card or program sheet indicating the program. Some of them may not have. And tomorrow, first session is C.V. Nagarjuna Reddy Garu on the topic, the art of advocacy. Next is Sri L. Nageswara Garu, the retired Supreme Court judge, next session on the role of the bench and bar in the administration of justice. Next, Satyanarayana Murthy Garu on the Transfer of Property Act. Ramakrishna Prasad Garu on the constitutional aspects of property rights. And Subbareddy Garu on the Registration Act and the Specific Relief Act and interrelationship, and Venkata Jyotirmaya Prasad Garu on the intellectual property rights. And there will be very interesting sessions tomorrow. You can come. Apart from that, before commencement of the regular session, you may have number of doubts, number of aspects about the profession. After completion of have breakfast, complete the breakfast, come to the dais. Before commencement of the regular session, we have the benefit of the presence of the elders, and all of us can participate in a participatory session where each one of you can have an opportunity to participate in that. Thank you.
After felicitation of the Honorable Justice, there will be cultural programs. Please be here and enjoy the same. Thank you.
మిత్రులారా, ఇప్పుడు మన ముందు రమణ అండ్ టీమ్ పాటలు, మనకి దేశభక్తి గీతాలు, అదేవిధంగా సినిమా పాటల్ని ప్రదర్శిస్తారు. వీటితో పాటుగా కిషోర్ అండ్ టీం, మన న్యాయవాది కిషోర్ గారు వాళ్ళ టీం తోటి కొన్ని డ్యాన్స్ పర్ఫార్మెన్సెస్, అదేవిధంగా మ్యూజికల్ ఇన్స్ట్రుమెంట్స్ పర్ఫార్మెన్సెస్ ఉంటాయి. చక్కగా ఈ ప్రోగ్రామ్స్ జరుగుతాయి. ఒక 1 hour 115 minutes జరుగుతుంది. అందరూ జయప్రదం చేయవలసిందిగా కోరుతున్నాం. రమణాన్ టీం ప్లీజ్ కమ్. మిత్రులారా, అందరూ బ్యాడ్జెస్ ధరించి మీ డిన్నర్కి వెళ్ళవలసిందిగా కోరుతున్నాం. డిన్నర్కి వెళ్ళేటప్పుడు ఆయనక కాబట్టి అందరూ ఎవరైనా ఐడి కార్డ్స్ ఒకవేళ తీసుకోకపోతే ఐడి కార్డ్స్ తీసుకోవాలి. తీసుకొని లేదా ఎన్రోల్మెంట్ నెంబర్ అయినా అక్కడ కన్వే చేయండి.
హలో
రమణ ప్లీజ్.
ఈరోజు కార్యక్రమానికి విచ్చేసినటువంటి న్యాయవాదులందరికీ స్వాగతం. మాకు ఈ అవకాశం కల్పించినటువంటి పెద్దలు గౌరవనీయులు శ్రీ ద్వారకానాథ్ రెడ్డి గారు, చైర్మన్ బార్ కౌన్సిల్ ఆఫ్ ఏపీ, అదేవిధంగా గంటా రామారావు గారు, పూర్వ చైర్మన్ బార్ కౌన్సిల్ ఆఫ్ ఏపీ, ఎస్ కృష్ణమోహన్ గారు, నరసింగరావు గారు, వేనాటి చంద్రశేఖర్ రెడ్డి గారు, బార్ కౌన్సిల్ మెంబర్లందరికీ స్వాగతం తెలియజేసుకుంటూ, ఈరోజు ముఖ్యంగా ఇక్కడికి నర్రా శ్రీనివాసరావు గారు, స్టాండింగ్ కమిషన్ మెంబర్, కౌన్సిల్ మెంబర్, కేఎల్ యూనివర్సిటీలో మనందరికీ అత్యద్భుతమైన ఆతిథ్యం ఇస్తూ మన కోసం మనలో ఉన్నటువంటి న్యాయవాద నైపుణ్యాన్ని పెంచుకునే కార్యక్రమాలకి అవకాశం కల్పించి మనలందరినీ ఇక్కడికి ఒక చోటుకు చేర్చి ఇంత జయప్రదంగా ఈ కార్యక్రమం సాగుతున్నటువంటి కారకులు, కళా పోషకులు, కళా బంధువు అన్న శ్రీనివాస్ అన్నకు ధన్యవాదాలు తెలియజేస్తూ, ముందుగా ఏం పాటలు పాడతారు, ఏం పాడాలి, ఇక్కడ ఏం పాడాలి అన్నప్పుడు మనం రకరకాల పాటల్ని, రకరకాల విన్యాసాలని, రకరకాల అన్నిటినీ మనం వింటున్నాం, చూస్తున్నాం టీవీలలో. వాటికి భిన్నంగా వాసన్న నిర్దేశించినటువంటి కొన్ని పాటల్ని, ఆయన ఎంపిక చేసిన కొన్ని పాటలు, ఎందుకంటే సమాజానికి ఏం అవసరమో అవి పాడడమే మా కర్తవ్యం. సమాజానికి ఏం పాడితే సమాజం చైతన్యవంతంగా ఉంటుందో అటువంటి పాటలు పాడడానికే మేము ప్రయత్నం చేస్తాం. ఈ అవకాశం ఇచ్చినటువంటి అందరికీ ధన్యవాదాలు తెలియజేస్తూ, ముందుగా దేశమును ప్రేమించమన్నా, మంచి అన్నది పెంచమన్నా అన్న గురజాడ గీతాన్ని ఒకసారి ప్యాడ్ అండి, అది రెడీ అయ్యే లోపల కీబోర్డ్ కూడా పెట్టుకుంటారా?